Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Ricada of Ricada Law, the small law firm in central Minnesota. Oh, my goodness. It's so early. Every day is so early, except for yesterday, which was supposed to be so early. Oh, my God. Whew. Whew. How are you guys doing? Tell you how I'm doing. I want to go right back to bed. I want to go to bed. But we have the trial of Curtis Reeves to watch. And I'm never watching an East Coast trial ever again. I hope the East Coast, anything in Eastern time, I hope it burns to the ground, all of it, and is forever removed. Okay. Let's get the live stream going here. It's only 8:30. It's 7:30. And I'm usually going to bed at 5 in the morning to 6 in the morning. All right. They should be rather, hopefully, should open up interesting. We have the cross-examination of the detective this morning who was conducting various interviews. I do need to let you guys know. Where the hell is it? Tell me that, like, it's late today. That'd be good. Hold on. Oh, here we go. Oh, excuse me. The detective who was conducting interviews immediately following the incident will be cross-examined. He also, it was revealed yesterday, mislabeled some pieces of evidence, kept a piece of evidence in his desk drawer for 11 days following the incident. Stuff that just shouldn't happen, frankly. And so now he will be subject to cross-examination. And I think the defense has really been waiting for this to happen. Let's see. I don't know where Mr. Branca is or if he'll be joining us. I mean, he has the link. But okay, I need to clarify something. Yesterday there was some confusion about whether or not I would have to leave right in the middle of the morning. I do not have to leave in the middle of the morning. We have my teaching obligation has been given a oh, there he's coming, although I only see lights on his camera. My teaching obligations have been have gotten a monkey wrench put in them. We have, because of LeCouf, everybody implemented very strict policies, and one of my children has had a fever yesterday. Nothing serious or anything, but hello, good sir.
Good morning, folks. Whoops. Let's try that again. A little discombobulated this morning.
Welcome to my life, especially during this trial. I am so tired.
Oh man, I'm up at 4:30. I still have to write up an analysis of each day, so
That's just made me feel worse. Yeah, that's horrible. But my so anyway, my kid had a fever, which means we don't get to go. The whole family has to stay home from our homeschool co-op. Um, that's the way of the world now. If anybody has a fever or a sniffle or a cough or someone throws up, doesn't matter. You don't get to go in to anything.
It looks like
So
the live feed just went up.
yeah, I've got it.
Okay. Right.
I've got it here. Nothing's happening other than Curtis Reeves' jacket is giving me cancer. Look at this thing. Whoa. He's been saving that from when he started on the police department back in 1941 or whatever. That's how long he's been wearing this suit. Goodness gracious. Like, look at that thing. It's amazing. I feel like he's about to open a broadcasting network in 1973.
It's right. It's right from a 1970s sitcom for sure.
Goodness. But yes, there will not be any we don't need to switch streams or anything today. There doesn't need to be any like cutouts and comebacks or anything like that. It made things really easy. That was the good news. Is it made things really easy, but it's really lame when I don't get to go in and teach. But I did record a video for the kids to teach, sort of, that not to teach, a video for them to watch today. That's what I meant while I'm gone. But anyway, so how are you? How are you this morning?
Awesome.
Yeah. Excited for the big cross exam?
I am. It should be fiery.
Yeah, me too. I think it'll be good. Good stuff. Hoping the defense does that. It'll get us through the morning anyway.
Attorney Escobar should be off the leash.
You think he's going to be the one to do it, or is it going to be the other bald guy?
No, I think it'll be Mr. No Bow Tie.
Oh, goodness gracious.
He's been more aggressive on cross.
Ray Donovan. Yeah, I kind of wonder if like Curtis Reeves gets a not guilty verdict, if Ray Donovan will stand up and beat him to death right there in the courtroom. Court got it wrong.
Street justice. I could have gone to law school, but I just use a bat.
Too many damn rules. Okay, let's see. We've got some chats. Oh, jeez. Oh, my neck is just a wreck this morning. We've got some chats here in the morning. Yellow Flash 2 says a shot of whiskey will cure you right up. Man, at this time of morning, I cannot. I do not like drinking in the morning. I do not. So gross. Shown photo says, I just watched your stream about the meme judge. Look into Judge Brennan in Michigan if you want a real scandal. She was banging the lead detective of a murder trial during the trial. Accused was granted a new
right
trial.
There in the courtroom.
Can't wait. Your Honor, this is awkward. I object. Stephen Oglesby says, hey, I used to have a jacket like that. Then I found a job. Tyler Mueller says, I've been listening for a while and finally saw the bow tie. I don't trust it. Would you ever wear a bow tie to court?
I don't think so. It's not my style.
I don't think it's anyone's style, personally. I mean, this guy, he doesn't like look bad wearing the bow tie. It's just weird. It's like, I feel like he's going to sell me a balloon animal.
Or something.
It just doesn't seem lawyerly to me. I don't know what it is. Probably just being picky about it. Oh my goodness. Man, I hope she ends early today. Like 10 a.m.
That would be awesome. These are long days and a lot of them.
Yeah. And I'm just wondering how much longer they're going to go. So if this goes past Friday, you're out, right? Like you're out for
No, probably next Wednesday, next week be my
oh,
last
okay.
day.
Gotcha.
Probably.
Gotcha. So there's a possibility that that this thing will wrap up by then. As far flung as it may be, because if the defense is planning on calling everybody, we'll have to see. I hope not. I hope they realize we don't have to do this. It's just we could just leave that as an idle threat to the jury. We'll call everybody if you bastards don't find us not guilty.
Yeah.
I'm eating a hearty breakfast of boiled eggs. Squizgar says Nick Rekieta, much like Rick James, it's Nick Rekieta, bitch. Very good. The Redneck Ram says, I missed most all of yesterday's stream. Was there anything juicy that happened? It's just been continuing with the same sort of pattern. The state calls some witness and they do fine on the stand until the defense gets up. And then once the defense gets up, they, oh, here we go.
Good morning. We need to address anything before we get started? All right, good. I like to hear that.
Okay, I'm going to crank the volume up a little bit here.
And Mr. Proctor's here? He's outside. Okay. Hey.
And then, they're doing fine. And then there's something called cross-examination. And once that happens, they run into real issues with credibility. They're not giving great answers. And things just look a little off. It's the state's case in chief. So it's not like the defense can do much other than undermine the credibility of the witnesses. And that's what they've been doing consistently.
And we keep hearing evidence consistent with self-defense. Evidence about the EMS flushing out his eye, the photographer, with the crazy eyes, taking pictures of his face, seeing some reddening there.
State?
His own recorded statements were consistent with self-defense.
Yep.
Back?
He could have been ranting about how this guy, got exactly what he deserved for throwing popcorn in my face, and that didn't happen.
Yeah. In fact, his testimony, his immediate statement was very little was about popcorn at all. And what he said about the popcorn was basically, I have no idea. I don't know what happened to the popcorn. I don't know if I dropped it, if he knocked it over.
And
no idea what happened. Just knew it was on the
I'll
floor.
remind him that he's still under oath. Yeah. You go ahead. Mm-hmm.
I'll remind him that he's still under oath. Because he might have forgotten.
He has.
I mean, given all his other, missteps.
Right. Yeah, he's not
I'll
very good
remind
with
you that
procedure.
You're still under oath. Oh, sorry. Thanks, Darren.
Oh, you're right. It's what you Esposito or whatever.
Escobar.
Go
Rick
ahead, Mr.
Nikita says,
Escobar.
Thank you.
please tell
Good
Mr.
morning, Mr. Proctor.
Good morning, sir.
Mr.
Just a
Proctor,
second.
you remember we left off with your last statement where you told this jury that you had probable cause based on a totality of circumstances to arrest Mr. Reeves. Remember that?
Yes, sir. Something to that effect. Yes, sir.
Okay. And so you would agree with me that that process requires the application of facts that you have learned in the investigation.
Yes, sir.
From witnesses and from the evidence,
That's correct.
and applying the law in this case.
Yes, sir.
And so what is the law on justifiable use of deadly force, Mr. Proctor?
Yes.
Yeah, he's not a legal expert, is what they're going to argue. However,
But he made an evaluation, whatever his
Yep.
understanding of the law might be. It could be incorrect. I mean, all this needs is a clarifying instruction to the jury that, hey, I'll instruct you by the judge. I'll instruct you on the law at the end. That's the law you'll apply. This is just the law as he understood it.
he's the more trial volume. What the hell's wrong with you guys? Yeah, so normally, outside of some sort of legal expert, they're not going to be, they're not going to allow someone to testify to what the law is or says. But the prosecution asked a question right at the end, and they wanted this question in very much. In fact, they argued over how this question was going to be worded at a sidebar for about 5 minutes yesterday. And that question was, did you make a probable cause determination that says that you could arrest this guy for second-degree murder? That was what they asked. So this guy may not be a legal expert, but he's made a legal evaluation. They've asked him about his legal evaluation, and now they get to the defense will get to ask him questions about that legal that evaluation. His understanding, of course.
Unless the jury would be misled on what the law is, I don't see any problem here. And that's easy enough to correct, to fix, to prevent.
Yeah, in fact, he'll likely answer incorrect.
Yeah.
and then
I think that's rather the point, right?
Yep. Absolutely. Rick Nikita says, please tell Mr. Andrew Broccoli that any bike short of a Dodge Tomahawk is for children.
I've never even heard of a Dodge Tomahawk. I guess I'll have to Google it. Or should I? It'll be some weird sex thing, probably.
It is
like a Cleveland steamer.
It is a sex thing, but it's a sex motorcycle. It is, if I remember right, yeah. It's the Dodge Viper engine that has wheels attached to it.
Right. A lot of wheels.
Yeah, it's hilarious. They're like a theoretical top speed that was ridiculous. Squizgar 2322 says best peanut butter and jelly. Put peanut butter on one slice, strawberry jelly on the other slice, peanut butter on the top, grape jelly on a third slice. Put it on top, batter and deep fat fry and coat in powdered sugar. I'm
going to refresh my coffee while they're doing this.
This sounds good. That's the only sandwich that might kill you faster than my sandwich. Holy cats. Any hot sauce on the eggs? Not right now, just because it'd be messy. I just have them in a bag. Pre-boil a bunch of eggs at a time. Then you keep them forever. Did you see the hacker who doxed the Canadian truckers? I saw of a hacker who claimed responsibility for hacking the Canadian truckers. But I didn't see the particular hacker. I saw information about them. Alleged information about how they've worked with governments and stuff before, which would not surprise me in the slightest, by the way. I mean, I'm not discounting the that information. I'm just saying I don't know anything about it. No, I don't boil eggs in a bag. I boil a bunch of eggs, right? And then you just put them in a baggie as a container in the fridge. So, boil like a dozen eggs at a time.
I see that I didn't miss anything.
No. I did not see.
First question, Your Honor, can we approach?
Oh, that's how this is going to be, by the way. I have a feeling the state is very, very scared of this cross-examination. And we saw yesterday, it was object approach when things got hairy with them. Connor O'Brien says, had a 400-pound history teacher that walked with a cane, would tell us erotic stories about peanut butter and May Sammys. You can put a half inch of peanut butter and then mayo just makes it slide down your throat. Oh, peanut butter and mayonnaise? That's foul. Ugh. God. What is wrong with people? Anyway. The supposed hacker has a threat on Kiwi Farms. Okay. What do you think the judge's breath smells like? Bud Light.
Nailed it.
Forever. It's just
PBR.
but not hipster enough for a PBR. Judge is a little too old.
Oh, did PBR become hipster?
I think so.
I missed
Well, I
it.
think the hipsters adopted it because they're all poor. She looks better today than she looked yesterday. Sometimes the camera has been unkind to this lady. It's kind of weird because normally you want to feel like, I mean, I guess I kind of feel bad for her, but her life today is so much different than it was at this incident, right? Like she's with this, presumably with this other guy.
A movie star.
Yeah, she's with this other movie star. She's no longer with the dead guy. Obviously, she's not with him.
The motorsports guy who wears shirts that he stole from the store.
She's got this attorney with a very yellow tie as well. She didn't have that 8 years ago. So it's weird because normally these things are a little bit closer in proximity to the event. And so the person's still grieving and mourning, but I mean, she's likely long moved on from this type of stuff. I'm sure it's still sad, but I mean, it's in the past. And if you're with someone else, you can't sit and dwell on your previous relationship all day long, every day. So, and that is the wife of Curtis Reeves right there. That's Vivian Reeves, who looked really, really down yesterday when the detective told her husband that she did not, in fact, see the punch. And that was her statement. Did not, and and that he specifically asked her, did he throw a punch or anything? And she said she didn't see it. Man, she looked sad about saying that.
Hey, as long as we got a pause, I'll grift my book. Hey, folks,
Yeah.
you can get the hardcover of The Law of Self-Defense. You guys were a little light yesterday in the revenue department. I just want to say, I noticed from my numbers review. So don't forget, this is your chance to get hard. With The Law of Self-Defense, best-selling book, you can get this at lawofselfdefense.com/get hard.
Get hard. Curtis Reeves' son did CPR on Chad Olson. Well, it didn't work. It didn't work at all.
Yeah, it couldn't have. Did he get a little like fountain of blood every time he did a chest compression?
Now, Detective, from the very beginning, you weren't supposed to be assigned to this case, correct?
Oh, they won
That's
that
correct.
objection.
In fact, it was Detective Soto that was supposed to initially be assigned to this case,
Yes, sir.
and he was on the other end of the county.
That's correct.
And because of the time that it was going to take in order for Detective Soto to come, you were assigned to this case, correct?
That is correct, sir.
And you would agree, would you not, Detective, that you were only assigned as a homicide detective in one prior case dealing with self-defense
That's correct, sir.
prior to the Mr. Reeves's investigation?
Yes, sir.
Is that correct?
Wow.
Yes, sir.
And you would
Newbie.
agree as well that you had never taken a course dealing with the issue of self-defense and homicide.
Not a formal course, no, sir.
Is
And
there
you
an
were
informal
really
course?
only, somewhat familiar with the law of self-defense.
Hey, that's trademarked.
Yes, sir. That would be correct.
Watch yourself there, Escobar.
Now,
I'll send you a law and crime letter.
Detective Aaron Smith was going to be the crime scene detective. Is that correct?
That's correct, sir.
Okay. And the crime scene detective is in charge of the crime scene.
That's correct.
That's a very important function, is it not?
Yes, sir.
And the reason that it's an important function is because in our system of justice, when you're out there, you're supposed to preserve all of the evidence, correct?
That is correct.
You're
If
supposed
only
to
there were
preserve the
a
evidence
law
for the
self-defense
prosecution,
class he could have taken.
correct?
Yes, sir.
You're supposed to preserve the evidence for the defense,
That is correct.
and you're supposed to preserve the evidence for the community.
Yes, sir.
Because when an incident like this is investigated, you don't call the public defender's office and say, hey, come on over and join us so that we can likewise investigate the case, right?
That's correct, sir.
Okay. And you certainly don't call a private attorney like me, right?
No, sir.
Okay.
I'd never call you, you piece of garbage.
Now, Detective Aaron Smith was quite new in the homicide section of major crimes, correct?
That is correct, sir.
In fact, maybe weeks or days before, he was a detective investigating missing persons.
I believe he had been in that unit a month, 2 months in the unit.
Okay. But before that, he was investigating missing persons.
Yes, sir, which is was under the umbrella of major crime.
Okay. And so when he came into that particular unit, he was going to be shadowing you.
He had shadowed me, yes, sir.
Is that correct?
That's correct.
So if it was a month, he was shadowing you for a month.
Yes, sir.
And you knew, did you not, that Detective Smith had not even been to the homicide investigative course by that time?
I'm not aware if he had been or not, sir.
Man, this guy so much doesn't
Now,
want to be here.
when you first got there, and I'm going to give you a pad. Make it easy. May I approach your honor?
That's fine,
Because
sir. I have my own pen.
You've got your pen, okay.
Could you write down for the court what you know about self-defense law?
Nothing. I thought so.
What time did you get there to the Cobb Theater?
According to my notes, sir, I arrived on scene at 2:15.
At 2:15, and what is that in military time?
14:15.
14:15. Okay, why don't you jot that down if we can?
Yesterday, I wore a lavender shirt and
And
tie,
so
folks. It's
you
not
get there
only blue
to,
shirts.
The Cobb Theater scene.
Although I'll admit
You
it's a
don't
lot
know
of blue
yet whether
shirts.
you're going to be assigned the case or not, correct?
That's correct.
And so you're kind of waiting around.
What?
You
Terrible.
were waiting around.
Waiting around.
Yeah, you got there. You didn't know if you were going to be assigned yet. It took some time for that decision to be made.
Not really, sir. I met Acting Sergeant Harris and Major Corbin. As I was getting out of my vehicle, I saw them standing there. I pulled up next to them. We got out and we were talking.
So he was new.
about
The other homicide detective was
Okay,
new.
and
The sergeant
you're
was an
talking
acting
about the
sergeant.
fact that Soto was on the other end of the county?
That's what I believe Sergeant Harris told me.
Okay. And so at some point in time in that conversation, a decision was made to assign you to this case.
That's correct.
Okay. And so, do you know what time that was?
I do my first interview with Alan Hamilton at 14:27.
Okay, so let's jot that down. 14:27
Let's jot that down.
is your first contact with Alan Hamilton, correct?
That's correct.
Okay, and so you didn't do anything between the time you arrived and your first contact with Alan Hamilton, other than speaking to the sergeant,
I received a briefing from them as to what had occurred,
the sergeant.
and Major Corbin.
Okay, and so by this time you realized it, and where were you when that conversation took place?
With Harris and Corbin
Yes, sir.
in the parking lot.
You were in the parking lot. Is that where a command center had been set up?
Not at that time, sir, no.
Okay, well, did a command center get set up?
I don't recall.
I don't remember, sir, that. I don't remember. I think they might have had a mobile command center there as I was leaving. I'm not for sure.
as you were leaving for the day?
Yes, sir. I was in and out, and that's one of the things I was not paying attention to.
Okay. So.
You didn't pay attention to where the
certainly
mobile command center was?
You knew that there was a large force of
One of the
police
many
officers,
things I
correct?
paid no attention to.
And you knew the minute that you were assigned this case, that it was now your responsibility to make sure that this case was investigated
Yes, sir.
properly.
Yes, sir.
And you had the awesome responsibility of making sure that the evidence was going to be preserved, that witnesses were going to be adequately interviewed, correct?
Yes, sir.
And that those interviews were going to be properly.
You see this
memorialized.
hammer? It's about
Yes,
to get
sir.
rammed
Okay.
into your face.
And so. let
Would
me
you
ask
agree
a
that you're the
question.
worst homicide
Before
detective
my
ever?
First interview, which was a mere, 12 seconds after you arrived? Excuse me, 12 minutes after you arrived?
Would
You
you
arrived at
agree that if you were
14:15,
investigating a pregnancy,
Allen
you would cause a
Hamilton,
miscarriage?
14:27. I'm not great in math, that's why I
That
became a
pregnancy
lawyer.
is called
12
justice.
minutes. Yes, sir.
12 minutes, okay. And so, within 12 minutes from you arriving, you are now going to be interviewing Allen Hamilton, and that took place where?
In the theater, I believe it was in the party room.
Okay, so you had to have some time, since you were talking in the parking lot with the sergeant, there was some walking time to get over to that theater, correct?
Just a couple of minutes. Yes, sir.
And then get in there and sit down.
Yes, sir.
Okay. Now, in order to do that, you had to walk through the lobby.
That's correct.
And you, as you walk through the lobby, you could see a bunch of people, patrons, lay people, congregating, correct?
The lobby was, they had a lot of people in the lobby.
And those people were not police officers, these were lay people, patrons of the theater.
The bottom tie
Some
should be
law
just above the belt buckle,
In
folks.
that group.
The bottom of the
But
tie.
the majority was lay people, right? Witnesses.
There were a lot of people, sir.
These guys
There again,
Wear their ties real low.
I didn't get a count on them or anything, but there were a lot of people in that lobby.
In those 12 minutes, did you go to the officers that were there in the lobby and tell them, hey, officers, this can't be. We got to separate these witnesses? Did you tell them that?
I know, sir.
Did you tell those officers, hey, officers, please, you need to tell these individuals not to talk to each other?
No, sir, I didn't tell them that.
You are quite familiar, are you not, with the issue of contamination, correct? Witness contamination.
Correct.
Yes,
So
ma'am.
Windsor tie,
In fact, that
Windsor
was
knot.
taught to you as early as your time in the academy, when you first became a police officer, right?
Yes, sir.
And what they taught you was clearly that you've got to separate witnesses. Because if you don't, the information that's exchanged
It's not a clip-on tie.
contaminates, right?
Yes, sir.
And not only does it
It's a big boy
contaminate,
tie.
it may be wrong, correct?
Mine too.
That's correct.
And not only can it be wrong, but the person that's hearing it actually believes themselves that they own it now. Correct?
That could be, yes, sir.
They
Contamination.
start believing it and actually think that they're seeing it.
Objection, speculation.
Sustain.
So, in order to get to Theater 11, is that where you were?
No, sir.
What theater did you interview Mr. Hamilton?
The party room.
Party room.
Party room. And where's that at?
It's right inside the entrance.
To the right or left?
This guy looks like he's getting deposed in his own divorce.
Okay, so
Yep.
in order to get into that party room, you can see Theater 10, right? You can see the Theater 10 sign?
Yes, sir.
Okay. And you knew at the time that you were assigned this case that the incident had occurred in Theater 10.
That's correct.
And you passed Theater 10 and you didn't go into Theater 10.
No, sir.
Well, you knew that there were officers in Theater 10, correct?
Yes, sir.
You weren't going to do anything to contaminate the scene if you had gone into Theater 10. Right?
That's correct, sir.
Man, he won't even look at him.
You knew the incident had occurred there, right?
Yes, sir.
You didn't know what evidence existed or didn't exist in Theater 10.
At that particular time, no, sir, I did not. I knew there was a popcorn and a cell phone.
Oh, so before you went into the party room, you're telling me and this jury that you knew that there
Look
was
away.
popcorn and a cell phone where?
On the aisle.
On the aisle. Did you know the measurements of that aisle?
No, sir, I do not.
Did you know the measurements of the seat?
No, sir.
Did you know the measurements from seat 9 to the seat right in front of row 9?
No, sir.
Did you know at that point in time what the lighting conditions were at the time the previews were playing?
Other than it was being dark, no, sir.
Did you know what previews were playing and how
Like a
loud they
kid
were?
getting yelled at. He just won't
No,
look
sir,
at
I
him.
did not.
No, Sergeant. No, Sergeant. No, Sergeant. Sorry, Sergeant.
Now, previous to this particular incident, it had been at least a year before you had been to the theater itself. And I'm talking about the complex, correct?
That's correct, sir.
And in fact, you don't even remember, as you were there, you don't even remember that you had ever been in theater 10.
Sir, I remember going into one of the theaters. I don't remember which theater number it was, but I remember being at that complex, and I thought it to be theater 10 with the bistro.
He's acting like when your dog does something bad and won't look at you because he knows it's wrong.
Right. There's garbage all over the living room.
You
There's a big
remember
turd in the middle of the bed.
52 depot, lines 16 through 18.
Uh-oh.
Do you remember?
May we approach?
My apologies, Judge. I should
Okay.
have said the date. March 27th, 2015. You would agree, you remember the depot that you and I had on that date, correct?
I remember giving you a depo, yes, sir.
Okay, and you remember.
I
being-
love all these depositions.
I do.
Love them.
And you remember
They
me
are
asking you a
expensive.
series of questions
Yes, sir.
about this incident.
Yes, sir.
And you would think certainly that your mind was clear, or certainly you had a better recollection of the events back in 2015 rather than 2022.
Yes, sir.
You remember the following questions. Have you ever been in theater 10? Answer. I've been to the Cobb Theater. I don't remember what theater I've been in. Were you telling the truth back in 2015 when I asked you that question?
Could we? I've never read that depo, even though at the end of the deposition, I asked to read before it was published.
Uh-huh.
And I've never had the opportunity to read that deposition.
Did you call the court reporter as you were supposed to?
Wait
Yes.
a minute. I never had the opportunity. Did you call the court reporter? Did you do the thing that you were supposed to do? By the way, him saying his answers there were improper as well. This is cross-examination. He was not asked about whether he wanted to read the deposition and got the opportunity. That is for redirect. But if he's gonna, again, these prosecutors keep making objections, and I'm annoyed that the judge seems to have sustained the first objection, because they raised the issue of his knowledge of self-defense law, or second-degree murder and probable cause. And here, I mean, this is going back to his deposition. The question is, were you telling me the truth when you answered this way?
Yeah.
And now
they should have been allowed to ask. I mean, because what he's testifying about is his understanding of the law as he applied it on that day to come to a probable cause conclusion, not necessarily what the law actually is. He's not claiming that.
Now,
Right.
so you go into this party room, correct?
Yet another one. That's a
And
bad
Detective,
sustained objection, in my
Smith,
opinion.
Was he there already?
I believe so, yes, sir.
Okay, and so he was going to go into the crime scene.
That's correct.
However, you don't know, at least you didn't know in 2013, whether Detective Smith had ever been assigned as the lead crime scene detective in a homicide.
That's correct, sir.
So I'm sure that that caused you to at least think, I've got to be careful. Because if he's never been assigned as the lead detective to a crime scene, he may need some guidance, right?
Sergeant Harris was there.
Well,
Yeah.
did you tell Sergeant Harris, please make sure that you go and speak to Detective Smith to make sure that he's got a real handle on this?
This crime scene was relatively.
Not answering the questions.
It was
Last two.
an in-depth crime scene, for lack of a better purpose,
How did you know? You weren't in there.
because I had been told that of the evidence inside. There was popcorn on the floor. There was a cell phone, spent casing, those kinds of things. But it was not an in-depth crime scene. I had complete confidence in Detective Smith. I had complete confidence in my team to process the scene correctly. They had been trained in that. They knew their job, and I had complete confidence in them. I did not go into the theater to see those items on the floor before I did my interviews.
Okay. So now, before going in to do this interview with Corporal Hamilton, is that correct?
Yes, sir.
Okay. Corporal at the time.
Yes, sir.
You knew nothing about Curtis Reeves, correct?
I knew that he was an ex-Tampa police officer,
That's it.
that he was an older gentleman, and that he had been detained for
And a
shooting
hell of a shot.
Mr. Olds.
You certainly didn't know about any extensive training that he may have had as an officer with the Tampa Police Department.
No, sir.
And you certainly didn't know that at one point in time, he was the commander. Actually, he started the SWAT team at TPD, right?
No, sir. He told me that, well, he didn't tell me about starting the SWAT team in the, with Tampa, but he told me that during his interview.
Well, no, that's further down. We're talking right now, right before you go into that, that little room to interview Corporal Hamilton. You didn't know anything concerning his extensive training that he had.
There again, sir, he had just shot a man. It didn't matter if he was law enforcement, if it didn't matter who he was. He had just shot somebody. And at that time, that did not weigh on me as far as needing that information. I wanted to gather everything that I could.
So this is
present
actually
to
a
the
good
court. And
point,
at that
because
time, I did not feel
what a defense lawyer would like
I
the
didn't
police
feel
to
the
do
need
is when
to
they
go
evaluate a
into his,
shooting, look at both the possible criminal
We're gonna
aspects
get into
and the
that in
self-defense
just a
aspects.
little
Yes.
That's not what
So
police
now you
actually
go
do.
into this
They do
room.
the criminal stuff, and then they
It's
figure
Corporal
the
Hamilton, is
self-defense
that
stuff will
correct?
be dealt
That's
with later.
Okay, and what you told the jury during
But that
direct
could mean that there's
examination is
evidence
you
of
go into this
self-defense
room.
that's not
Corporal Hamilton was
preserved
supposed to
or
be an
even
eyewitness,
destroyed
right?
That's
by
correct.
the
Okay,
investigation.
you knew
And if they
police
had
officer,
considered
right?
self-defense, they may not get the probable
And
cause.
so you go into this particular room with Corporal Hamilton.
Not everybody who shoots someone is arrested,
decide
much less charged and
Now
prosecuted.
you're going to talk to him about this incident, but you're not going to turn on your tape.
At the start of the interview, that's correct, sir.
Well, it was about, what, you spoke to him about 5 minutes off tape?
Yes, sir.
And so for 5
Did you
minutes,
time
you're
the
talking to him
amount?
about this
Did you
particular
record the
incident,
time
and
down?
You told the ladies and gentlemen of the jury yesterday that you did that because you wanted to know what he was going to say.
I wanted to know if he was going to be able to communicate it to me in such a way that I would be able to understand.
This is such a lame
Well,
excuse.
who cares?
There's no reason you
Turn
don't
the
have
tape
that
on.
conversation on tape.
You let him communicate whatever he wants to communicate. And now we know.
Object being argumentative with the witness.
Are you?
Overruled.
Yeah. Come on now.
Detective,
I'll
you
allow
follow
it.
the tape recorder.
Yes,
You get it from the very beginning. If he's not making sense, then we know that maybe he's excited about what happened or he's concerned about what happened, but we get all of his words, right? There's nothing wrong with that.
Yes, sir.
You would agree with that. You want to get sometimes, many times,
Indeed,
the
Florida
emotions
law
of the individual,
explicitly
correct?
says you can't even arrest someone
At times, yes, sir.
in a self-defense
uncertainties
case
of individuals,
unless there's
correct?
probable cause, which
Yes, sir.
implies you need to
or
evaluate
sometimes the
self-defense to get the
precise
probable
information
cause.
from the individual, correct?
Precise information, yes, sir.
And so that's all captured by a recording.
What
Yes,
is he looking
And
at?
if you
He's
don't
looking at his
record
own
all that-
shame.
It goes out the window. Right?
Yes, sir.
And your responsibility in this case was not only to the prosecution, but your responsibility in this case was to preserve everything for this community and for the defense.
That's correct.
And you
Look
chose
at
not
him.
to do that. Now, what you did was you got some kind of checklist. I believe you told the jury yesterday that you just, jotted down what he said, and then you were just going to go down that list, right? That's what you did.
It's not a checklist. I was taking notes as to what he told me.
And then you, in that interview that's recorded, you just go down and ask those questions that he already answered.
That's correct.
But you don't know how he answered them, what his emotions were, what his recollection really was, nothing.
The tape stands for itself, sir.
Well, that's the tape after the first 5 minutes.
Yes, sir.
Now, let me ask you this
Keep
question.
reminding him about that 5 minutes,
Did you have in front of you,
what he's-
before you started
which is good, by the
that
way,
interview,
for him to do.
did you have a voluntary statement form that he had filled out, signed, and dated? I believe it's on page 2 of your report.
So the
Yes,
answer is
right.
yes, I had it.
And you had it in that room, correct?
Yes, sir. I believe I did.
And so you were aware, you read it, right?
I did.
Okay, and so you were aware that Mr. Hamilton had indicated that Mr. Olson was coming over the back of his seat, yelling at Mr. Reeves.
If I could review the written
Oh,
statement.
absolutely. I'm going to hand you what's been marked as.
Yeah,
defense
I
exhibit
was hoping you'd never ask. Oh my goodness. This guy's had all night to think about how this was going to go today. He knew this was coming. That's the funny part.
So your question, could you reword or do the question for me again, sir?
Absolutely. So you were aware when you read that statement, right? Let me have it back and I want to do it verbatim.
I'll be happy to ask that question again.
Mistakes.
It's basically testifying.
You were aware that I observed a white male stand up to my right, lean over the back of his seat, and begin to yell
Objection.
something to the effect.
Yes.
I'd like to interrupt this line of questioning for a moment, Your Honor.
I gotta commend the prosecution. This whole may we approach strategy is very, very good because he's getting into a flow. He's being theatrical and dramatic. He's hammering home this guy's incompetence. And every time he does, Your Honor, may we approach? And then they get 5 minutes of jabber and cool down. And then, sometimes the judge will sustain the objection, but even if she doesn't, he's broken up the flow and the drama of what's going on. I mean, hey, Dad, what you doing, Dad? Hey, Dad, can you tell me about it, Dad? This
Dad,
whole
can I have
thing-
some money for the snack machine?
this whole thing is he's got a witness. Remember, so what you said earlier is you want the defense to be investigating or the police to be investigating the self-defense claim, because under Florida law, they're not allowed to make an arrest without probable cause. It's the law everywhere. But they have to do a probable cause evaluation that includes the claim of self-defense. That's unique to Florida, or not unique maybe, but limited to some states.
Yeah,
So-
just a few states
So
have that explicit provision. You can't even arrest. You can't. You can't basically do anything except use normal investigative techniques.
right. And so that's the issue here is if they don't do the investigation, the theory behind it is the evidence could be destroyed or omitted, and the defense would have no opportunity to collect it. The defense doesn't have an investigator there at the time that the self-defense shooting occurs or
The
shortly
voluntary
thereafter.
statement that you had,
Yes, sir.
what were you aware of at that point from Mr. Hamilton?
That he had witnessed the shooting.
Well, and what had he witnessed? I'll put that in front of you so you can refresh your recollection if you need to.
We're going to object. This is hearsay. Mr. Hamilton already testified, just going through the previous testimony with the different witnesses involved.
No, because it's about what you knew.
Refresh his memory with it, but
So what, you can look down if you like.
Yes, sir.
Okay. And so what did you know?
Right. If he
That
just
he was
reads
at
it
the
aloud,
concert.
it's hearsay.
That the movie had began. He observed a white male.
Your Honor, I think
yeah.
What did you know about it?
Overall.
Thank you.
Go ahead.
He stood up. The white male stood up, and according to the statement, he leaned over the back of the seat and began to yell something. "I'm trying to text my fucking daughter, if you don't mind."
Okay.
And then he observed him throw
Your Honor, I
a.
think
Okay.
But I can have it read more if you want.
no, that was
Okay.
that was
Okay.
what we talked about.
Okay, so you had that before you even started questioning Corporal Hamilton, correct?
Yes, sir. I believe so.
And you would agree with me, may I approach you?
You may.
You would agree with me that defense exhibit number 21, take a look at it, is written very neatly. Correct?
Yes, sir.
The wife wrote it.
Okay.
That'd be funny.
And so I think that on direct examination yesterday, you acknowledged that, hey, we really should be turning these recorders on from the very beginning, right?
Yes, sir. It did not, however, change his statement.
Now,
How do we know that?
you interviewed Corporal
That's
Hamilton.
you say.
with
You remember
wife
his
present.
exact statement from 8 years ago
No, sir, I
that wasn't
did not.
recorded?
So his wife was not present when you interviewed Corporal Hamilton.
That is correct.
You're telling this jury then that the only time that Corporal Hamilton and his wife were present is when you were interviewing her.
That's correct.
Okay. Now,
I believe that's
Your
contrary to her testimony.
interview of Corporal Hamilton was 5 minutes off tape, correct?
About that, yes, sir.
And
Hey,
6
Stephen
minutes-
Gosney in the chat. Nice to see you, buddy. He's
About-
a lawyer from
Okay, so
Florida,
let's
public
put
defender.
down now, we've got the time that you came in, 14:50, the time that you started
Very, very good lawyer.
Hamilton's interview, 14:27,
Very cool. Nice to see you, Stephen. Welcome
Yes,
to
sir.
the show.
and the time that you ended that interview, which was
238, 1438.
14:38. Okay, 2:38.
Yes, sir.
Now, after that particular interview, you go to interview the wife. Is that correct, Mrs. Hamilton?
Yes, sir.
Stephen, if you ever want to be a
You know
guest,
you were in that
just
same
you,
room.
you have my email address. Just let me
And
know.
you
We'll,
still
we'll
had
set
not
something up.
bothered to go back into the crime scene or not even back, you hadn't gone, period, to the crime scene to go see anything in there.
That's correct.
Okay. And when you interviewed her, you likewise started that interview without turning the tape on.
Yes, sir.
And your reason for doing that was because of what?
I wanted to make sure that she could communicate in such a way that I could understand it.
Well, you would agree again with me that if you had that tape on from the very beginning, we would know possibly her emotional state.
Yes, sir.
We would know whether she was sure or not
Yes,
of
sir.
what she was telling you,
Yes, sir.
whether she was undecided about certain events.
Yes, sir.
And we weren't able to capture that because it wasn't recorded.
That's correct, sir.
Okay, and so after that initial interview,
Ouch.
how long was that initial non-recorded interview?
Uh, 2:43 is when I started.
And you left the other one at 14:38, so at best 5 minutes if my math calculations are correct.
Yes, sir.
Okay. So 5 minutes possibly off tape and on tape.
I've got to hear that it was, the taped interview was from 14:52 to 14:57.
What?
14:52.
Yeah, 2:52 to 2:57.
So there's 2 interviews that were recorded, and one was definitely more than 5 minutes.
Okay. So now, you get her statement in the same manner that you got the recorded statement, in the same manner that you got Mr. Hamilton's. Is that correct?
Yes, sir.
Okay. You had jotted down your notes and then you go through those notes, correct?
That's correct.
Okay. Now, clearly, in this particular interview, you had Corporal Hamilton there listening to what his wife was saying.
Yes, sir.
And you agree with me that violates protocol at the Pasco Sheriff's Office, right?
Yes, sir, possibly.
Well,
Okay.
definitely.
Yes. The answer you're looking for is yes, sir. Wouldn't you agree?
Now, when you went to go get Miss Hamilton in order to do this interview, where was she?
Out in the lobby, I believe.
And was she out in the lobby with a group of patrons that had gone to the theater to view the theater?
I'm sorry, sir?
Yeah, out in the lobby,
Right.
concession area. Was she in that group of individuals that had been in the theater during the time of this incident?
There again, sir, she was out in the lobby. I don't recall where she was at. She was near that party room. I remember there being windows, I believe, around that party room. And I sat looking out the window, and I did my interviews with them facing the wall. Is how I recall it, sir.
But my question is in the lobby area. She was in the lobby area with those people.
Yes, sir.
And that's where you all went to retrieve her.
That's right. That's correct.
And you certainly, when you went to retrieve her, you didn't hear any police officers warning those individuals not to talk to each other.
No, sir.
And you certainly didn't give any instructions to officers to do just that.
That's correct, sir.
Okay.
Okay. I'm so disappointed.
No, so both Corporal Hamilton and Mrs. Hamilton took notes there in that party room, correct?
Yes, sir, I did.
You don't have those notes because you shredded them.
That's correct.
What?
It wouldn't have been difficult for you to just attach them as a piece of evidence, right?
That's not procedure protocol.
I needed it for my hamster's
These are
box.
my notes.
So you want to follow procedure protocol concerning the destruction of the notes, but you don't care about following procedure protocol
Great
when you're
question.
interviewing individuals together.
Sir, it's been a few years since I've read that procedure, but the thing that you do not want to do is interview 2 witnesses together without having at least one of those individuals interviewed. In this particular case, like I explained yesterday to the court, I had interviewed Mr. Hamilton. I had obtained information that I felt I needed at that time. I had saw his wife. She was upset. I wanted to get the very best statement that I
This
could
is
from her.
nonsense because you're interviewing the wife now. She's picking
No.
up nonverbal cues from her
Not
husband,
say anything.
right? He's nodding his head or shaking his head or
During the interview. He simply sat behind her with me facing her and him behind his wife at a different table.
Did you put all that in your notes, Detective, that you shredded?
No, sir.
Okay. So now you're done with both interviews.
Yes, sir.
And the one thing that you knew, that there was yelling and curse words that were being directed from Mr. Olson to Mr. Reeves, correct?
Yes.
Leaning over the back of the chair.
That's correct. Yes, sir.
And so you would agree that that is an indication to you that Mr. Olson was aggressive.
Objection, Judge.
Yes.
he's allowed to have a perception.
Yeah, it's literally a present sense impression. We're looking for what you were what was impressed upon you at the time by the statements that you heard.
What did that mean to you? Your Honor, we'd like this evidence excluded. It's rather damaging to our prosecution. I mean, surely you understand.
what a catastrophe of an investigation. And it's actually, it's not that, I would say this is probably not that abnormal. It's just funny to have it thrown into someone's face at trial.
Sorry, Detective, I know I do it constantly here on my table.
Yes,
I'm like, my funny bone is ready to pop out.
I can understand. Yes, sir.
Okay. So Detective, that's aggressive, right?
I guess it's in the way you would perceive it. We hear cussing and yelling all the time. It's that could be considered, I guess, aggressive if you wanted to term it that way.
And especially when you're leaning over the back of your chair and you're within, what, a foot, 2
In
foot?
what world would that be non-aggressive conduct? They weren't two guys bullshitting over a beer using curse words.
Yeah.
There again, sir, that would be it could be considered to be aggressive.
And you would agree, would you not, that when you're loud towards someone else, it has an impact on that person?
Objection, speculation.
Sustained.
It's 701.
Approach.
The evidence.
Okay, so they've cited a rule of evidence here, 701. Present sense is that present sense impression? Let's see. Florida rules, evidence, 701. Opinion testimony of a lay witness. Yeah. If a witness is not testifying as an expert, the witness's testimony about what he or she perceived may be in the form of inference and opinion when the witness cannot readily and with equal accuracy and adequacy communicate what he or she perceived to the trier of fact without testifying in terms of inferences or opinions, and the witness's use of inference or opinions will not mislead the trier of fact to the prejudice of the objecting party, and the opinions and inferences do not require special knowledge, skill, experience, or training. So yeah, what inference were you drawing from these statements that are being told to you in the course of an investigation, where these statements are supposed to give you some sort of inference? His job is to draw an inference at that time. Wow. Why is it that he won't look at the defense attorney? I don't know. Have you ever thrown like a cat off of you because it's being annoying? Like you throw it away and then it like the next time you see it, it doesn't look at you and it goes and pisses on your sport coat or whatever. That's how this guy feels right now. All cats should be thrown until they pee on your jacket.
Detective, you would agree that at that point in time, you had this information from Corporal Hamilton and Angela Hamilton. At that point in time, you didn't know the distance between Mr. Olson and Mr.
Sustain the objection,
Reeves
apparently.
while he was being aggressive, right? You didn't know what the distance was.
He got the aggression in there, though.
I did not know the measurements.
And you didn't ask Corporal Hamilton, can you tell me, was it a foot? Was it 2 feet that you were seeing? You didn't ask that of Corporal Hamilton.
So all this is driving towards how could he possibly have made a rational evidence-based assessment of probable cause in a self-defense case without knowing any of these fundamental facts?
And that last interview with Angela Hamilton on tape was 5 minutes.
That's correct, sir.
Okay, so let's what time did you end with Angela Hamilton? Let's go there. Started at 14:43, ended at 14:57.
That's correct.
Okay. Correct me if I'm wrong. You arrived at 14:15. You started,
Objection, Judge. Ask and answer.
Oh, come
I
on.
do, get the timeline, Your Honor.
This is insane.
All right, I'm gonna overrule.
I'll let you tell us. You got there at
At
14:15. When did you first start Alan Hamilton?
227.
So 14:47, 14:27. And you ended with Alan Hamilton?
At 1438.
At 14:38. You started with Angela Hamilton, 14:43, correct? That's why I gave you the pad so we could,
Thank you, sir. I forgot.
okay.
I'm not accustomed to doing it this way.
I don't take very good notes.
That's at 1443, 243, and I concluded that at 257.
14:57, correct?
Yes, sir.
Military time.
Oh, we're going to use military. 1457.
You put
Okay. Now, from there, you do what?
this guy is
I,
salty out of his mind.
Got a hold of Detective Koenig, and we went out and interviewed Mr. Reeves.
Okay,
I rather
so
doubt any of this is
left the
helping his
party room,
pest control business.
right? You didn't go into Theater 10, which was a crime scene.
That's correct.
And so how did you get to the location where Mr. Reeves was at? Did you go through another theater? Did you go all the way around the building?
Oh, he's holding in a hiccup. I hate that.
We walked to the back of the theater and entered the parking lot. I had obtained my vehicle, and that's where we did the interview, was in my vehicle in the
So
parking
you
lot.
went onto the parking lot, got in your vehicle and drove it around to the back.
That's correct.
Is that correct?
Yes, sir.
Okay. Now, your purpose of doing this now was you wanted to interview Mr. Reeves.
That's correct.
And we've been fortunate enough to hear the interview of Mr. Reeves yesterday in this case, and you were present, right?
That's correct.
Okay. Now,
I put those interviews in my blog post summarizing yesterday's proceedings, folks, over at
Certainly.
lawofselfdefense.com.
when you first got to the point of interviewing Mr. Reeves, you now had this information, this voluntary statement that Corporal Hamilton had given to you concerning the aggression that he had witnessed, correct?
Objection to the characterization of the question.
He testified it was aggressive,
Overruled.
correct?
This judge does not want to answer
And,
any more
um,
objections.
You certainly were interested, were you not, in what effect that aggression would have had on Mr. Reeves?
Yes, sir.
Because your job at that point was to assess whether or not Mr. Reeves's evaluation of the circumstances was reasonable, right?
Your Honor, I'm going to object.
No kidding.
Approach.
There's a lot of objection going on here from different attorneys. Some states seem to let, you got one attorney who gets to do the objections and questioning at a time. I guess some courts. And then other courts, it's like if you've got multiple counsel, it's just anybody can pop up and object.
Yeah. So, and people are commenting this guy's never making eye contact with Attorney Escobar. And you're supposed to direct your responses to the jury. You're told to do that. But normally people look back and forth. Remember the robot girl from the Edgecombe trial, the state,
State's
whatever her
ballistic
job was, I
expert.
forget. But
She's
she was like a
ballistic.
little animatronic. She'd look at the lawyer, get the question, and then tilt her head to the jury to answer with the same inclination every single time.
Yeah. This guy, he's made eye contact a couple times with the lawyer, and when he does, it's not happy. He looks like a beat dog. Let me read some of these real quick.
That can't be a suit, right? He can't have a jacket in that pattern and pants in that pattern. That would
I
be
hope so.
That would be circus-like.
Rayona 1868 says, Branca, how long does it take normally to get the book? I bought it on the 26th of January and still haven't heard anything in regards to shipping.
I don't know. I can tell you, I just autographed another 200 or 300 books just earlier this week. They're being brought back to the warehouse today. So if they ran short, they'll have an influx of books coming today.
You were going
Autographed.
to
Get
interview
hard.
Mr. Reeves, not only with yourself, but you were going to interview Mr. Reeves with another detective president. Is that correct?
That's correct.
And in this particular interview that you had with Mr. Reeves, you didn't have a pre-interview non-recorded, right?
That's correct.
You applied a different procedure for Mr. Reeves in this particular case. You recorded from the very beginning.
Yes, sir.
Okay.
You didn't chat with him first to make sure you'd be able to get intelligible answers out of him.
I loved it.
That was done in the front seat of your car.
That's correct.
Is that correct?
Yes, sir.
Okay. And is there a reason that it was done in the front seat of your car and not in the party room as the other witnesses?
Convenience. Yeah, he was handcuffed, detained. I didn't want to parade him back into the theater.
Well, you brought him into Theater 11 shortly after your interview, right?
Yes, sir, but we pulled as close as I could to that door to allow him to exit the vehicle to get into the
You couldn't have done that for the interview?
Theater 11.
And that wasn't difficult.
Sir,
That wasn't difficult.
I ran over a curb, so I was able to get up to it. Yes, sir.
Okay. Now, your interview of
Ran over a
Mr.
curb.
Reeves, you turned on the recorder, right?
Yes, sir.
And you started asking him questions, correct?
Yes, sir.
And we heard that Mr. Reeves told you that he was scared of Mr. Olson, correct?
Yes, sir. The tape. Yes, sir.
Okay, so let's talk about that. When you first started your interview of Mr. Reeves, you didn't even know the age of Mr. Olson, correct?
If this poor cop was a waiter, the only thing you could be sure of is you would not get the food you ordered.
I'm saying before the interview of Mr. Reeves, you didn't know Mr. Olson's age.
There again, sir, I believe that I might have been furnished that information as to the fact that he was in his 40s by Major Corbin and Detective Harris. I knew that he was not a older man, the victim. I now recall that they told me that he was a middle-aged man and might even have told me that he was in his 40s.
And did you know how tall he was?
No, sir.
And did you know how much he weighed?
No, sir.
Okay. And so you start interviewing Mr. Reeves. That interview of Mr. Reeves takes about 30 minutes, correct?
Goes on at 15:10, 3:10, and
This was a movie, be Ace Ventura, Homicide Detective.
Gotta
Do
get it
shaky
if you
hands.
need it.
I've got it here. That's right, 3:40.
Okay. So about 30 minutes, right?
Yes, sir.
Okay. You indicated to the ladies and gentlemen of the jury that you already knew, supposedly, that there was a phone in front of seat 9 in the theater, correct?
Yes, sir.
But you didn't know that seat 9 was the seat that Mr. Reeves was seated at, correct?
This is cross of
At
a
the time that I'm
state's witness.
interviewing Mr. Reeves.
Yes, sir.
I knew that he was on the back row. I knew that his wife was immediately to the right. I knew that Mr. Hamilton and his wife were 4 or 5 seats over to the left, and that the victim and his wife were in front of him.
4 or 5 seats. You think the Hamiltons were 4 or 5 seats to the left? What
Yeah.
about 7 to 9 seats to the left?
7 to 9. At
Whoops.
the time that I did the interview,
Yeah.
I wasn't aware. I knew there were witnesses on that row.
Well, you just said that you were aware that the Hamiltons were, I think you said 5 to 6 seats.
4 to
It's
5.
7 to 9, right?
He's those seats that the Hamiltons are in are not numbered on this map that I have. During my interview with them, they told me that they were 4 or 5 seats over to the left.
To the left. Okay.
According to Mr. Hamilton, he was to the north. The shooter was to the north of him, which would have been to the left.
And I'm sure that Mr. Hamilton told you as well that he was only able to see a silhouette because of the darkness in there.
I don't remember if that's the terminology that he used, but he did tell me that it was dark.
And that he couldn't actually see any facial features of Mr. Olson because it was dark.
Are you telling me that's who said, do that again, counselor, please?
Alan Hamilton.
Yes, sir.
Now,
Hold on. Could you redo that question? I'm not for
Sure,
sure.
sure.
Okay.
Alan Hamilton told you that it was so dark that he couldn't see the facial features of Mr. Olson.
Your Honor, I'm going to object.
Sustained,
There's-
sustained. Move on.
It's just what? This
Now,
is this
You
guy's
knew,
job is
however,
to
when you
investigate
were
it.
interviewing Mr. Reeves, that there was a
It's
phone
annoying.
on the floor, correct?
Yes, sir.
Did you know whose phone it was?
No, sir.
Well, did you ask anybody? By this time, I would imagine you had Detective Smith already in the crime scene, right?
Yes, sir.
But did you ask Detective Smith, hey, can you tell me what seat that phone is in front of? Did you ask him that? Smith?
No, sir.
So you didn't know who the phone belonged to and you didn't know what seat it was in front of?
No, sir.
But you knew that it was in the back row, which we call row A, right?
Yes, sir.
And you realized that it was somewhere in the center of that row? Or did you even know that?
I knew that it was in the center of that row, around the center of that row. Yes, sir.
And Mr. Reeves tells you that Mr. Olson hit him in the head, either with a fist or a phone.
Or something. Yes, sir.
A fist or a phone or something.
Yes, sir.
And so that must have triggered immediately a ringing of the bell. Wow. Mr. Reeves is saying he was hit with a phone.
Your Honor, I object to the gratuitous comments being made by counsel.
What?
The ring the bell.
That rang a bell.
Surely you're not a complete
Because you knew
idiot.
there was
You must have
a
occurred
phone
to
in
you.
that row.
Yes, sir.
And if Mr. Reeves is telling you that, hey, I think I may have been hit with either a fist or a phone, that phone becomes paramount in this investigation, right?
It's important. Yes, sir.
Very important. Would you agree?
It's important, sir. Yes, sir.
Is it not very important?
Everything is important, sir.
But this is
Very
really
important.
right?
It's
Not
important.
not the first 5 minutes of untaped interview. That
And
wasn't
the reason
important.
that it is
Not the
important
notes.
is because there may be some evidence, some physical evidence on that phone, right?
Yes, sir.
And that physical evidence could link that phone, or at least the DNA on that phone, to Mr. Reeves. Right?
Yes, sir.
And if in fact it does, now you've got a piece of evidence to try to recreate what happened, right?
Yes, sir.
Because that's what you're trying to do in these investigations. You're trying to recreate what actually happened in that theater, right?
Yes, sir.
Okay. So Mr. Reeves also tells you in that interview, not only that he was hit with a phone, but he tells you that that phone was in between his legs immediately after the shot. He realized, oh, there's the phone right between my legs after the shot took place, right?
Yes, sir.
And clearly you knew that because Alan Hamilton was the person that told you that the phone was on the floor,
That's correct, sir.
in between Mr. Reeves' legs.
Yes, sir.
And Reeves told you that it was a dark theater.
Yes, sir.
And you would agree the darker the theater, the more it affects people's ability to see.
Objection, speculation.
Oh, come on.
You would agree the darker the theater, the more it affects people being able to see, right?
Yes, sir.
He also told you that it was extremely loud in that theater because of the previews, correct?
I don't know if he uses that terminology. He says that it was loud.
Okay, and you didn't doubt that, right? Previews are loud.
Calls for speculation.
They can be, yes, sir.
And had you known by this time what the previews were?
Objection, Your Honor. I only watch
you didn't know
Nicholas
that there
Sparks
were
movies, and they're
action
not
RoboCop,
loud.
Terminator.
Objection, facts not in evidence.
RoboCop and Terminator. RoboCop's in evidence.
Oh. Overruled.
Did you know?
No, sir.
You hadn't asked anyone there in management with the theater, hey, listen, tell me what the lighting settings were during the previews and what those previews were.
No, sir.
In fact, you never did that, did you? In your entire investigation there at the scene that night, you never even did that.
No, sir.
Hmm.
And they really never do, folks. They should. That would be the right thing. But normally, once
Now,
the cops get
When you
to
realize that there was that.
something that looks like a coherent narrative of guilt, they hand the case off after that.
Contact Detective Smith and say, hey, we've got to be very, very careful with that phone.
That's why it's important to be able, as a defendant, to hire your own investigators.
Mr. Reeves just told me that he thinks he may have been hit with that phone. Did you tell Detective Smith, who was the crime scene detective, to do that?
No, sir. That was part of his training, forensic techs, his training on how to handle possible DNA evidence.
So you left it to him that you didn't know whether he had ever been assigned as a crime scene detective on a case.
He had been assigned as a crime scene detective on a case, probably not on a homicide. However, he knew the proper procedure for handling DNA evidence.
How do you know he did?
He's very sharp. He
This
knows
is from
how
the
to
cop
work
who's
with
already
things.
testified. He himself
I've
does
been
not
with
follow
him
the
before.
procedures
He
for
knows
evidence.
his job.
So grabbing the phone off the floor.
He's a good cop. He
and,
knows his job.
Turning it off the day of the incident and then coming back a few days later and taking the phone from.
You're damn right I ordered the code
the
red.
evidence room and turning
Yeah,
it on.
Jack, there's been no evidence of that.
Sustained.
What was there no evidence of? What did I miss?
Mr. Reeves
Something
told
about
you
how
that
the
in
phone was
addition to
picked
being
up by
hit
one of the
on the phone
investigators.
with the phone,
There was
Mr.
evidence
Olson
of that.
was cursing violently at him, right?
I don't know if he uses the terminology violently, but he was cursing.
And that certainly was being corroborated by your previous interview of Corporal Hamilton.
Yes, sir.
Did you ask Mr. Reeves, how close was Mr. Olson to you when he was leaning over that chair and yelling profanities?
No, sir.
You didn't ask him that?
No, sir.
I think you already testified that you didn't ask Mr. Reeves in that interview what his training was in identifying danger. Correct?
No, sir, I did not. But as I've previously testified, he could have been an ex-police officer, but in this particular case, that had no bearing on this investigation.
So you're telling this jury then that his prior training, no matter how extensive, had no bearing in this case?
So as I testified yesterday, we are all human and we all have the capability of making mistakes.
No, listen to my question. You just told this jury that his prior training and expertise has absolutely no place in a case like this. That's what you just told the jury.
During my investigation, it had no bearing
What?
in my investigation.
And so you didn't consider it.
I did not.
How would
Now,
that have no
Mr.
bearing in
Reeves
any
told you
investigation?
that he was so frightened that he was trying to create distance by leaning sideways and back on his chair, correct?
I recall him telling me that he leans back in his chair.
And that was to create distance, correct?
That's correct.
You've been a police officer long enough to know that that's one of the skills if someone's about to attack you that you want to do, correct?
Objection.
Oh,
Words are not violence, folks,
One of the
but
things
words
you're
can
supposed to do
color
is to
aggressive physical
create
conduct.
distance.
He wasn't standing up to ask
Some
him for the
situations,
time.
yes, sir, you want to do that.
You certainly don't want to get closer to the person that's about to attack you. That's a big no-no, right?
There again, sir, it depends on the situation that you're in.
Oh, so you think it's okay if someone's attacking you just to get closer to them?
There again, sir, every situation is different.
Well, this situation, you think it was reasonable then for Mr. Reeves to get
John
closer?
Ryan, John.
sustained.
I like the counters in the chat.
Mr. Reeves told you that Mr. Olson told him that he was going to kick his ass.
There again, sir, I'm not sure if that was the terminology or not that he used.
We just heard it yesterday.
There again, sir, I don't recall that. Let me look. Do you have the page number there?
I can give you the whole transcript.
I've got the transcript.
Okay, well then.
I was just hoping that maybe you would have the page number.
Can you please remember my answers for me?
I love that last question that just got objected to. So you're saying in this situation he should have gotten closer to the man threatening to beat him up? that's the every situation's different.
Pardon me, Your Honor, I'm trying to locate it real quick.
Out of 100, how many threatening situations is it safer to get closer to the assailant? Probably one or two. They have really long arms like this chick named Mars Girl. You'd want to get within her wide reach.
Pulls out a wastebasket full of shredded notes and starts taping them together.
It's in here somewhere. Give me a few hours.
Bad police work may not mean innocent, but it certainly can mean not guilty. Not guilty
right.
means the
It does
state
say
failed
that.
to prove guilt beyond a reasonable doubt. That can be the result
Say
of
not
bad police
listen
work.
to
The burden
stories.
is on the
I
state.
think that he was talking about texting his daughter. If it was any of my, there's fucking there 3 or 4 times. This ain't fucking, this ain't my fucking business, or I'll kick your ass.
There it was.
Whatever he's saying, he was threatening. I'm going to be candid to you. I don't remember exactly.
So that's what he was telling you, right?
Yes, sir.
And you believed that Mr. Reeves was forthcoming to you, right?
Objection.
So I said-
Yes.
He's trying to make this witness seem honest and sympathetic. I would imagine this is the character for truthfulness objection here. You trusted him. He was trustworthy. He's forthcoming. He's being honest with you. And that probably should be objected to, by the way.
Normally, I would say yes. I mean, of course, police investigators are supposed to be trained in techniques to help determine whether or not someone's likely to be lying or telling the truth.
True.
They can't know if they're telling the truth, but they could testify, I didn't see any of the typical signs of someone attempting to deceive me.
Bill Anderson says, so much nonsense going on at work right now. Nick and Andrew, you two are literally helping me survive it. And also creating random out loud laughter all day. Thanks, guys. Appreciate you. Hey, thank you. Lancelot 652 says the defense probably deposed the janitor to see if he used pine or lemon to clean up the blood. They've had plenty of years to track him down. Randy May says, Nick, have you ever had Classic 12 by Canadian Club? It's my favorite. If not, please review at your convenience. I have not. If I ever see a bottle, I'll try and pick it up. Stephen Oglesby says, can the jury object to the objections? No. And Andrew, if I bought your class bundle, can I get DVD instead of streaming?
Oh, I saw that comment. We can certainly do that. All those courses, I think they're all also available on DVD, but obviously then there'd be a shipping charge. So you'd have to email support@lawofselfdefense.com and let them know what you'd like. And I'm sure we can set something up.
And then White Alakazam says, what about one slice of bread, peanut butter on one side, jelly on the other, and then you can lick your fingers after, like when you eat Doritos, or use it as lube for your Murphy hole. That got disgusting. No. If you're doing the one slice of bread, you should do half of it with peanut butter, half of it with jelly, and fold them together. You fold it over like a little half sandwich that you give a kid or whatever. Let's see. Self-defense. Okay. Greg McNeely gave you a thumbs up, a cross thumbs up. Andrew, when Nick Rekieta Law initially streamed the Burlington Coat Factory shooting, we had the same conclusion. Law enforcement work is multifaceted, intel-driven, updates, and split-second decisions. Yeah, well, this isn't split-second at this point. I mean, now they're in an investigation. They get to take quite a bit of time. But it's like this guy wanted to just go home right away. I mean,
in a sense, I'm sympathetic to the cop in that this is how they always do this. I mean, they never do a thorough investigation of self-defense factors, ever. Should they? Yes. Arguably, does Florida law demand that? Yes. Would that be a truly comprehensive investigation intended to arrive at something resembling the truth? Yes. But they don't normally do it. So this guy was doing the half-assed job that they normally do. In his head, he wasn't doing anything wrong.
Right.
But that's why we have an adversarial process in court to expose this stuff. Just because it's their normal practice doesn't make it right. In fact, it would be nice if it changed the normal practice, right? Where
Absolutely.
There's an apparent self-defense dynamic, that evidence on that point is also collected as aggressively as evidence consistent with a probable cause of a crime being committed.
With any case where there's any, not just self-defense cases, not just murder cases, but any idea where exculpatory evidence could be found, it should be found, especially if the person says it wasn't me.
Now,
This
let's talk
thing.
about that phone a little bit more.
Sir?
Let's talk about that phone a little bit more.
Okay,
You didn't know the weight of the phone at that point in time, correct?
that's correct.
But you would agree that if that phone was being thrown at someone else, it's being used not as a phone, but as a weapon.
It could be, yes, sir.
And you would agree that that phone can cause great bodily harm.
It could, yes, sir.
It cause death.
It'd be difficult, but I guess anything is possible, sir.
It'd be difficult. No. Tell me why you think it would be difficult.
Judge object.
You opened the door on it, Judge.
Judge, can we approach, please?
Oh my gosh. They're going to make this cross exam take 10 hours.
Well,
Well, you're lagging on me hard there, buddy. Oh, it's starting to clear up. Starting to clear up. You turned into a robot and it was
oh, I did. Oh,
yeah.
a glitch in
Sure.
the matrix.
Andrew's programming is rebooting as he watches this detective.
Well, we pay for all the internet here, so we normally have a pretty good connection, but you never know.
Oh,
There
yeah.
was a delayed school start today, so a lot of kids are still home streaming stuff, I'm sure. So
Yeah, normally, I mean, everything's clear. It was
To
just seemed to
suggest
be that one
that you
moment.
can't cause death with a phone.
I have no medical training, sir,
Okay.
other than first aid.
Yeah.
oh, so you
You
have some medical training.
training.
In fact, not only a phone, hands can kill.
Yes, sir.
How many murders did you investigate? How many of them involved the beating to death?
And
How
you
many
would
of them
agree
involved an elderly person getting beaten to death?
that if a phone is thrown at somebody and it hits them in the head, not necessarily going to cause an open wound, right?
It might not. Yes, sir.
There's a lot of factors that you have to consider, right?
That's correct, sir.
You didn't investigate those factors, did you?
Did you all ever weigh this phone?
Yes, sir.
Was that after we weighed it?
I believe so, sir.
And you found this phone to weigh as much as a cue ball. Correct? Cue ball, like a billiards cue ball?
I'm not familiar with the weight of a cue ball, sir.
Well, if I had thrown a cue ball at you, it could cause great bodily harm, right?
Yes, sir.
That's a nice analogy.
It could cause death.
Good. Yeah.
No one's going to volunteer to get hit in the head with a cue ball.
Now, of importance was, in this case, Mr. Reeves' disabilities, right? What was his medical condition, his physical condition? You never asked him that. Right?
No, sir. He volunteered it.
Yeah, it is about
Yeah,
the same
to tell
weight. How about that?
That he had arthritis, bad back, correct?
Yes, sir.
A whole slew of
I would not have guessed that.
ailments that he was telling you he was experiencing at the time of this incident.
Yes, sir.
Did you ask him for particulars of that?
No, sir. I did not.
Meaning, Mr. Reeves, tell me what, you've got arthritis in your hand. Tell me what that does to you. Never asked him that.
No, sir. I did not.
Mr. Reeves, you've got arthritis in your shoulders and in your spinal column. Tell me what that does to you. Never asked him that.
No, sir.
Mr. Reeves, do you have difficulty getting up off a chair? What do you have to do in order to get up off of a chair, Mr. Reeves? Never asked him that.
And he never told me that. No, sir.
My question is, did you ask him that?
Oh, no, sir.
Did you ask him, Mr. Reeves, you've got these shoes that you have to kind of pull some strings there. Are you wearing those shoes for a reason? Didn't ask him that.
No, sir.
Did you ask him how heavy he was?
I did.
Did you ask him, hey, was that your normal weight while you were a law enforcement officer?
No, sir, but he told me he'd gained some weight.
Did you ask him if that was his weight while he was the head of security for Bush Entertainment?
No, sir.
Did you ask him if he had deteriorated during the last few years?
No, sir.
Did you ask him what his limitations were?
No, sir.
But he told you he was a physical wreck, right?
Yes, sir.
Oh, it froze?
That was important in
What?
your investigation, was it
Did the
not?
court feed freeze?
No, mine's still running.
Oh, okay.
As we
Mine is running on my laptop, but it's
Well, that
on our
is
screen.
particularly
It's
important, was it not?
It was
in
important.
StreamYard. It's frozen.
But you didn't ask
My
Oh,
view.
weird.
any follow-up questions at all?
No, sir. He appeared to be
Running on my
healthy.
screen.
Oh, is that back to your medical degree?
Judge objection, Judge.
Sustained.
Is that because?
It's
you
frozen
now have
for
qualifications
you
to be
guys.
able
I
to
mean, it's
assess
playing on
someone's
mine.
condition by visual sight?
Now it popped forward. Yeah, it's all.
Okay.
Observe someone.
It's like snapshots.
He's able to walk around. He's
I'm
not
having
under,
a lag issue. Just a second.
doesn't need a cane. Doesn't need any of that stuff to get around.
So you're okay if you don't need a cane and you can walk?
Well, he didn't appear to be physically disabled.
Do you think that individuals in their 70s
This medical assessment is okay.
can
Yep.
perform just as easily as someone in their 30s or 40s?
There again, that depends, sir.
And that's why we have to ask those questions, right?
It'll catch up in a
Yes, sir.
minute, guys, when my internet decides to get back to normal.
Did you consider Mr. Reeves's age?
Yes, sir. I knew he was 71.
Okay. And did you ask him, hey, why did you retire from Bush Entertainment? Such a great position as head of security. Why did you do that, Mr. Reeves? You ask him that?
No, sir.
Pretty good job, right?
I don't like Busch Gardens.
Head of security for Busch Gardens.
I don't like Busch Gardens.
Oh,
He
you don't
doesn't like Busch Gardens?
Okay.
Is he getting snippy?
Oh yeah, he's been progressively getting.
And then let's talk about this eye. Mr. Reeves had told you that he had been hit somewhere in the eye area, correct? The head.
Yes, sir.
And he told you that he was experiencing some difficulty at the time of your interview. Correct?
With his eye. Yes, sir.
With his eye. Now, by this time, had you interviewed Mrs. Reeves? Not yet, right?
No, sir.
That was after the first interview of Mr. Reeves.
Yes, sir. He requested or told me that.
Guys, it's just a lag
Okay.
issue between me and StreamYard, or between StreamYard and YouTube. Just chill the fuck out. Like,
Now-
there's nothing you can do about it.
Mr. Reeves also told you something very important. And that is immediately after he fired the weapon, he placed that gun on his lap, took his hands away, right?
Yeah, see how I fixed
He
it
said
by
that he
not
put the
doing
gun, on his
anything?
leg, and that I don't recall him saying that he moved his hands back.
Well, what did Corporal Hamilton tell you then when he came up and took the gun from Mr. Reeves's knee? That Mr. Reeves's hands weren't anywhere near the knee, right?
I don't recall him telling me that, sir.
Well, what's the issue with it?
I don't recall. I knew the gun was on his leg. I don't know if he had his hand on top of the gun. I recall Mr. Hamilton telling me that he walked over and took the gun from him, that he had it
On his knee?
on his knee.
Okay. And so you would agree, and I'm sure you've been trained in this as well, you would agree that in a situation where you're in a darkened area, you're in a theater, there's been a shooting, you certainly don't want to be displaying that weapon out to the entire group because someone else may have a gun and start shooting, correct?
That would be a very pertinent thing to do, not to display.
So Mr. Reeves, immediately after the firing the shot, was in training protocol, putting that gun immediately on his knee out of sight.
Yes, sir. Common sense.
Well, it's common sense and training, correct?
Yes, sir.
Immediately after the shot took place, correct?
Yes, sir.
And you're taught as a police officer that the minute that you stop the threat, you don't keep shooting, right?
That's correct.
One shot in this case, and only one. Correct?
Yes, sir.
Training protocol.
His training is
Is following that
relevant.
training.
Yes, sir.
You said that wasn't relevant earlier to your pertinent to your investigation.
You finished that interview with Mr. Reeves. And let's talk about the time, because I want to make sure we've got this time sequence nice and tight. What time did you finish with Mr. Reeves? 3:40. I thought you wrote it down on that piece of paper there.
I finished at 3:40.
At 3:40.
Yes, sir.
Okay, and so now you are going into what investigative mode? What are you doing now? After you finish that, you go to Mrs. Reeves, correct?
That's correct.
Okay, so let's talk. What time do you start Mrs. Reeves?
One moment, sir.
I'm sorry.
I started that interview at 16:25.
Also known as 4:25, right?
Yes, sir.
16:25. And you finished that interview at 16:38.
That's correct.
How many minutes is that?
That's
Oh, math. They said there wouldn't be math.
30,
I hope it's not 30.
no, at 30.
Oh, no, he can't do the math.
Oh, you talking about for Miss Ray's? I apologize, sir.
Yes, that's okay.
That's 13 minutes.
You had a 13-minute interview with Mrs. Reeves.
That's correct.
And this one you recorded immediately. No pre-recording by you.
That's correct.
And she was a witness, not a suspect.
That's correct.
And so you didn't violate the protocol of the sheriff's office.
That's correct.
And Mrs. Reeves likewise told you that she was scared.
Objection, Judge, to hearsay.
Sustained.
Okay. You spoke to Mrs. Reeves for 13 minutes, right?
Yes, sir.
Okay.
It's again,
And so
it's not about whether or
after
not
that
she was
13
scared.
minute
It's about
interview
whether
with Mrs.
she
Reeves,
told him she was
you
scared, and
decided
then
to go
he
back
used
and
that
interview
in his
Curtis.
investigation. So it's not actually hearsay.
So let's try to take the scenario if I can. Alan, Angela, right?
Yes, sir.
Curtis,
Yes, sir.
Mrs. Reeves,
Yes, sir.
now back to Curtis, right?
Yes, sir.
Okay, and so when you go back to Curtis, what time was that? I've got it right here if that makes it easier.
16:43.
16:43.
I've got the answers here that I'm
16:43, right?
trying to get from you.
Which would have been what?
4:43.
4:43. And then you finished that at 16:48.
That's correct.
Is that correct?
I'm waiting for him to pull out a giant old style mechanical calculator.
Let's talk about between 1643 and your last interview with Mrs. Reeves. You finished Mrs. Reeves' interview at 1638. Is that correct?
That's correct, sir.
And you started Mr. Reeves's second interview at 1643.
According to my notes, yes, sir.
Is that correct?
Yes, sir.
How many minutes is that?
5.
5 minutes. Okay. And so in between that period of time, after you interviewed Mrs. Reeves for the second time, your testimony is that you go to the command center.
We have a meeting. It's not really a center, but command center, but we have a meeting out in front of the theater.
Okay, so you have to, let's see if I can get this correctly. You were interviewing Mrs. Reeves in the same room?
I believe so, sir.
Okay, and so you have to leave that room, have to leave the theater. You got to go through the doors
Right.
and go out into the parking lot where you had your makeshift command center, right?
That meeting occurs right there outside the front of the theater, right there in front of the box office.
Okay, and would you tell the ladies and gentlemen of the jury again the purpose of that meeting?
To discuss the case, the information that patrol deputy or detectives had received from their witnesses, their interviews.
To discuss the case. So that's a very important meeting, is it not?
Yes, sir.
Because you're trying to get information from all the various sources of witnesses that are being interviewed, correct?
Yes, sir.
And these witnesses are being given voluntary statements for them to write down what, in their opinion, they saw. Right?
Yes, sir.
And so that's a lot to look over, right?
Yes, sir.
And so it must have taken you probably, what, a minute to get from the room that you were interviewing Mrs. Reeves to that meeting up front?
Possibly, yes, sir.
So that leaves us 4 minutes. And so now it must have taken you at least 3 minutes to go from the meeting to go back to Mr. Reeves, right?
I'm not for sure, sir, how long it would have taken.
Well, he was in the back, right?
Yes,
In a
sir.
car. And the meeting was out front of the theater.
Yes, sir.
But it took you at least 3 minutes to get there, right?
There again, sir, I don't know. It would have
So you must have had a 1 minute meeting with your group outside the theater, because those are the numbers, right?
Yes, sir.
A 1 minute meeting, you had to discuss all of the evidence that allegedly had been uncovered.
We good, boys?
at that
Yep, we
point,
good.
right?
Going
1
home.
minute.
There you go. Done.
I tend to believe, sir, it was longer than that.
Well, the numbers don't add up, right?
That's correct.
And so tell me who you spoke to outside the Cobb Theater for a minute that gave you enough information for you to go back and tell Mr. Reeves that you were going to charge him with second-degree murder.
We had stood there and talked. The detectives, command staff was there. Sergeant or Captain Eckley, Major Corbin, the sheriff, Detective Harris, Sergeant Sessa, and they had said that no one had seen a punch being thrown and that no one had seen the suspect coming over the chair.
Oh, you must have told him, wait a minute, I spoke to Mr. Hamilton. He says, yeah, that, Olson was leaning over the chair and he was yelling and he was cursing. I'm sure you told Captain Sessa that.
Your Honor, I object to the characterization of the question. Leaning over and coming over are two very different things.
Sustained.
What did you tell Captain Sessa about your interview with Mr. Hamilton?
Sergeant Sessa.
Sergeant, sorry.
I think we didn't go into in depth. We didn't go in depth. We simply wanted to know if anybody had seen a punch being thrown or anything being
Listen, it was
thrown
4:55.
the-
We were going off shift in 5 minutes.
and
Yep.
we wanted, or at the suspect. We wanted to determine
Dancing with the Stars was coming on.
if
My wife was
anybody
gonna be
thought that
super
the
pissed if I wasn't
shooting
home.
was justifiable.
Well, in a minute, that's hard to do, right?
There again, sir, my times could be off.
Well,
it's-
times are important, aren't they?
They are.
They're critical. They're part of the evidence, right?
That's correct.
And in a homicide case, especially, we can't afford to not be correct, right?
It's very important, sir.
And so
it's not a very good defense to say, yeah, all my stuff may suck.
nobody saw a punch being thrown. Nobody saw a phone. That was like the deciding factor for you, right?
Being thrown.
The being thrown.
Yes, sir.
And so, darkened theater, correct?
Yes, sir.
You don't know how dark it was because you weren't in there to see it for yourself.
That's correct, sir.
You hadn't gone back into the crime scene and said to the manager, please turn the lighting to the lighting that was present during the previews so that I can sit in this chair that Mr. Reeves was sitting and I could experience what he was experiencing. You never did that
No, sir.
before you had that meeting with, I guess it's the brass of the sheriff's office, right?
That's correct, sir.
Someone in the comments
never
asked, does it
went to
take
the
an hour to
manager and
explain
told
a
the manager, hey,
5-minute
by the way,
confrontation?
I
Well,
also want
it's
you in
taken
addition to
8
put
years
the
for
lights
the
down,
media to
I
be
want you
selling
to put
killed
those
over
previews
popcorn. So yeah, the
Because
defense
I
has to
wanna sit in
overcome that
chair and
8-year-long
I want to
narrative.
Experience whether the loudness of the previews
Your Honor, I object.
had any effect.
Your approach, or it's just an improper form of questioning.
I'll overrule.
You never did that,
It
did
does
you?
seem kind of random.
Sir, I did not.
Yeah.
And did you tell the
She's just playing
brass
Candy Crush right now.
there
She's
at
not
the
even
Pasco Sheriff's
worried
Office
about
that,
what's
by the
happening.
way, I haven't even gone into the crime scene? Did you tell them that?
No, sir. We were aware of,
Well, you may have been aware. You didn't tell them that you had not been in that crime scene. Is that correct?
that's correct.
Nobody has to
The
prove
first
a
time
punch was thrown,
that you went
folks.
into that crime scene was
Nope.
at 5:32.
And there is
in the
evidence
afternoon.
consistent with a punch being thrown.
If I may.
You may, please.
This is like a shark with a Florida tourist in its mouth,
You may be.
just shaking it back and forth.
Yes, sir. because I don't seem to have everything. You have the crime scene?
Got him.
I think I do.
Got him in the jaws.
At my fingertips.
Thank you, sir.
Can I approach?
You may.
I've got my notes at my fingertips. I didn't shred my notes, officer.
Someone in the
Detective.
chat said this is all irrelevant bullshit. Actually, it
It's
is
in the
not.
first page,
mean,
detective,
the-
very top.
There you go.
And if you-
I apologize, sir. 1732. That's correct.
If you're on trial for
Yes, sir.
murder, all of this is very relevant very quickly. How good of a job the detectives do is the difference between you going to prison forever and you going home.
Now, let's talk about that very important process of the case, because your job's not over, right?
No, sir.
You may have told Mr. Reeves and charged Mr. Reeves at that point with second-degree murder. Let's talk about the number. What was it, 2 hours? And in 2 hours and 16 minutes from your arrival, you're charging Mr. Reeves with second-degree murder. In 2 hours and 15 minutes, 16 minutes. That's why I became a lawyer. Math is. Tell me if I'm right.
I always love when lawyers validate that none of us can do math.
About that, yes, sir.
Okay. So now your job's not over, is it?
No, sir.
Your job now, you're going at 5:32 for the first time into this, and let me call it an incident scene because that's what it is, correct?
Objection.
What?
The phrase is improper.
It's an incident scene
Is it?
where the incident happened. Correct.
Overrule.
Objection.
So
We want him to
crime
call it a
scene,
murder,
Murder
scene.
scene,
We do
right?
not agree.
I consider it to be a crime scene.
You consider it to be a crime scene. Okay, so we'll call it a crime scene. So now you go into the crime scene and Detective Smith is there, correct?
Yes, sir.
Could the crime have been the
have some,
assault on Curtis Reeves?
Some forensic people there as well, right?
Felony battery
You already know
on a
about the phone.
71-year-old?
Yes, sir.
Is that correct?
Was that the crime? Did you
But
consider
you
that
still
crime?
don't know what seat
Destruction
Mr.
of
Reeves was
popcorn
actually in.
property.
Pointed out that seat at that time.
Well, we're gonna get to that.
Okay.
Hey, given what
Okay.
they charge for
And so
popcorn, every
when you
theater
go
is a
in there,
crime
you don't
scene.
know what seat Mr. Reeves was in.
I knew they was on the back row. I knew they was in the center, but the actual numbered seat, I did not know.
Okay. And so when you go in there, do you see the phone? Do you see the phone at 5:32 in the position of that aisle?
I'm not for sure, sir, if I saw it there or if it was pinned with a pin marker.
Meaning that there could have been a pin marker there, but the phone may not have been there.
That's correct.
Yep. Battery on a 71-year-old
so-
in Florida is automatically
I'm
by
sure that at
statute
some point
felony
in time
battery.
in your investigation post-entry of the crime scene, that you discovered that the phone had a black case, correct?
Yes, sir.
And so if, excuse me a second, Your Honor. If I am throwing a dark object in a darkened theater, you may not be able to see it. Right?
That would make sense. Yes, sir.
That makes a lot of sense, doesn't it?
It would be difficult. It would be possible that that could happen.
So did you go up to Smith and say, let me see the phone?
Striking somebody with a thrown object is battery, folks. That's
No, sir. I
a
knew
simple
what-
battery.
I knew what a cell phone looked like. We did not want to. We don't handle phones. We had photographed it. We knew where it was
Called the
at. We
Verizon
had it
guy.
pinned. They're handling the crime scene properly.
Well, you hadn't been in there. If you arrived at 2:15, you hadn't been in
Hey.
there for at least
Welcome to
3.5
the show,
hours,
sir.
right?
That's correct.
Hey, Steve.
You don't know what was
Hello,
in there.
can you hear me?
Detective
Yep.
Yes.
at the helm.
All
right?
good.
There again, sir, I have
You're cracking me up, you guys.
my team of forensic investigators and Detective Aaron Smith.
Hello.
So let me ask you this question. So
Hey, thanks for being here. This is Stephen Gosney, who was in the chat, folks. He's a
the dark
public defender down in Florida. Very, very good attorney.
As
We're lucky to have him here.
that's one of the important
Thank
things.
you.
That's correct.
Your coverage is
At
great.
that point in time, at 5:32 in the afternoon, did you go and get a manager to say, I want you to dim those lights?
Objection, asked and answered.
No, it's at 5:32.
This
At
is a very
5:32,
good
you did
defense attorney,
That's right.
Cross.
Yep. They've been great on Cross the whole
Is
trial.
that not important at that
Yeah.
point?
I'm sorry, sir.
Was that
Dino
not important?
Michael's opening was a train wreck, but they've been very
To get
good on
those
Cross.
lights down while
I haven't
they're-
really been following it today. I'm homesick,
But was that not important?
so I've tuned
I
into
did
you
not.
guys, and this is just a
I didn't
brilliant.
know.
I love watching great
At the
lawyers
time,
do
I didn't
Cross.
think of that.
This is your only opportunity, detective, you would agree with me, to recreate the scene that Mr. Reeves was experiencing. You could have sat in that chair. You could have put the lights on at the preview level. You could have put the previews on. You could have had someone that was 6'4" from the battalion of officers that you had there standing where Mr. Olson was. You did none of that.
No, sir.
Well, let me ask you this. Did you get your crime scene technicians that were there in order to memorialize by cameras that very experience?
That day,
No,
no, sir.
that day, no, sir. Did you
I
do it
thought
at
you
a
were in charge
different?
of this homicide case.
I was.
Did you ask Mr. Smith, hey, Detective Smith, you know, we've got some lady here by the name of Amy Parrish who has had extensive training in being able to capture photographs in darkened areas. She's got some expertise in that. Let's get her to do that here. Did you do that with Detective Smith?
Not that. No, sir. Not that day.
Not ever.
Not that day. Why not that day?
I didn't think of it, sir, at the time.
You didn't think of it.
No, sir.
And was that because you had only had one case in the past dealing with self-defense, detective? Is that the reason why you didn't do these things?
Killer.
Difficult question, isn't it?
The
Hand him a box of tissues.
I tried my best to do the very best job that I could as far as the investigation.
Detective, I don't doubt that you tried to do your best. That wasn't the question.
Right.
The question is, do you think that the reason that you didn't do these things is because at that point in time, you did not have the experience in dealing with a self-defense?
You have the competency of a
Ooh.
cabbage.
It's a good question.
Oh boy, stunned.
Limited experience with that. Yes, sir. That could be a possibility.
Wow.
Possibilities are dangerous in our criminal justice system. You would agree?
Yes, sir.
I'd sit down right there, man.
We can't afford to make mistakes, can we, Detective?
No, sir.
When a man's life is at stake.
Right.
Because you have a man's life in your hands as well.
Bronco hits it again.
Sustained.
Oh, wouldn't you say? I mean, at what point is this a dead horse? At what point do you sit down and let the dramatic effect,
All right, let's take a 10-minute recess, please.
or take a
Remember
recess?
mine's-
If you got more points, take a recess, right?
Yeah, it's good. The 10-minute recess, they'll go over their notes, make sure they hit everything they wanted to hit on.
Yeah. Oh, brutal.
Brutal.
So, Steve, welcome to the show. Tell us a little bit about yourself, if you could.
Thank you. Well, I'm actually, I'm a board certified criminal defense lawyer, trial lawyer in Florida. I work for the public defender's office in the Seventh Circuit. And although I've been in appeals for 11 years, so I do criminal appeals, recently promoted to capital appeals. And so I've been in criminal law. I was a prosecutor for 6 years, been a public defender for 11 years, worked in civil practice before that, worked in private industry for 7 years before that. So I've been around for a while, and I do a lot of writing, and I'm an Andrew Branca fanboy.
Steven's one of those genuinely intellectual lawyers. He gets stuff published in law journals and things like that.
Oh, you're like one of those guys that works hard.
Right. Well, I'm a glutton for punishment. I mean, I figure that I'm being paid for by the taxpayer. And when I'm not busy, I owe the taxpayer some of my work. And so a lot of what I'll do, a lot of my stuff is practical. I think I might have sent Andrew a link of some stuff, but basically I get questions from our trial division, and they'll ask these questions over and over again. So I ruminate on them and try to really drill down to the bottom and answer those practical questions. And sometimes they turn into law review articles. So you can look me up on SSRN. Most of my articles are on SSRN, but they're all practical Florida defense attorney based stuff. And sometimes they're genuine insights. Sometimes they're just a result of research. But, sometimes the work's already been done. Like when I one of the reasons I found Andrew's book was because I had a self-defense question, and I started drilling down, and I'm like, the book's already been written. And I got his book for free. Nice signed. I love my signed copy. And it's so well written. It's just, why recreate the wheel? You've got the guy who knows what he's doing there. So
All of you can get the book free too, folks. lawselfdefense.com/free book. Now's your chance.
He says free, but you got to pay the shipping.
Oh, yeah, nice.
Well, that's awesome, man. It's great. I think public defenders get a really bad rap from kind of popular media and stuff like that. But in my experience and what I try to communicate with people is it's with public defenders, it's rarely the quality of their work that's at issue. It's usually, if anything, there's so many cases, they're just so busy that for some public defenders that can cause some issues because they've got 300 files at a time, which is that's just too much work.
that's somewhat true. It depends on the case and the jurisdiction.
Right.
Because, our jurisdiction, I think we could use a few more. A lot of it is recruiting people who will stay for the salaries they're getting paid. So, that's more of it's not, I wouldn't say the workload, because when we have a big case, we put the pedal to the metal and we hire experts and we have teams of people handling it. I mean, when we have a case that we really fight and it's like there's a legitimate issue, the thing is when you get complexity and you have difficulty, that's when, you know, if you have like a self-defense case that's complex, I don't know. I mean, I think the quality, for example, just on the quality of the public defender's office, we have a great office. And I mean,
Yeah.
I think John Terhune you interviewed, and I would say he's part of a team. We have multiple trial attorneys of that caliber in our office. And I'm just always humbled working with them because we have some great, now there's also people that are new, but we also have a training. I'm in charge of all the training in the appellate office. And I also train the trial division. And I'm proud of that our office does that for our attorneys is we train multiple attorneys to be better attorneys. And so the main thing is keeping them when they can get bigger money. But sometimes you're a true believer like me and you stay around even when you're getting paid the peanuts, right?
So did you see that interview I did with Terhune?
I loved it. Great. Isn't he
Nick,
brilliant?
I did not.
So he had just won a self-defense immunity case down in Florida in a case where the guy had previously been convicted and sentenced to, I forget, 20 years, I think, and
Right.
for I forget, attempted manslaughter or murder.
Right.
And it got reversed on appeal due to ineffective assistance of counsel, which really almost never happens. It's almost always claimed, but it's never granted. But it was in this case. In fact, Terhune tells me that the trial lawyer himself said, "Yeah, I screwed up. I didn't do a good job."
Right.
So it got reversed.
That was a private counsel. Yeah.
Private
And that was
counsel.
actually, it was reversed on what they technically called a 3850, which is a procedural motion at the trial level, not at the appellate level, in which you can allege ineffective assistance of counsel. And then at that point, that's an evidentiary hearing. On an appeal, you can't bring in new evidence, whereas that trial lawyer testified in a new evidentiary hearing before the trial court in 3850.
But I interviewed Terhune afterwards, just a couple weeks ago on my own show. And man, the guy's like 40 years of experience as a prosecutor and a public defender. I forget how many scores of murder level cases he'd worked on before.
I remember he said he had 250 trials and I've had about 70. And, but having 250, I can't even believe it. Of course, he was a prosecutor for many, many years.
Right. So he's currently a public defender. He works in the sixth judicial circuit?
Seventh. Sure.
Okay. But you're not going to find a private attorney with that experience.
No way.
I mean,
and you can't pay for the commitment, the heart. And that's what I always tell people when they're, looking for private counsel is find somebody who is a believer, somebody who's going to fight for you, believes in defending your rights to the nth degree. And, what you pay doesn't necessarily dictate the quality of that attorney. We have some great attorneys, private counsel, we got bad ones. And I think that's the way it is in most professions.
Yeah, what you want to do is you want to find an attorney who looks at you like the defense or like the prosecution lollipop guild looks at the bottom of the counter.
Or the press looks at Hillary Clinton.
Yeah, that too. Oh my goodness. So you haven't, you're like a guy who works and does stuff. So you haven't been following this case as for as many days, right? You said this is the first day you're watching?
Well, I picked up occasionally. Today and tomorrow I'm off. So I was, what do I do on my day off?
More law.
More law. Oh, sick. But anyway, yeah. So I've tuned in. Well, of course, I always follow Andrew where he goes and try to pick in when I can. And then this defense attorney is just blowing me away. He's really good at cross. And I love watching good lawyers work. And you can learn from that.
Yeah, I think both defense attorneys have been very good so far in this case. And the prosecution hasn't been bad. And I think actually their objections today were very strategic. They were using them a lot to break up the flow of testimony and the flow of questioning. And that can be, sometimes you just have to do that because otherwise the way these guys are going, they would have just steamrolled that guy into the dirt if you gave him the road to do it.
Well, really what it is it's a test for the defense attorney on whether they can stay on point and not let it rattle them, and also a way to interrupt the attention of the jury. But ultimately, he's got this guy on the ropes and he's pounding him, and there's no it's just there's no stopping that. I think that the judge is a little tired of it, and you can see she's getting a little stricter. If she wants to shut this down, she can. She can say overrule, but and not let him approach.
When they come back from this break, I'm sure there's going to be a little bench conference, and she's going to tell them, "Listen, you got like 5 minutes more, and then we're done with this witness."
Right. That my question, kind of, you guys, was at what point is this beating the dead horse? You've made the point that the guy has been sloppy. He's admitted exactly what you want. I think now's the time to sit down. I think you can talk yourself out of good cross sometimes.
Yeah. I think he's there now.
Yeah.
I mean, those last couple of questions, the tone was much reduced, and
He
he's kind of,
closed it. The guy agreed with him. The guy says, "This is relevant. I didn't do what I was supposed to do. Yes, I'm incompetent." Just what else do you want? You can't get any more than that.
I guess it was my young naivete that
no more
prevented
belt,
me from
daddy. No
doing
more
a proper
belt.
job. No, this is the time you come back from break. Like you said, check notes, make sure there's no other questions that you really needed to hit. And I mean, who knows what they would be? They have so much back material to such a deep well to draw from. But once you hit those, as long as you've hit your main points, go ahead and sit down, and let this guy off. Or, well, the redirect is coming.
Well, and I think John said this to Andrew at your interview, which was really insightful, that even a good defense case is 50-50, because we're lawyers here, and we've looked at it and we know the technicalities of it, but destroying the lead investigator does not change the essence of the facts of the case.
No.
So, you can argue. What it does is it gives you reasonable doubt arguments that you're closing. But ultimately they can say it doesn't matter if the cops did a sloppy job. What happened was this guy he did not act in self-defense. So you still don't have it. It's not enough. And a jury can disregard your argument in the sloppy police work and says, well, maybe they did sloppy police work, but he's still guilty. So
we saw that in the Theodore Edgecombe case that just occurred recently, where the defense attorney was arguing all this stuff. The police didn't talk to this possible witness or that witness, or didn't do this or that or the other thing. But the underlying facts were so bad for the defendant that he'd been a fugitive for 6 months. He lied when he was finally pulled over in a traffic stop, gave a false identity. There was nothing consistent with self-defense there. So it just gutted his claim of self-defense at trial. It didn't really matter if the cops were, and by the way, there's no perfect police investigation. They don't do everything. They don't go to every building in eyesight of the scene and talk to everyone who might have been looking out a window. I mean, that nobody has the resources for that. But it's rarely as bad as this has been made to look here.
Well, this is true. This is kind of, I wouldn't say that this cop is uncommon. This is pretty typical police behavior and the way they do things. And very, very few cases go to trial. So you don't see this kind of sloppy police work. And so, because maybe 1 out of 100 go to trial. And cops hate testifying.
Right.
Because they're used to being in charge and asking the questions and just, and then when the tables get turned, they get very uncomfortable. They hate this. I've actually trained police officers on how to testify. One of the people I think he's really destroying his credibility by the eyesight directed at the jury.
Yep. Terrible.
But as a prosecutor who used to train cops to do this, I'd say talk to the jury. Talk to the jury, because they're the people you talk. But this guy has taken that, put it in his head, and so now he's fixed. Right. And he's not, what you do is it's a conversation amongst people. Oh, that's a good question. Well, let me explain.
Because the way he's doing it, it doesn't look like he's talking to the jury. It looks like he's merely avoiding eye contact. With
it looks
attorney.
like he's staring at the wall above the jury's head.
But I think, is the jury off to that side?
They are.
He's looking towards them, but if I'm talking to a jury or even a group of people, I'm kind of scanning, I'm scanning the different faces, right? Or slightly above them, because it's weird to look people in the eye sometimes, but I'm scanning over them and I'm making sure to address all of them. He was just like, even when the guy's asking him questions, he's
probably just focused on the jury, and because he's been told talk to the jury, but he's taken that and become robotic about it. But it does diminish his credibility. I think he's basically admitting the criticisms of the defense. Yeah. But again, that doesn't give you everything. It does give you an argument for reasonable doubt. The core question, from what I understand the case, and I'm not following it like you guys are, but is whether or not he acted reasonably in using deadly force in defense of a perceived threat.
Right.
So that's really where now if the jury is making that call, that's a very close call, I would say, in this case, and it could go either way. So regardless of all the surrounding, killing the cop on the stand, regardless of that, that's really where the rubber hits the road in this case, in what I'm seeing.
Yeah, and the key is really going to be when Curtis Reeves, when the defendant takes the witness stand, as they said he would. And of course, I mean, they've actually had this trial really already, because they had a 2-week-long self-defense immunity hearing back in 2017. So presumably his testimony is going to be basically a replication of what he said in the immunity hearing, or he'll be subject to a hell of an impeachment.
Right.
But it's going to come down to whether or not you believe that guy, that he's telling the truth when he says he had that reasonable perception of an imminent threat of grave bodily harm from this large dude rearing over the seat, cursing at him, apparently striking him in the head, throwing something, hands coming in what looked like a sustained attack. It turned out to be grabbing the popcorn and throwing it back. But Curtis Reeves says he doesn't know what happened to the popcorn. All he knew was he was in a physical confrontation when he pulled that gun and fired that shot.
Right.
If you don't believe him, well, then it's got to be guilty.
Right. No, his testimony is going to be very important, just like the Rittenhouse case, which is the testimony was excellent. And I think you're going to see the same thing out of this defendant, I would expect. And I always like to put my defendants on the stand, because the jurors do want to hear from him. And what matters is that he was reasonable in his perception and his reaction. And that's where you're going to have, jury selection is so important in these things, because what people's view of using firearms is such an important factor on how they perceive this interaction. Because
you see a lot of that just in the chat here. A lot of people saying, who would bring a gun to a movie theater? And I'm like, well, me. I carry a gun all the time, but if someone has that inherent bias coming into the calculation, then he looks aberrant merely for having exercised that privilege of being armed.
Right. And I really think that people come in with that perception. That's going to be the critical deciding factor in the case. And I think and I didn't watch the jury selections. I hate jury selections. That's one of my weaknesses, I must say, as a trial attorney. I usually get second share to pick the juries because I'm not good at picking juries, but so I know where my weakness is and I let them do it. But how was that going? And because I would really focus on my jury selection.
I didn't see the whole thing. I tried to watch from the beginning. Nick and I tried to watch from the first day, but it didn't appear to be streamed online. Later in the week, suddenly I discovered now they were streaming it. I don't know if I just missed it from the first day, but I only saw the last, I would say, day and a half.
No, the first day was not streamed, and then I think it picked up either on the second or third day at random. But the first day was largely the first day was largely useless because they the first
Stephen
50 jurors all came in and said he's guilty as hell. So it didn't work out for him.
Well, there was a question in the chat I wanted to address too about tag teaming on the objections, because I've dealt with that in court in the 7th, because I second chair, and often I'm bringing is the disciplinarian to do specific to object on certain issues and to preserve records. And that's very much a local courtroom rule imposed by the judges. Now, I think it does impact on the right of self-defense or right of defending yourself as far as picking the attorney of your choice. And I think as long as you delineate the roles of the attorneys, you can get past that. But it's really judge specific, and the appellate courts aren't going to disturb whatever the judge comes up with as far as their rules. But this judge seems to be lax on that point.
Proceed. Okay, Tina.
All right, Tina. You can bring it back in.
This judge seems pretty sharp. How's the judge been doing in this case? She looks pretty sharp.
Oh, that hasn't been my impression.
Well, on the objections, she seems like she's ruling.
It's hard to tell because sometimes they do a lot of sidebars and then they come back without a ruling that's audible to the court. So you have to kind of infer the rulings based on the follow-up questions a lot of times.
And there's been a lot of instances where everyone in the courtroom seems to be there's a lack of clarity of thought and argument and following of facts, and people get confused and they're using terms to mean different things. And
a lot of that's on sidebar though, right?
Mr. Escobar, go ahead.
Yeah.
Thank you, Your Honor.
I want
Mr.
my internet is
Proctor, you're still
bad.
under
I don't suppose you
Thank you,
can
ma'am.
share the stream, Andrew, or
Detective,
what? It's coming back.
I'll keep calling you detective, I'm sorry. Mr. Proctor.
That's fine, sir.
Before going back into that theater, or before going into the theater for the first time, anybody give you the name of Joanna Turner?
Not by name, sir.
Well, what did they give you if they didn't give it to you by name?
After the meeting, or after the, I went into the theater, there was a meeting of,
We're not there yet. I'm saying
Okay.
before you went into the theater
yes, sir.
at 5:32 in the afternoon,
Yes, sir.
did the name Joanna Turner, was that given to you?
No, sir.
Despite the fact that you had the meeting with supposedly all of the brass and discussing all of the interviews and all of the voluntary forms and all of that.
So if you need it, Nick, I've got the stream set up
Yes.
to share.
And
Okay,
certainly
for now, I'm
nobody
good.
Gave you a voluntary form there at that meeting with the brass that had the name Joanna Turner for you to read.
No, sir.
In fact, you didn't read a single voluntary statement that had been given by any witness prior to going into the theater at 5:32.
The Hamiltons.
Well, that was because you interviewed them, right?
Right.
No, I'm talking about from the brass at the meeting.
No, sir. I didn't read any written statements.
Okay. So now you go into the theater, and even though it was 2013, we are at an age where surveillance cameras are pretty common, right?
Yes, sir.
It didn't have to be 2022 for that to happen, right?
That's correct, sir.
In 2013, surveillance cameras were pretty popular.
Wasn't it 2014, Mr.
Excuse me,
Escobar?
2014.
Yes, sir.
Am I correct?
They were popular. Yes, sir.
They'd been popular for quite some time.
Sir?
They'd been popular for quite some time.
Yes, sir.
And so when you went into that theater, you immediately realized that there were cameras in that theater, correct?
Yes, sir.
And so as you walked into the general theater, you looked up, there was one to your right, and there was another one to your left, right?
And theater 10?
Yeah.
Yes, sir.
Okay. And so when you looked up and saw those cameras, you realized with all the years of law enforcement experience that you had, that video surveillance is important, right?
Yes, sir.
And when you see cameras, you're going to go and watch that film as quickly as you can,
Yes, sir.
because you don't want that film to be destroyed, right?
That's correct.
And that film can have incredible opportunities in your investigation.
I'm waiting
correct?
for what the gotcha
Yes, sir.
is on this one.
Right. He's
So
same
you
here.
didn't do that.
What's the
You
setup?
didn't do that.
You didn't
You
go
didn't
to
do something.
management at the cop theater and say, Mr. Manager,
No, the
Why
video
would
got
people
sent to
wanna see
corporate. Then they had to
whatever is-
in South Carolina or something, and then they had to send people out there to get it.
That's right. I did not.
and you would agree with me that you later found out that you didn't even have to go to the IT room upstairs in order to view that video, correct? You could have done it from the manager's desk.
I wasn't aware of that, sir.
You weren't.
No, sir.
It's because you never asked anybody, right?
No, sir. I'm not computer savvy. I'm definitely not video savvy. We had those people with the sheriff's office there.
Cybercrime.
Thank you, sir. We had cyber crimes there to obtain all of that.
So if you're not computer savvy and you've got the battalion of cybercrime there, you had Busson, correct?
Yes, sir.
You had Lindsay, correct?
Yes, sir.
You had Pepinella, correct?
Yes, sir. I'm not for sure who I was there the day of.
Those guys are really good, aren't they?
They are.
They're highly trained, correct?
They are.
They're highly trained to preserve evidence, correct?
They are.
In fact, that's why they were there. Correct?
To obtain the video, yes, sir.
Well, not only to obtain it correctly,
That's correct.
and to make sure that nobody, even the cop theater, could destroy it, correct?
That would be correct, sir.
Because when you're doing an investigation, you can't trust anybody else. You've got to put that trust only in the people that are employed by the Pasco Sheriff's Office, correct?
Oh, this is Pasco. Okay.
We'd like to have it that way, yes, sir.
You got to put the
And that's
Nick.
why
Can you
they
put
were
those pixelated sunglasses over this witness?
Yes,
Yeah.
sir.
And so did you go to Detective Busson and say, Detective Busson, I see that we've got some video here. I need you to go and I need you to preserve that evidence, period.
That's first thing, right?
They told me that it was being preserved.
That's not my question.
Yes, sir.
Did you go to Detective Busson, who is an expert in cybercrime, and say, Detective Busson, you're here for this purpose. I want you to go and preserve that video evidence.
No, sir, I did not tell him that.
That's first thing.
Well, why not?
He knows his job.
He knows his job.
That's what he does.
But he didn't.
Well, unless
Unless he
Detective
doesn't.
Smith tells him, I don't want you to do it. I'm going to handle it myself. Right?
Judge, I'm going to object. Calls for speculation on the part of this witness.
Sustained.
You would agree that Detective Smith was the crime scene detective, right?
See how smooth he just goes right past that objection? Right? Doesn't let him bother him at all.
That things
Excellent.
were going to be properly preserved because he is the crime scene detective.
That's correct, sir.
And in 2013,
14.
but in 2013, the year before, when he was in missing persons, you didn't know anything about Detective Smith as far as his capabilities in cybercrime. He wasn't in cybercrime. Right?
He might as well have been a missing person.
I knew that he knew how to obtain video. He had assisted me before in robberies where he had obtained the video for me in other cases.
I mean, this is going to be a never-ending chain of incompetence.
He had in order to be able to do that?
Nobody did their job.
Yep.
No, sir. I knew that I didn't know I didn't know all this training, but I knew that he was very capable of obtaining the video.
But you
Not
would
quite.
agree that obtaining the video doesn't mean that you tell the cop theater, hey, listen, do whatever you all want to do with the video and then give me a copy later on. That's not what you expected.
And I don't think that's what occurred.
My
What
question
did
is,
occur?
that's not what you expected, right?
No, sir.
Okay, so you pretty much didn't have even a conversation with Smith about the video because you assumed that he was going to do something.
I remember the conversation occurring that the cop theater was not able to produce the video the day of the incident.
Oh, wait a minute. The cop theater was not able to produce the video, but you had cybercrime there that could extract the hard drives in the proper way and preserve the video, right? You agree with that?
There again, sir, that's above my my knowledge. I don't.
Well, you could have spoken to Busson and say, hey, Busson, I guess someone in the cop theater is saying that they're not going to turn over the videos. What can we do here? Did you have that conversation with Busson?
I did not.
This is the lead detective, right?
You knew
Yep.
at that moment that the cop theater had a
Very
liability
shoddy.
interest of its own, right?
That would be a possibility, yes, sir.
And you certainly didn't want the cop theater to be doing anything with that video, did you?
No, sir, I did not.
Wow.
Did you know that at the very moment that you had walked in to that theater tent, that the cop theater was remotely looking at the video? Did you know that?
No, sir, I did not.
So the cop theater can look at the video remotely. You're there. You can't look at the video.
It was my understanding, sir, that we could not view the video that day.
That's
Or
so
was
that's
it
so
your
weird.
understanding that Detective Smith told Busson, hey, get out of here. I'm handling this?
Judge, I'm going to object. It calls for speculation.
No, there's no speculation about that.
Sustained. There is.
Judge Busson is going to be testifying for me.
Okay.
So
For me.
Okay,
For
so
me. Ooh.
what else do you do in that in that crime scene.
Yeah, that
Other
guy,
than
he
talk
retired.
to
He sucked. Glad he's
Detective
gone.
Smith for a few minutes and leave.
I also, Detective Smith gave me a rundown as to where the evidence that they had collected, the evidence they were in the process of collecting, where the victim and his wife and the suspect and his wife were sitting.
Okay, did he give you the measurements?
No, sir.
Did he give you the measurements of the seats?
No, sir.
You knew that the seats had arms, correct?
Sir?
You knew the seats had arms, right?
Yes, sir.
And did those arms move up and down?
I'm not aware, sir.
And so you left the Cobb Theater without obtaining that video, those hard drives that day, right?
That's correct, sir.
And in fact, you had posted, had you not, officers there at the Cobb Theater to not allow anybody to come in to the Cobb Theater, right?
Theater 10, yes, sir.
And you became aware that the Cobb Theater sent an IT person from Mulberry to seize the actual hard drives that very night, correct?
I wasn't aware of that, sir.
You're not aware of that today?
I wasn't aware of that.
This is the first time you heard of it.
I was not.
Council's testifying. That's on that.
What?
This is what I'm asking if this is the first time he's heard that.
Where's the batch coming?
Oh, it's Mr. Sills.
I'm gonna overrule.
The first time that you have heard that a Mr. Sillis, an IT person from Mulberry, came over that night, penetrated security there at the Cobb Theater and seized the videos is today?
That's correct, sir.
Wow.
So I guess Detective Smith never shared that with you.
I wasn't aware of it, sir. He could have, but I don't remember that conversation occurring.
Well, if that had occurred, you'd be disappointed.
I wasn't aware of it, sir.
Were you disappointed now that you heard that today?
I'm disappointed that I didn't know it before. I'm sitting here in front of a jury.
Disappointed
That's honest.
Honest answer.
a multitude of hard drives right under your nose.
I'm disappointed that I didn't know that.
Gosh.
Brutal.
This is painful to watch.
Yes, sir.
You didn't know that the hard drives from the Cobb Theater, especially all the hard drives dealing with Theater 10 and lobby and what have you, you didn't know that those hard drives had been seized and flown to Alabama?
No, sir.
Like it's another country.
It is-
Estonia.
Alabama.
And retrieved those hard drives?
I did.
Well, where did you think those hard drives had come from? Thin air?
No, sir.
I would rephrase you.
I object. He's being a dick, Your Honor.
I was not aware that the hard drives were in Wesley Chapel.
You didn't believe that the hard drives that you were getting from Alabama were the ones that were taken from the Wesley Chapel Cobb Theater?
Gosh.
Yes, sir. I thought the ones from Alabama are the ones from Wesley Chapel. I understand that now, but at the time, I thought that the hard drives were being remotely, that the feed was remotely to that location.
So are you telling me that when you went to Alabama, you thought that the hard drives that you were picking up were not the actual hard drives? You thought that there were some kind of
A copy?
copies that were done for you at the pleasure of the Cobb Theater?
No, sir. That's what I'm saying. I'm not video savvy. I don't understand all that working. And I did not realize that the hard drives, I didn't realize that they were even in Wesley Chapel.
You didn't realize that the hard drives were in Wesley Chapel because you never went into the IT room to take a look at the surveillance equipment, correct?
That's correct.
You didn't know the make and model of the system, correct?
No, sir, but I had people there that did.
You didn't know the make and model of each hard drive?
No, sir.
But didn't he say he asked the other guy, right? He said he had experts there with him.
Correct?
Yeah.
That's correct.
He didn't know.
And he's
if
the
he
lead
had
detective.
multiple hard drives that were supplied by any particular camera.
That's correct.
You didn't know anything about that system.
Absolutely correct.
And so at some point in time, much days later, right? You and Smith decide, I think we better go to Alabama.
Your Honor, we briefly approach?
Yes.
He's killing him on the stand, Your Honor. This is really, really devastating for us. This makes our guy look really bad. Can we
Well,
approach?
It is really bad, but you know, at what point he's made that point, he's nailed it down. I mean,
Yeah.
I'm a big fan of moving things along. I don't want to bore the jury. You've made your point that this guy doesn't know what he's doing on the video. You gotta kind of keep that ball moving forward, right? I mean, it's a tactical thing. I know for different trial attorneys have different techniques, but I like keeping it snappy.
Yeah. Yeah, I think he's getting to the end of this thing. But you know, when we thought they were going to be done when they went to break, because we had no idea that this fact was coming, and this is juicy. This is
Right.
juicier than the other stuff.
Well, I mean, how many road deputies? I mean, we have misdemeanors with road deputies, and the first thing they do is say, "Oh, camera, get the camera," right?
Yep.
Or they'll take it on their little badge cam. They'll take a video of the thing. For a lead detective not to be aware of the video,
You went all the way to Alabama days later, right?
That's correct.
And you went with Detective Smith.
A nice little day trip to
To
Alabama.
go and retrieve those particular hard drives that had been in the cop theater on the very moment of this incident.
That's correct, sir.
And you didn't go to just cop theater management. You had to go to a lawyer's office for the cop theater to go and retrieve those hard drives.
That's correct, sir.
The
And when
theater's
you got
lawyer has
the
them.
box or the luggage that the hard drives were in, it had a lock on it, right?
That's correct.
And so there at the lawyer's office, you didn't say, hey, lawyer, open this box so that we can see what's in it and we can inventory it and we can take photos before I am taking it back. Right? You didn't do any of that.
No, sir.
You left the box locked, not knowing what was in the box.
That's correct, sir.
And certainly you had done nothing prior to going to Alabama to go and check and see what system they had there at the cop theater so that you could correlate as to whether, okay, this hard drive goes here, this hard drive goes here, and this. You didn't do any of that.
No, sir.
And so now you're getting this box with, you don't even know how many hard drives are in there, right?
I don't, sir.
And so you get this box that was locked and you take it with you and you got to come all, did you fly or you drove?
We drove.
You drove. You drove all the way back to Pasco County. And certainly when you got to Pasco County and you got to the evidence room, certainly you opened that box and said, okay, let's inventory it before it goes into evidence.
No, we did not.
That's the proper protocol, right?
No, sir.
Oh, it's not. So you can just get a box that has nothing that you know of. I mean, it could have had 3 kilos of cocaine and you would have known it, right?
I'm sorry, do that again.
That box
Right.
that's
that box
argumentative.
could have had anything in it and you would have never known it.
I was told that the box contained,
Well, I
The hard
realize
drives.
you were told that by
yes, sir.
some lawyer that was representing the interests of cop theater, right?
Yes, sir.
But my question is that you did not know before you entered that box into evidence what was in that box. For all you know, it could have been anything. Right?
Yes, sir. I was told that it was the hard drives.
Okay. And so now
We
you
were
put
told.
that,
Still don't know if that's all the hard
In
drives.
evidence,
In
right?
all honesty,
Yes, sir.
they have no idea.
Yeah, this is just poor evidence
and
preservation.
the person that you call on in order to image, to copy those hard drives is the person that was at the cop theater the night of January the 13th of 2014, Mr. Busson, right?
I don't know who copies those, sir.
Do you know that he was the one that copied those for you?
He's part of that team.
He's saying
So
Cobb,
it's
Cobb,
stated evidence.
C-O-B-B Theater, Cobb Theater.
Tell me, stayed in evidence for a week without knowing what was in there?
Sir, I don't know.
How about a month?
Oh God, he doesn't even know how long it was.
I don't know, sir.
How about 3 months?
Oof.
Let the witness answer, please.
My apologies.
Sir, I'm not aware how long the box remained in evidence.
Lead
cyber
investigator.
crimes. The state attorney's office, they were handling all of that aspect of it. We had CDs of the incident, the shooting. And,
What are the odds this guy gets arrested for DWI tonight?
And those CDs that you had were given to you days after the incident
a couple of days later, that's correct.
from somebody there with Cobb Theater, right?
Detective Smith obtained those.
Do you know how? Do you know if he got it from a competent source, like a IT person, a computer engineer, a cybercrime expert?
A guy in a street corner.
They're actually the bootlegs of the video
And
they're
so
selling outside
then
the
at some
theater.
point in time, those that bought, were you responsible for also taking
It's
that
the porn
box out?
version of the movie they were going to watch, Bone Survivor.
That was Detective Smith.
That's right. I went to Alabama to get it, and I brought it back with Detective Smith. We put it into evidence, and that was it. I simply accompanied him there for the long drive.
Detective, you would agree that you were not happy having to go to Alabama to get a vital piece of evidence that should have been preserved right here.
If it was Hawaii, you'd be happy.
I
I didn't mind going to Alabama. It's fine.
Yeah, that's kind of nice.
that again, sir. I'm sorry.
Yes, I'll tell you again.
He just wants to get off that stand so bad.
Alabama to pick up a vital piece
Andrew, your audio's
of
off.
evidence in this case. When it
You're
should
muted.
I'm just waiting to see that witness's whole seat just slowly sink below the camera. You sunk my battleship.
Or again, sir, I'm not aware of how cyber crimes, how to obtain that. We were that's the way it occurred. I didn't know that the DVRs were even in Wesley Chapel. There again, cyber crimes is the one that handles that. My happiness, I wanted to obtain the video.
Let me ask you this question.
My happiness has no bearing on the trip to Alabama.
Well, let me ask you a question. You certainly.
It's because they had a couple
you
drinks. They had
certainly
some
interviewed
meals,
John
all paid
Sills,
for by the
who
Pasco
was
County
the IT
Sheriff's
person
Office.
That came in the middle of the night and took the hard drive. You did that, right?
I did not.
Or did you direct someone to do that? Did you direct some of your detectives? Hey, this John Sillis, we need to talk to him. Did you direct anybody to do that?
Sir, as I've testified to earlier, I did not know that the video had been removed. The hard drives.
I have no further questions.
Thank you.
Andrew, your audio's off again.
May I have a moment, please,
You
Judge?
may. Put your pen, Mr. Escobar.
Oh, thank you, Your Honor.
Do you
My
try to
pen, but I'm leaving
rehabilitate?
it for the detective so he can take an accurate note at some point in his life.
Pasco County Sheriff's going to come in and charge Escobar with attempted murder.
How do you rehabilitate this guy?
I don't know. Did you retire because you're bad at your job?
Isn't it true that? Never mind. Forget it.
He's happy that's over.
Thank you, Detective.
Yes, sir.
Now look how he's looking forward. That's fascinating.
And Your Honor, exhibit.
Yep. Jackson
have to go
Kai
home
says,
and-
shouldn't they be separating the people in that courtroom since they were all just witnesses to a murder?
If I were him, when he goes home tonight, he should definitely take a pregnancy test.
Oh. Yeah, I'm trying to think as a prosecutor how I'd try to rehabilitate him.
Well, at first you appoint a guardian ad litem. I need someone to represent this guy's interests. He's not capable anymore. Yeah, they're trying to figure it out too.
May it please the court, counsel. Mr. Proctor, do you have a copy of Alan Hamilton's statement?
I do not, sir.
Okay.
Counsel does.
I-
I've got it. Sure. Defense exhibit, I think. It's in your back. Defense exhibit.
For the record, it's defense exhibit number 21. May I approach the witness?
You may.
Detective Proctor, I'm going to ask that you look at that statement, not only look at it, but I'm going to ask you to read it to yourself and see if anywhere in that written statement, Mr. Hamilton stated that it was dark in the theater. And the second thing I'm going to ask you to do is see if he ever uses the word silhouette in his written statement.
From me.
Commenters are great on your site too, by the way.
Tortheo asked, doesn't that breach the stipulation because they stipulated to the videos? Real quickly, no, they stipulated that the videos are what they purport to be, footage of the incident from that night. But remember that the defense's position is that those videos are actually evidence of self-defense that should have been observed and considered before an arrest or charges were even brought, and that those would weigh against probable cause. That's why they're stipulating to them. The prosecution believes that they're evidence of not self-defense, but evidence of a murder. But they're each going to be making those arguments. So it doesn't breach the stipulation.
Sorry, but there's no mention of silhouette here?
Is there any mention of dark?
No, sir.
And the objective of the cross is to show that the arrest itself was flawed,
For the record,
and to undermine that credibility, to get that out of the jury's head.
Yes, ma'am. Now, Mr. Proctor, let's talk about notes.
Please,
You
no.
indicated on cross-examination, based on questions from Mr. Escobar, that you take notes when you interviewed Mr. Hamilton and Mrs. Hamilton.
That's correct, sir.
And once you have memorialized your police report, you destroy those notes.
I'm going to object.
I do.
Sustained. That was.
Right. You took notes, right?
Yes, sir.
Did you write a police report in this case
Yes, sir, I did.
in reference to your interview with Mr. Hamilton and Mrs. Hamilton?
That's correct.
Did you document in that report what they had told you?
Yes, sir, I did.
Did your notes comport with the report?
Yes, sir, they did.
After the report was written, did you then destroy the notes?
Yes, sir, I did.
Was there anything different in the notes as compared to the report?
Yes, sir, there was.
All right. Now, on cross-examination, Mr. Escobar went to great lengths asking you, well, did you ask Mr. Reeves about his disabilities? Did you go into this? Did you go into that? Remember that?
Yes, sir, I did.
On the second interview, did you ask Mr. Reeves, is there anything else you want to tell me?
Yes, sir, I did.
Oh, well, then he asked him about everything
Now,
in the history
let's
of
talk about on
man.
cross-examination.
Perfect.
Mr. Escobar asked you, Mr. Proctor, did you go into the theater and did you ask him to put the manager to put the lights on and the previews on and so on and so forth, right?
Yes, sir.
Now, as you're sitting here today, Mr. Proctor, is there any way that you could have gone back in time and done everything in that theater exactly the way it occurred on January 13, 2014? And by that, I mean, have the defendant sitting in the same seat.
Man, he looks like he got the last suit from
Obviously,
Kmart.
all the other witnesses that were in that theater, right?
Yes, sir.
With the previews playing at the volume with the correct lighting at that time.
That's
No.
also speculation as to whether you could have done it or not. I mean, we'd have to bring the witnesses in.
Judge?
Oliver.
Oof.
Right?
There's no way you can recreate it.
Okay. Mr. Escobar went into great lengths about you going in there and you sitting and seeing this, right?
Yes, sir.
Leading.
Does it matter what you saw or you heard?
And
If it's you,
yes, sir.
it doesn't matter, right?
No.
Leading.
Judge, I'm going to move to strike.
Would you please testify to these words?
Sustained.
He did object and moved to strike.
Rephrase.
Mr. Proctor, what's important is what the defendant saw through his own eyes.
That's correct.
What he saw, what he heard, not you.
That's correct, sir.
You have a moment, Judge?
You may.
A little bit deceptive.
I don't have any further questions. Mr. Proctor,
Yes.
It's a little bit deceptive because what he would perceive from that seat actually does matter to the investigation. Like, well, you can't see what he saw. You can never see what someone saw, but we try any investigators trying to get an idea of what they might have seen. They try and replicate the scenario. They try to get an idea of if their story even makes sense or is plausible.
Right. And here in self-defense, of course, a key issue is not just, it's a matter of, even if Curtis Reeves had a genuine good faith belief in the need to act in self-defense, was that belief objectively reasonable? And you can only know that from circumstantial evidence, right? From observing what the circumstances were like.
Yeah, the objective reasonability is, would a reasonable person similarly situated, which is kind of how it would be if you're recreating the scene, a reasonable person similarly situated feel the same reasonable apprehension of imminent death or bodily injury.
How dark or light the theater is, how loud it was, how proximate the seats were. That's all relevant information to a reasonable perception of a threat.
Right. They should put a rod in the dead guy so that he stands up and he's propped up over the seats too, so they can replicate the threatening
Come up at
posture.
poles on his hands.
Yeah.
Comes with a bag of popcorn.
I'm talking to my fucking daughter.
But how much do police really perceive or understand their duty to exclude self-defense in these type cases? Oftentimes they just want to get, oh, we got this guy, shot him, send it on to the prosecutor's
Stand
office.
by.
Right. That's right.
All right, Mr. Proctor, you're free to go, but if you do get called back, you have to. If you do get called back, you have to come back.
Yes, ma'am.
Do you need a paramedic, sir?
Out of this area, can you give me a day's notice?
You will, Your Honor.
All right,
Thank you.
you'll get a day's notice.
Thank you, Your Honor. It's good seeing you.
You too.
I'll also send you a first aid kit with some burn cream.
Good
Yes.
seeing you.
I don't want it. Thank you.
Stay.
The state would call Mark Turner.
Gentlemen, I'm going to step away for just a minute, go to the bathroom, be right back.
All right.
Do you solemnly swear or affirm the testimony you shall give in this call to be the truth, the whole truth, and nothing but the truth, self-defense?
I do.
Go ahead, Mr. Rosenhauser.
Thank you. Good morning, sir.
Good morning.
Can you please state your name and spell your first and last name for the court reporter?
Mark Turner, Markturner.
And you don't have to tell us exactly where you live, but what city do you currently live in?
Brandon,
All right. And back January 13th of 2014, what city were you living in?
Wesley Chapel.
Are you currently employed?
I'm retired.
All right. What did you do before you were retired?
26 years in the Air Force and 10 years in the aviation industry.
Okay. And just very, very briefly, we don't need an entire history, but very briefly, what did you do in the Air Force?
I began as an enlisted man and then went to officer training school,
Good for
aviation
you.
school, and spent most of my time in the intelligence arena.
Back on January 13th of 2014, did you go to the Cobb Theater to see the movie Lone Survivor?
I did.
And who'd you go there with?
My wife.
All right. Is there a particular part of the theater that you sit in when you go to the movie theater?
I usually try to find an aisle seat up high.
And were you able to do it on that particular day?
Yes, sir.
When you went into the Cobb Theater, so you walk up a ramp to get in there, is that correct?
That's correct. Yes.
All right, then you have to turn around to your left or right, depending on what side of the theater you're on. And
Yes.
you look back at the seats, correct?
Yes, sir.
All right. When you walked in, do you recall whether or not the previews were playing at that time?
They were
Do you recall what the lighting conditions were like?
dimmed, but you could see your way through pretty clearly.
All right. And we're obviously going to be talking about a shooting.
So the pattern through much of the trial, especially with these theater eyewitnesses, is they testify and direct in a way that's fine for the prosecution,
All right.
and then they get torn
let's
apart
tell
on
the
cross.
jury about that. Was it dark like when the actual movie?
In a way that the state
No.
should have seen coming.
there's
It's almost like the
lights
state
on.
seems surprised
Right.
sometimes
Not
that their
full house
witnesses are
lights,
being
but
subject to
I guess they're doing it
cross-examination.
again.
Yes.
Yeah, usually on direct as a prosecutor, you want to bring out any
Can you
weaknesses
see
in your
the
direct.
rows?
Yes.
Can you clearly see them?
Yes.
Can you see people sitting in the rows?
Yes.
How about the aisles? Clear enough to see the aisles?
Yes.
Clear enough to see the steps?
This is another theater eyewitness.
Do you have any
Nick.
concern for your safety? And I don't mean like in a
Okay.
super dangerous way, but walking up to go find seats.
No.
All right. Did you need a flashlight from your phone or anything like that?
No, sir.
Could you see 5-10 seats away from you?
You could.
All right. So you make your way up to where? Is it the back row?
Back row. I sat in the first seat on the aisle. My wife sat inward.
Okay.
When this
So if we
prosecutor
were-
goes to the
if we're-
theater, they
if the
ID him
screen's
for rated
behind
R
me,
movies
you're
still.
facing the theater. Were you on the left side of the theater or the right side of the theater?
On the right side.
Okay. Well, that'd be facing the screen. You're on the right side.
That's correct.
All right. So if you're sitting, you're all the way to the right of the theater in the back row.
That's correct.
All right.
In his car, the child boosters in the driver's seat.
Now, when you sat down, you indicated the lighting conditions were the same as you described it.
Yes.
All right. You could recall what the volume was like?
It was elevated, but you could still converse.
Okay. And when you say elevated, that's coming from whatever's coming from the movie theater screen.
Right.
All right. And did you have any difficulty hearing your wife, the person you came with?
Not,
So one of the things we've seen consistently is that on direct, they'll say what the state wants. They'll say, well, it was reasonably well lit and it wasn't too loud.
Could
And
you
then on
hear,
cross,
you know,
they
the
gave a
chattering
deposition
people?
earlier where they said it was dark and very
Did you
loud.
specifically hear what people were saying, or maybe the better way is, were you listening to other people's conversations?
no.
All right.
I like
So
to
you
listen.
couldn't hear the conversation because you weren't paying attention to it,
Correct.
but you could hear that people were talking.
Yes.
I'm going to object. It's like 10
Last-
leading questions.
I understand.
Last two.
Last
Sustained.
two.
Based on the level of the volume in the theater, did you have any difficulty hearing anyone else?
Last trial.
No.
A lot of times you let them lead if it's something that's not important.
About, the shooting
Yeah, just
incident.
laying foundation,
First
stuff
of all,
like that.
did you know any of the people involved in the shooting?
I did not.
Did you later learn the name of the person that did the shooting?
Yes.
And what was that person's name?
Curtis Reeves.
All right. Did you later learn the name of the person that was shot?
I did.
And what was his name?
Chad Olson.
All right. And we're just doing that just so it's easier to describe to the members of the jury who everyone is. When you first sat down in the theater, was the defendant Curtis Reeves there?
He was not.
Right. Did you see him at some point in time?
I caught him just as he was approaching my aisle, coming back from wherever he had been.
All right. Did you have an opportunity to watch him come up?
Briefly, yes.
All right. Is there anything about what you saw of him that led you to believe that he has difficulty walking?
Not that I noticed.
Okay. He didn't have a cane or a wheelchair or anything like
No,
that? Did he go by you?
he did.
All right. And did you watch him as he went down the row?
Only in the sense that I turned in that direction to move my knees out of the way so that he could get by. And of course, he was in my field of vision.
Is
saw
this
him go
the
back to his
lady
seat.
with the strokes husband?
Did you see him
Oh, I don't know.
lean forward or do anything like that when he got to his seat?
His name is
Not really. I saw him
Turner. What was her
take
name?
his seat. I didn't pay much attention at that time. I was just really kind of scanning the room.
Okay. And based on the lighting conditions, did you have any difficulty seeing him?
No.
Yeah, Steve, do you have a Twitter or anything where people can follow you?
All right, at some point in
No.
time after he returned to his seat.
I'm a public defender.
and channels.
Read my articles. I adjusted my
And
volume on
what
my
did you
mic,
see
by
this
the way.
Just Mr. Reeves leaned forward. There was a
Email me your
exchange.
SSRN page and I'll put it in
And
the
when you say
description.
exchange, could you hear exactly what was being said at that point in time during that exchange?
I could not.
You just know there was an exchange.
Right.
Is that correct?
Yes, that's correct.
At this point, did you notice whether or not Chad Olson was standing or sitting?
He was standing.
The woman with the strokes, her name was Jane Roy.
Okay.
While Chad Olson was
This guy's
standing,
name
did
is
you hear him
Mark
say
Turner.
anything?
I did, yes.
And what'd you hear him say?
He said, do you mind? I got a message or a text from my babysitter. I'm checking on my daughter.
Could you hear the defendant say anything in response to that?
I could not.
After that response from Chad Olson, what was the next thing you saw happen?
Well, something, I guess something was said. I saw a reaction from Chad Olson where he reached across and grabbed popcorn from Mr. Reeves and flipped it back in his face.
Okay. And
Flicked it back in his face.
when
The
you saw
exact
that
same
happen,
wording of the other witness.
Do you know where? Let me ask you this: do you know if anyone was with Chad Olson at the time?
His wife, he was with his wife.
Okay. When Mr. Olson reached over and grabbed the popcorn,
Yes.
did you see what his wife was doing?
I did not, before the incident, all that I had seen was her hand go up to his chest as if to coax him to sit down.
Okay. And do you recall if she was standing, sitting?
My recollection is that she was sitting.
And do you know how it was that she positioned her hand? Do you recall which way it was facing?
It was her left hand and on his left side of his chest.
Okay. And do you recall, let's say that if she was wearing a wedding ring, was the wedding ring facing Mr. Olson or facing Mr. Reeves?
It would have been Mr. Reeves.
Okay. So her hand, I'm just using myself as a demonstrative aid, would be just this way facing.
Yes.
Kind of like holding someone
Now,
back.
prior, let me skip ahead just for a moment. After you saw Mr. Olson, you said, how did he throw the popcorn?
He reached across, grabbed the popcorn, and just kind of brought it back and then flipped it, kind of with the flip.
So
of
he
the
went like
wrist back into
this?
the face.
So,
Kind of consistent with a repeated motion
Well,
at someone.
striking.
I saw Mr. Reeves' arm come up from his side, extend. I saw a muzzle flash and heard the gunshot, and Mr. Olson was shot.
Was that fairly quickly after the popcorn toss?
Very, very quickly.
At any point in time, in this entire time that you're watching, do you ever see Mr. Olson climbing over his row into the defendant's row?
No, sir.
Okay. And are you sitting in the defendant's row?
I'm in the defendant's row, that's correct.
Okay, and where is Mr. Olson in relation to the defendant?
One row below.
Okay, and at any time did you see Mr. Olson climbing into the defendant's room?
No, sir.
At any point in time, did you see, other than the popcorn flip, Mr. Olson throw anything at the defendant?
I did not.
At any time, did you see Mr. Olson punch the defendant?
No, sir.
At any time, did you see Mr. Olson in a position where he's leaning over the chair as if to punch the defendant?
No, sir.
At any time, did you hear the defendant exclaiming or yelling anything that would give you the impression he was being attacked?
I did not.
Did you get the impression from anything that the defendant was doing physically or saying that gave you the impression that he was in a life or death struggle?
No, sir.
So you're telling this jury the only thing you saw was Mr. Olson flip popcorn?
Yes, that's correct.
R. Vanwick over on Odyssey says, thank you for the channel. I really enjoyed watching a functioning justice
At any
system.
time, did you see the
Since I'm in
defendant
South
grab his head
Africa,
as
and the
if he
saying
was
here is,
injured or
why
hurt?
hire a lawyer
No,
when you
sir, I
can
didn't.
buy a
And that would
judge?
be before the popcorn.
Correct. No, I didn't see anything.
And at any time, did you see him act as though he had been injured?
No, sir.
Did you ever hear Mr. Olson threatening the defendant?
I did not.
Did you ever see Mrs. Olson standing in front of Chad Olson trying to hold him back as if this raging guy was trying to get into the defendant's room?
No, sir.
I really thought we were done with these theater witnesses. I hope they're not going to pull everybody in.
I would expect that they would. Why would you not call all
After
your
the
witnesses?
shot, did you hear the defendant say anything?
Because we don't want to watch that much.
Yes.
We gotta
And what was
consider
it
our
you heard the defendant
needs.
say?
Throw popcorn in my face.
After the shooting, did you see what the defendant did with the firearm?
He brought it back and appeared to lay it in his lap.
Did someone come up to him at some point in time and take the firearm from him?
Yes.
After Mr. Olson was shot, did you see what happened to him?
He said, I can't believe this. And he turned toward his row and took a step or step and a half and collapsed.
I'll do a
At
poll
some
at
point in
lunch
time,
break,
did
guys.
you see Mrs. Olson?
Yes.
Okay. And what was she doing when you saw her?
Well, she was hysterical, of course, and had began running up and down the aisle to where I was at. And my wife was behind me. She had been shot in the finger, and we tried to help her with that. We had some napkins and wrapped her finger up. And
Okay, so when you saw Mrs. Olson, you saw her finger.
yes,
And what did it look like?
it looked like it was hanging on by the skin.
So you helped her at that point.
Tried to, yes.
All right. At some point in time, did deputies from the sheriff's office come to the theater?
Yes.
All right. Did you stay in the theater the entire time, meaning from the time of the shooting until the time deputies came into the theater, or did you do something else?
Well, I had, in an effort to help Mrs. Olson, I had asked her if there was someone that I could call, and trying to catch up with her, we wound up down at the exit by the screen and stepped outside, and I asked her if I could call someone to help her if she wanted to check on her children or whatever. And she said yes and gave me her cell phone and told me who to call.
Sly. How long was it before you invited her to
Deputies eventually get
dinner?
the theater?
Yes.
All right. At some point in time, were you given a form sometimes referred to as?
I
a
typed in my
registered-
digits.
Yes. Actually, I had to go find it, but there was a gentleman in the
Because clearly she needed some digit.
to get the form. It was pretty organized.
Ooh.
Mm-hmm.
Cello,
That,
you can't do
No, sir.
All right, so you
That
just-
stuttered on my end too.
yeah, that wasn't on my end.
Yes,
All right. Did you assume at some point you'd be interviewed by someone in law
That
enforcement?
was on
Yes.
the
Were you in
feed.
fact interviewed by someone in law enforcement?
I was.
At any point in time, did you discuss all the details of what you saw with people that were in the theater that you did
Well,
not?
at least with this guy, I know why his tie appears so long.
Right. That's
Everything you're
actually a short
testifying to,
tie.
Is that what you personally heard
That's correct.
and personally what you observed?
Yes, sir.
At any point, did you think that this was just an interactive part of the movie as a sort of new 4D viewing experience?
Yeah, it wasn't. What was it?
What's up?
I was thinking, what's the name of that movie? The Transylvania
You may.
transsexual.
Oh,
Rocky Horror Picture Show.
yeah, Rocky Horror Picture Show. The stream just glitched out for me again.
Yeah,
Yeah.
me too.
Hmm.
Hmm.
Let me see if I can pull it up on one of the other channels here. Oh,
Yep.
it's
Yeah.
catching up.
Yep. Sidebar.
Let's see.
What
Okay,
are we up
well
to
then-
the sidebar counter? 48.
All right, guys, I'm gonna put Steve's SSRN page. It's Social Science Research Network, I think, right? Is what that acronym is. That's where you can find Steve's papers. If you want to give a look
Lunch
at the
now, and we'll take
need
an
something
hour
to put
for
you to
lunch. I'll
sleep.
ask you to be back at about 1:45, and we'll resume at that point. All right? Remember my instructions during the recess.
if you want to do some in-depth legal reading on various topics that Steve has written about, go check him out. You can look at what legal writing looks like. It's a different world than a lot of other stuff, but it's also full of useful information, references, and covers topics that you might find very interesting. If you're watching trials anyway, you might find the legal writing aspect of it very interesting. It's
Right.
a whole different
It's
practice
a different
of law.
world. Most of my writing is practical criminal
We'll
defense
be in
stuff
recess
in
as well
Florida.
For an hour. We'll see you back at 1:45. Oh, yeah, thanks.
Is my
Thank
mic
you.
better? I adjusted my
Oh.
mic. Everybody's complaining it's too low.
And
That's
for
good.
the record,
Your
we
your
do
mic's
have,
fine.
present and has been present
Just
the
making sure.
entire day is Mr. Scott Rosenwasser for the state, Mr. Manning Garcia for the state.
Every day she forgets to put in the
Glenn
record who
Holmes for the
counsel is.
state, Mr. Richard Escobar for defense.
She has to be
Mr.
reminded.
Neil Michaels for defense. Mr. Reeves has been present the entire time, and Mr.
Not
Matt
mentally.
Funderburg and Miss Lopez as well. Flores, I'm sorry.
Hey, wait a second.
All right.
I know that a defense attorney.
I know she's back there somewhere.
Which
Which
one?
one?
And
The
Mr.
fellow
Attorney,
black
you
with
can
the
take a lunch as
brown, and
well.
I
Just
trained him.
Back at about 1:45. Okay.
The young
Thank
guy?
you.
Yeah. Oh,
Thunder.
Funderburg. Matt Funderburg.
Yeah.
Yeah, he's a buddy of mine.
Oh,
Yeah, he used to be with our office. I trained him. He was in appeals. I helped train him. I mean, he's not obviously he had a lot of training, but I worked with him. He was hired by our office. Came out of the appellate division in the Seventh Circuit, fifth DCA. That's Matt Funderburg. Excellent attorney. We lost him to private practice. I know he's over in Tampa, so there he is.
well, we knew he was a good attorney because he argued the hair off of the other counsel and onto his head and face. He just, it's like they had luscious manes before he got there to their office.
How about that? What a connection. Yeah, Matt Funderburg. What a neat guy. I went to his wedding actually.
Matt,
to drop
Matt
him
Thunderberg.
Funderburg. It's Funderburk.
You have to drop him a line and say, "I was watching you."
I was watching. Sorry.
So, Stephen, you had a chuckle about Pasco County a while back. What was that about? You have some insight into the Pasco County Sheriff's Office?
No, just Florida generally. Pasco's a poorer, more rural county. So when you're dealing with police from those areas, they're going to be generally underpaid. I mean, let's just face it. And so somebody who gets promoted into a detective position at those, if they're really good, they're kind of career hoppers, they'll probably go to a larger jurisdiction and make more money. So the detectives and the higher ups are going to be, underpaid career servants who are from the area.
Maybe
And
not
it's
top tier.
maybe not top tier. Now, that's not a blanket condemnation, but I just want you to understand that Pasco is more rural, and this guy's a lead detective from there. It just reminded me of our Putnam County, which you've had dealings with, which is one of the poorest counties in Florida. So that just has an impact on the way that I saw that detective. As I understand, I've seen him, I've dealt with that guy, I know who he is and what he's about.
Got it.
I see. Let me read a couple of these chats that I've been lax on reading here. Justin Wright says my peanut butter horseradish and barbecue sauce sandwich was a dare from my squad mates. That is of the devil. He says found I liked it a lot. Horseradish does not affect me anymore. My second favorite condiment after brown mustard. Had a blast making them sick watching me eat it. Oh, that sounds wrong. Sean McDonald says, so you mean to tell me the lead investigator doesn't know anything about this case, but the defense knows more? How is this guy the lead investigator? Well, he's not anymore.
Yeah. But isn't this kind of typical? I mean, we see this all the time. This is the way that cases get investigated. And it's only rarely does a case get taken to trial, and even more rarely to get publicity. So you see this oftentimes at trial because this is the way most cases are investigated. Now, there are exceptions, and there are excellent investigators. And usually when there's a death or a murder, they're going to see higher tier investigation. But that's why I said Pasco County, and now it makes sense because their lead investigator was this guy. So,
right.
So that's my impression.
Yeah, no, I think you're right. We find out police aren't lawyers, and not that lawyers would make. I mean, lawyers do often make very good investigators, or at least interrogators. But there are aspects of the law, and the police have. The lawyers have like the scholarly approach to things like the Fourth Amendment, search and seizure. They have kind of a scholarly approach to legal standards that are set out. And then police have like a practical field guide, and they're very good at putting that practical field guide into practice. But sometimes when you have just the practical aspect of it, you miss things that could be very important. You miss nuances or special procedures that could make something more complete or more thorough. Andrew was talking earlier about how technically under the law in Florida, they're supposed to do investigations with self-defense in mind when there's some sort of evidence of it prior to making a probable cause determination. But does that get done?
Yeah, one of the things is that that's exactly right. But it's almost an unfair fight because the lawyers have had years, literally, to investigate and to know every detail and master it and focus on this case. With that cop, he's going in there and investigating it and being done with it and moving on to the next case. So
right,
it's an unfair fight, but that's the way it is. I mean, he's doing the best with what he's got, and now the lawyers are second guessing everything he's done, which that's always the way it is.
Yeah, absolutely. But that's and that's I'm trying to think where I was going with that. I think you covered it. But it's this idea that you're right. The lawyers have, in this case especially, they've had 8 years to be looking at this. They've been actively defending this case for a good deal of those 8 years. They've done a trial on this already. This is a mini trial. This is like their second run at all of these witnesses. They've had time to review their notes and refine things. This guy, this was one case that he had at one point while being a detective for, I think he said he was a police officer for something like 30 years. So sure, it seems big to us because we're watching the trial, but it's not that, it might not have been that big to him as it's going on. This is just another thing. And like you said, Steve, most of these things aren't going to trial. they're going to get pled out or not charged, or that's the outcome of most of them, is they're going to be pled out if they are charged. Something like 95% of cases are pled out. It's crazy. And so the cops aren't expecting any
you can
particular case to go to trial.
Yeah, but you can see why this one's going to trial, because the
Yes.
state's not going to drop it. Somebody died. He got shot in a movie theater in a public place in a questionable shooting, right? And the guy's too old. Any sentence that he gets is going to be a life sentence. So they offer him 10 years. It's still a life sentence. So, this one's going to be tried, and the jury's there to make the fact finding and decide.
So that special provision of Florida law that I've been referencing, I just looked it up. It's from the Self-Defense Immunity Statute, and it reads, a law enforcement agency may use standard procedures for investigating the use or threatened use of force, but the agency may not arrest the person for using, not even arrest, right? Not arrest the person for using or threatening force unless it determines there's probable cause that the force that was used or threatened was unlawful. Which many defense attorneys I know in Florida tell me their reading of that is you have to make the self-defense assessment before you can make the arrest.
That's how it reads.
But what's the consequence of them ignoring that?
Nothing, as far as I can tell.
Yeah.
But normally what happens is the cops only do the crime half of the assessment. And if there's probable cause the crime was committed without even considering defenses, the defenses in their mind come down the road. Those are raised effectively, affirmatively later. If there's probable cause for the crime, and if you shot someone in self-defense, there's probable cause for a crime. If you're not also considering the defense, then the arrest is made and the charge is brought.
Yeah, and to be Ivory Lamar's credit in the Theodore Edgecombe trial, I mean, he kept making a big deal about the White Claw in the back seat. But if you're Theodore Edgecombe, you actually do want them to investigate that White Claw. When was that? Maybe not do a DNA test or whatever, but ask a question about it. There's an open container of alcohol in a car where someone with a high BAC was pursuing you and you shot allegedly in self-defense. Of course you want that investigated. But with Theodore Edgecombe, of course, his problem is that he fled the scene. He wasn't there to make a self-defense claim. Whereas Curtis Reeves is there saying, here's all of these factors for self-defense. He's saying all of the things. I felt threatened. I thought this guy was going to kick my ass. I'm old. I can't fight with anybody like that anymore. I've got arthritis all over the place. I'm really scared. He's doing all of the things you need to do to make the self-defense claim, and the police still don't investigate it. And he doesn't have an attorney or a forensic team to act on his behalf. But what's interesting with self-defense is this neat artifact of criminal activity or purported criminal activity is that self-defense is justified. And so when the self-defender is justified in defending, they become the victim of the crime. The crime then was either an assault, a battery, something to that, or maybe an attempted assault or battery. And so the investigation of the crime at that point should be collecting evidence of the other crime of which they are the victim. And so that's why it's important to have this happen. That's why it's codified in the law in Florida. And that's why it should be practiced by these police officers, because you don't get an opportunity on the day of. And listen to how important it is on the day of getting this video, getting this stuff. If these defense attorneys wanted to get that video, how are they going to do it when the police haven't even secured it? Right? Like, how are they going to get
Curtis Reeves was telling them, at least he believed he was acting in self-defense, right? So they knew it was a self-defense type case. There was another shooting in Florida a few years ago, I think right about the time this happened. Michael Dunn was a guy parked in a convenience store parking lot, and an SUV with 4 young black men pulled in next to him playing loud rap music.
Right.
And of course, the stories differ, but Michael Dunn says, hey, I asked them to turn it down politely, and they pointed a shotgun at me, and so I shot at them. He killed one of them, but then he fled the scene. So he did not stay on scene or nearby, which he could have. He lived an hour or so away, but he was staying at a local hotel for a wedding. So he could have just called the police when he got to his local hotel. Instead, he ordered a pizza, walked his dog, and watched a movie on TV. But what he didn't know was witnesses to the shooting had gotten his license plate number. So by the time he got home, the cops knew who and where he was. But when he told his story about self-defense, that they pointed a shotgun at him and there was no shotgun recovered at the scene, he said, well, didn't you look for a shotgun? But of course they didn't look for it because they didn't know. It could have been, they just treated it as a shooting, not as a self-defense shooting, because he had not stayed around.
Well, there's a little Florida connection here. If there's an issue about flight being evidence of guilt, and there's some case law on that in Florida about whether flight can be used as evidence of guilt. I think in the Dunn case, did he testify that he was afraid of being attacked by staying at the location, or what did he just leave?
I don't recall, but it wouldn't have been very credible. I mean, the courts don't really like flight as consciousness of guilt evidence because there's lots of reasons that people flee. But once you achieve a position of safety, well, then flight for safety doesn't apply anymore.
But I'll say Florida courts, they love allowing that. I mean, at least in the Seventh Circuit, I've seen that judges routinely allow the prosecutors to argue that he fled, therefore it's knowledge of guilt. And it's been uphill battles to say that it's equally, the argument is it's equally consistent with guilt or innocence, therefore it should not be used. But the state gets away with it a lot.
Yeah, it's a tough one.
But for sure, to flee and then claim self-defense, that's going to be an uphill row.
Right. Yeah. So I guess the lesson for the civilians, if you're in a self-defense situation, try to stay. And as soon as they question, you say, I want my lawyer and I'm taking the fifth.
Yeah. Well, you either try to stay or you flee to safety, and then you notify law enforcement immediately, and you comply with law enforcement. It's one of the few times where the advice of complying with law enforcement is somewhat better advice than not complying with law enforcement.
I always tell people, listen, don't stay in a dangerous place. If you really believe it's dangerous, get to a position of safety. But once you're in a position of safety, the normal rules apply again. And of course, comply with police doesn't mean be subservient, right? It means comply with their orders. But it doesn't mean you have to, they want to ask you questions. Obviously, you do not want to be answering any detailed questions of any kind.
Right. Coy 540 is going to get banned from the chat for this. He says, you think a new guest can get away without being asked balls or no balls? Steve, what is your answer? Also, thank you for being a guest, but you got to go through the initiation process.
Uh-oh. Well, I don't know what the question is actually. So I'm.
It's probably better that I don't explain it, in all honesty. You can plead the fifth, or you can just take a gamble and roll the dice.
I want my lawyer. I'm going to hire Branca.
Yeah. Well, my advice is to feel free to ignore the chat.
Yep. That's the best advice.
Chatters. I love good chat rooms. I mean, that's
well,
valuable.
Yeah, you qualified.
You said you love good chat rooms. This objection assumes facts, not in evidence.
Well, he gives it $20. He's entitled to an answer, right?
Well, then you've got to answer him. I don't know. It's
well, I'm gonna defer to my attorney over here. I don't know.
The super chat entitles them to the question, not necessarily to an answer.
No, very lawyerly of you, Mr. Branca. Thank you.
Yeah, that's why you have a lawyer.
Look, I'll stand in as your champion and say balls is the answer. It's always the answer. Okay, there are also there's old super chats as well that I should probably start reading. But if any of these spark any conversations, please feel free to interject. Or if anything comes up that you think of, we have this beautiful hour-long break to just converse about literally whatever. But if we don't have a present subject, then I'll read these. Hellsnake says, "Hey, you awake?" I am awake. I was awake today. I didn't want to be. I felt the life flowing out of me with every passing minute, but I was awake. Court Eklund says, "Early and straight as an arrow." United States of Q says, "Good morning. Grab some popcorn and enjoy the show." Not recommended.
Popcorn. Yeah, I get it.
Grab someone else's. Jim Horman says, "I hope that Captain Pest Control lubed up because I suspect It's going to go in harder than Jack Murphy on a college boy. Oh my God. The Dragon's by the way, my chat is degenerate and horrible. So there may be some of those chats. The Dragon's Treasure says, is today's trial brought to you by the Dragon's Treasure? It can be. It can be. Guys, go to thedragonstreasure.com if you like tea, loose leaf, hand picked, hand selected, blended, whatever tea. It's actually very, very good. It's also a haven for tea and anime lovers, if you're like that. Tyler Mueller says, I've been listening for a while and finally saw the bow tie. I don't trust it. Yeah, Steve, what's your expert opinion on bow ties in a courtroom?
You have to be able to pull it off. You know, I think this guy does. I think he pulls it off. I had a really good friend who pulled the bow tie off, but you know, I'm the kind of guy, I bring out the worst in people. You know, that's why I tend to be the trial guy. So I go in there when there's war because I tend to like everything I say people want to disagree with.
Yeah.
And so I just go in there to like throw bombs and destroy. Whereas if you want to negotiate, I'm the wrong guy. So if I wore a bow tie, it would be like a target on my neck. So anything I try to be as anything that's a target, I'll try to stay off. So
Sure.
bow ties, if you can pull it off, I don't think you could pull it off, but I think maybe Branca could.
I will only wear bow ties to an event where the bow tie is provided as a theme.
Yeah, I consider it a high fashion day when Nick's not wearing a wife beater on the stream.
At least I have his shirt on today. Hold on, let me pour
Got
liquor on
sleeves.
myself. The Redneck Ram says, I missed most all of yesterday's stream. Was there anything juicy that happened? Particularly juicy yesterday? No, I don't think so. But just in general, witness after witness in this case, the cross exam has been very, very good. And for me, who I went into this thing thinking that this guy was probably guilty, and now I'm really not there anymore. And it's because witness after witness has been expertly cross-examined, and their cross-examination testimony shows me that they have changed their statements today from what they said at the time, and they've changed them in a way that is prejudicial to the defendant, which tells me that at the time, all of these people had a more deferential view towards the self-defense argument, even if they didn't articulate it that way. But it was dark. Now it's dim. The guy was yelling. Now he was talking at a normal volume, but that's weird for a movie theater. That just doesn't
I'll
measure.
add on that. I have a fascinating friend of mine who's Brian Cutler, who I actually collaborated with on a paper. He's an expert on eyewitness memory and brilliant guy. I don't if you ever get a chance to interview him, he's fascinating. And I've used him as an expert on this. See, what happens is people's memories are not as good as what they think. And what happens is they perceive something and then they put it together as a story. But they don't perceive the entire story end to end. So there's a lot of gaps in between and facts that they don't have. But what happens is over time, your brain does not like having unconnected facts that don't fit a quote narrative. So the brain will actually fill in those gaps to create a story. And then you remember it. And then you're like, no, I remember that. But your brain actually created the memory to fill in the gaps. So that's why that evolving memory is something you see all the time in court. And it's difficult to explain that to a jury. And it's hard to cross with a depo. So that's a human failing that we all have. And most people aren't aware of it because, your balance, your sense of balance, you walk away 99.9% of the time, you never fall. But your memory doesn't have that evolutionary check. And it's evolved to instead give you complete pictures even when you don't have it. So it creates memories. And that's what I think. You're not seeing coaching of witnesses, but you're rather seeing people developing narratives.
Right. And one thing I was talking about yesterday and Andrew was talking about as well is that as these people tell those stories to themselves or to other people, the longer and longer it goes, as they tell that story, they're going to also get subtle feedback from their audiences. And when you tell stories and audiences react positively, those details get embellished a little bit. Or could get embellished a little bit over time. And where you tell stories and those details get negative reactions, those details kind of go to the wayside, and we start telling the story, and it gets bigger and bigger. As Andrew said yesterday, the fish doesn't ever get smaller, the fish that you caught. So, and that's another process, or part of the process. And with this particular trial, where you've got 8 years of it, and it's such a traumatic event that has gotten media attention, for, at sporadic times for that 8 years, there's a lot of retelling of that story that happens, and a lot of gaps that get filled up. And Andrew's muted. Rip.
Bad habit. It's the most exciting thing that's ever happened in these people's lives, right? The shooting in the movie theater feet away from them. They've told the story 10,000 times, and they're telling it in the context of 8 years of media propaganda that this was a shooting over popcorn.
Right.
The prospects that they would have the strength to not conform to what the universally accepted narrative of this is, as far as they can tell from the media, is impossible. I mean, people don't do that.
And that
Right.
they're probably reading stuff, and then when they read things, then that explains X, Y, and Z, and then all of a sudden that memory gets incorporated into their story, and they don't even realize it was picked up secondarily.
Right. And to be very clear to people who are listening, that's not like a condemnation of the witnesses. It doesn't
No.
mean they're nefarious or bad actors. It
It's
just
normal.
is. It's just how our brains operate, because like you said, Steve, we don't perceive whole situations. We can only see this limited picture that we get. But these people are, they're hearing from other people, they're reading about it, they're retelling the story, and suddenly they need to have another camera angle to find out. Someone asks, "Oh, what was going on over here?" And their brain might put together some interpretation of what must have been going on based on what they perceived. And that's why we get some of these people who say that that Chad was saying the F word. We have other people who don't mention that at all. And that can be, they didn't hear all of the statement, and so their brain put in what they're used to. And maybe they're people who use a lot of profanity. They hang around people who use lots of profanities into the statement. Maybe they're not people who ever use profanity. And so when their brain is filling in gaps, it leaves out F words that might have been there or might not have.
Right. Or
And
they don't use profanity, and they've told the story 10,000 times, but when they tell it, because they are people who don't routinely use profanity, they leave
Right.
that out, right? If you're telling the story to your grandmother, you're not including all the F-bombs.
Right.
Well, maybe your grandmother, I would.
It's that's really one of the great facets of the movie My Cousin Vinny, arguably the best legal movie ever made, is
Agreed, yeah.
all those witnesses that he impeaches. None of them are big fat liars who are wrongfully trying to put these kids in prison. They all believe their own testimony.
Yep.
But through impeachment, he exposes how defective what they believe to be true actually is.
And the only way to get at that is exactly what this attorney just did on cross, which is the timeline. And when he said you had 1 minute to discuss this, right? And he laid it out,
Right.
He boxed it in. That was exactly how
It
you
was the
bring up.
instant grits moment.
Well, that was excellent.
Right.
That way he did
No
that.
genuine Southerner
Yeah.
makes instant grits.
Right. So but that's how you reveal those errors in narrative or memory, is just by getting into the minutia.
Okay. I'm putting up a poll here for people in the chat, and it's guilt or innocence. It's the same poll I did yesterday. So the options are guilty, not guilty, guilty, but the jury says not guilty, or not guilty, but the jury says guilty. So you guys can.
It's like an LSAT question.
Well, yeah, but I mean, there are a lot of people get confused. Is this my opinion? Is it what I think the jury's going to do? The cynicism of the system could come into play on either side. So I'm trying to make sure to write better poll questions, and I think adding those last two options helps.
Well, I always like to say, how do you represent the guilty? Well, there's some people that I think maybe not guilty beyond a reasonable doubt, which is a different question. That's,
Yep.
Are you guilty beyond a reasonable doubt? No, I've got some reasonable doubts. Doesn't mean, if I was to ask, well, did they do it or did they not do it? Or that's a different question. You have to ask the specific question that the jury is put to, right?
I told you, Nick. I told you yesterday. I told you.
Told me what?
It's got to be beyond a reasonable doubt, not just.
Oh, yeah.
Otherwise, people are just asking whether or not they think it's
Oh.
more likely.
Yeah. Yeah. I look, the way I write the answers, I'm already left with only 4 characters. So I'll just write Bard in there. So, okay. So here's a super chat. This is a question from Lightning Ninja 36. I'm in a parking lot working with the only option to retreat being a road that has people constantly speed down it, and I had just been threatened. Am I allowed to hit the other person, or do I have to run to the road?
So, I mean, you're asking the wrong question and getting to the wrong answer. I mean, there's 5 elements to a claim of self-defense, folks, right? lawofselfdefense.com/elements. This infographic is free.
Did you
The fact
send
that the
the
road
super
is
chat
busy
to set
behind
that
you
up?
addresses only one of those. It only addresses whether or not you might have a legal duty to retreat from the confrontation. If retreat's not safe, you don't have the legal duty, even in a state that has a generalized legal duty to retreat. That doesn't necessarily mean you'd be entitled to use any particular degree of force on that other person. That question requires consideration of the other elements.
I think you sent that. You sent that as a seed question. You're like, aha,
Yeah, I should.
this is how I can promote my chart.
How awesome is Andrew's book? Could you have Andrew describe it?
And can I add to the not guilty, innocent, guilty kind of thing? The
Yes.
question in this case again is not did he do it? The question is, was he justified in using deadly force? And that's the only question. And I like to narrow, when I do trials, I like to narrow it down to one question. This is the question for you, the fact finder. And in this case, I'd be hammered on he was justified or not justified, you're a prosecutor, in using deadly force. That's the question you have. There's no question of identity. There's no question of this. There's no question of this. This is the issue you need to answer.
And they should answer that one first.
That is
I mean,
the
when-
only question. What
yeah.
other questions are there?
Don't waste all that time going through all the alleged crimes and all those elements and all that. You know, I always like to say, hey, if you consider self-defense first, you could be home by lunch. So,
Yeah, I like that. Yeah.
Steve, would you think it's a good idea to tell them, to frame in your closing argument? We've heard a lot of testimony about a lot of things about this case, because the state has an obligation to show that my client is the one who shot this person. But we all know that's what happened. That's not actually an issue here. So a lot of that stuff you could kind of ignore and get to the real heart of this matter. Was he justified in taking that shot? You can, and just kind of set it up to get rid of all of that forensic testimony and all of that nonsense.
Exactly. That's exactly the way you do it, because that's and there's different trial strategies, and different attorneys have different ways, and you have to play to who you are as a trial attorney and a defense attorney. But that's the way I do it. I like to say there's no, all of these issues. This is not an issue. We are not here because we don't know who shot. We don't know who did what. The question is, was this a justified shooting? That's it. And you have to look at it through the eyes of my client. Was
right.
My client, who's wearing a cane, who's infirmed, who has this certain self-defense training in his mind, and he's being attacked by a larger, younger person in this darkened theater. And is that a reasonable perception? And is he reasonably perceiving an imminent use of threat against himself?
He doesn't even have to be right.
Right. Doesn't have to be
Yeah.
right.
And I think I'm curious if it would be a good idea at some point to for some use of force expert to start making the argument that bigger versus smaller at some point doesn't really matter that much. Because when you get to guys who are 200, 220 pounds, it doesn't matter how, one guy's 220 and the other guy's 245. He's bigger. It's like, yeah, but you get hit by anybody who's 220 and exactly how terrible of a calculation you just made. That's a lot of meat. This Chad guy, I mean, he's not a big guy, really. He's tall. He's 6'4", he's 200 pounds. That's about my build. I'm 6'2" and I'm about 190. So, I mean, he's just a little bit bulkier than I am. That's a lot of force that can be generated by a guy that big. I don't want to ever be hit by someone who's 6'4", 200 pounds, or any if you're 6'4" and you're 130, okay, let's take it. I'll snap you around. But
the jury instructions do allow for the jury to take into account the relative physical abilities and capabilities of the participants. And the fact is that you have a stronger person. What are the facts in this case? Did the attacker, person who got shot, did he know that the other fellow had a gun, or did the guy pull the gun and he shot him before he knew?
Pulled the gun, shot him before he knew. The gun was in a pocket holster, and he's sitting down, and it's fairly dark. The previews are playing. One of the witnesses testified that all he could see was a silhouette. So you get the idea that he was turned around, and the light from the screen is the predominant light that's
Right.
that's behind him. So you can't see the dead guy's features. So that's kind of the environment you're in. So there's probably no way he knew that the guy had a gun as he's making this argument.
And the deadly force that the defense is painting as being used against him is what? The cell phone being used as a battery, or the physical disparity?
It's a combination of several things. The defendant his police statement.
The
he
focus
says
has really been more on grave bodily injury portion of the deadly force than
From
death
what-
itself.
From what?
The narrative of the defense is really that it would have reasonably appeared as an ongoing series of blows to the head of this victim. So first he was struck in the head. Then the thing with the popcorn happened. So the guy reached in, grabbed the popcorn, threw it back, but the defendant didn't even know the popcorn was being taken. What he saw was more blows coming in, the movement of the hand coming in. So he perceived that this was an ongoing attack on his frail person by a younger, stronger, aggressive attacker leaning over the seats to get at him and perhaps get at his wife as well.
See, this is where the problem comes in. This is why this case being tried, is because if he had struck back with non-deadly force, it wouldn't be an issue.
Yeah, for sure.
It's the escalation to the deadly force that makes this. That's the big thing. Was that justified?
Right.
Yeah. And really, that's one of the reasons I caution everybody to listen. I carry a gun for personal protection. I have every day of my adult life. I also carry pepper spray. So I have some option other than just having to go to the gun, because if all you carry is the gun, I work a lot of cases where people were genuinely frightened of a genuine threat, and they're scared and they go to the only tool they have, which is that gun, but it wasn't a deadly force threat. And they find themselves charged with aggravated assault with a firearm, which is a pretty damn serious felony.
Yeah, it's with this one, it's he did testify, or he hasn't testified, but his police statement involves him getting struck. He doesn't know what by. There's an inference that it could have been the cell phone, because the deceased cell phone lands on the floor between his feet. They recover the cell phone from there, but they don't actually know if it's a cell phone or not. Might have been a hand. It could have been nothing. He could have not been struck at all, but he had said that he was struck, or had the sense that he was struck, and felt dazed sort of by it. But he doesn't have a manifest injury that is clearly apparent. He has some redness around this area, but who knows? That could be,
See,
that could
this
be
is
anything.
such a close call. That's why I think that it's going to be about who your jury is and what their perceptions about violence and use of force and firearms, because they're going to make that call. You're going to have your opinion based on what you think you can do with a gun.
Right. And people are, I do see people say that he started it or whatever. The interesting thing, and correct me if I'm wrong, Steve, but mere words are not sufficient provocation in Florida. So
Well,
he's-
for a battery, for a self-defense, for a battery, for the initial aggressor is usually the one that throws the first blow, although that's
Right.
often foggy with facts. But
yeah. So in this case, there's the claim that he started it comes from his words or interaction that he has with Chad, and in that hey, can you turn your cell phone off, or maybe it was turn your cell phone off, you young friggin' punk, or whatever it was. I don't know, right? None of us know how to categorize that, so I'm not trying to draw any inferences, but that, and then he goes to talk to the hotel, the movie theater employee, says, "Hey, guy's got his cell phone on in the previews." And then when he goes back in, the guy turns the cell phone off, and he alleges that he said something to the effect of, "If I would have known you were going to turn your phone off, I wouldn't have bothered with it." And then that's when the altercation heats up, apparently. But that's only if you believe what he said, right? Maybe he said, "I knew you'd turn your phone off, you little bitch." Right? Like that. That's what I would say. But
Well,
I'm a
not me.
jerk. No,
Yeah.
no, I'm kidding. Of course. I wouldn't talk except,
You'd
I
say it
would-
in Kermit voice.
yeah. I knew you'd turn that phone off, you little bitch. That'd be great. I'll try that next time I'm at the theater. I hate when someone turns their phone on in front of me, because it's always like, it's like the sun has risen in front of you and you're like, "Oh my God," because they never have their like screen brightness down. It's always maxed out. Anyway.
Well, the reason I brought up the about the perception of the gun, and it's something that defense attorneys miss, everybody misses in these cases, that drives me batty, is that if somebody has a firearm and the attacker you have an attacker coming at you with fisticuffs, but they know that you have a firearm, there is a deadly force threat within that, because they can take that firearm from you and use it against you. And oftentimes that gets overlooked by everybody in the courtroom, that
Yeah, there's a gun in the fight already.
there is a gun in the fight. And if that person, the attacker, is aware of it and keeps coming at you, that is a possibility of deadly force being used against you. So that's why I didn't know about the fact particularly in this case.
Yeah, and that's one of the things we discussed heavily in Rittenhouse, because Joseph Rosenbaum is chasing in
Right.
bare hands. However, Rittenhouse is openly armed, obviously armed. This guy's still chasing him and makes a motion for the gun. So the implication is, if he takes the gun, you're dead.
Right. Exactly.
And so that's a big issue there.
Especially in combination with his earlier murder threats against Rittenhouse and his demonstration that he's not afraid of people who have guns, right? The whole shoot me binger.
Yeah. Yep. It's shoot me binger.
Got to clean it up a little bit, Nick.
You got to do it.
I watched a lot of that trial. That was a very good coverage you guys did on that one. That
Oh,
Rittenhouse
thank
trial.
you.
Thank you.
Really enjoy your coverage of these trials, because it's interesting to criticize, because that's what I do all day in appeals, is criticize courtroom behavior. So it's neat to see it in action and hear other people's perceptions of how it goes.
Well, you have a very busy schedule, but at any time you're available, and like if you have some time off and we're covering a trial, you are welcome on for sure.
Well, thank you. Maybe in Florida, it's tricky, but I'm on This is what I do on my time off, right? I take off and I just come on to a legal show, right?
Koi 540 says, on the Citizens United decision, in general, I think I agree, except in one situation where as district attorney elections, an equal part of what this country was founded, everyone is subject to the law. That is jeopardized by Citizens United. Nope. I can't agree with you. Citizens United for me is that money is speech. And I agree with that money is speech. And even if that is a bad result, because the evil George Soros, even if that's a bad result, I still have to stand by the principle that money is speech and we have the right to spend our money to say what we want to say. Now, it's different if you're coordinating that expenditure with the campaign. That's illegal. That's fine. But
Well, a good example of that is right now in Canada. They're seizing the money of people that want to donate to the truckers. Isn't that speech? Aren't you supporting the idea of what they're doing is peacefully protesting, and you're donating money, and yet that's being seized? So aren't they in fact silencing you and your money and your votes with your dollars? I mean,
it's worse. It's worse
that's
because
a horrible what they're doing in Canada. I mean, that is crazy.
Yeah, and
money.
That's where this came up in context on my stream the other day. Is I likened the Canada thing to Citizens United, because not only are they silencing your speech, they're actually, by seizing the money, they're compelling you to support the Canadian government against the truckers. which is it's one thing with stopping something for me, but when government compels something out of someone, that is the more offensive tyranny, in my opinion. And the fact that they are compelling support of the Canadian government by stealing, frankly, the money that's supposed to go to the truckers, that is absolutely beyond the pale. And I agree. It's a silence of speech. It's a compelled speech, and I hate it. From here on says Branca, Bruce Rivers, criminal lawyer, and Nick on the same stream would be the show of the century. I've seen Bruce Rivers a little bit. I haven't watched a bunch of his stuff, but I've seen his show on YouTube. I'll have to reach out to him. Morgan Babcock says Branca. Branca, damn it. I'm trying to work on that. I just went to download the element sheet. It downloaded no problem, but I'm confused as to why when I did, I was redirected to Google Maps location Thal. I've never heard of such a place, but I'm a hermit. You're muted. Yep. I don't know what that, but I don't know what that means. That could be a joke or meme that I'm not understanding.
I don't know. I'll have to have someone take a look at it. But you should not be, that would not be intentional on our part. If I was going to redirect you anywhere, it would be to buy a product or service.
Stace on the case says time to make the donuts. Wait, do you make donuts like real ones? Not like these stupid cake donuts, but a real raised yeast donut. It's fried, delicious. They don't have these in Minnesota. I'm deprived. I'm a Texas boy. Okay. Beast on the run says, Nick, forget your PB&J sandwiches. You ain't shit until you've had Serbian style pizza. Add ketchup on top. No, thank you.
Ketchup on that.
Ketchup on a pizza. I mean, I guess it's just sugary tomato sauce. But John Hallgren says, quit ragging on his jacket. He was buried in it. Oh, come on. Distro 32 says, can we get the Edgecombe judge and prosecutor? Oh man. Yeah, that'd be great. That's been an interesting thing watching these trials to me is in all of the trials we've watched, I felt that there's been a disparity between the quality of the prosecution and the defense. Kim Potter, I guess, the prosecution ended up winning, although I thought the defense was better conducted for the most part. I think the close by Earl Grey certainly deserves some criticism, but in general, throughout most of it. But and in this case, I think the defense is doing a much better job than the prosecution.
Well, and the lawyers, we like to compliment ourselves to think that it's all about us. But
right.
Sadly, sometimes it's about the facts and the law. And, we try to get in the way, and whether thankfully it's not who's the more likable guy, because I would lose every time. So instead I try to focus on the facts are from that jury and don't care about us. So yes, a prosecutor can screw up a case, but actually being a prosecutor is actually quite easy. All you do is you just call your witnesses and say, now tell them what happened, cop. And the cop says what they did, right? They throw all the evidence out there and then they say they did it. Yep. Whereas a defense attorney, it's a lot more difficult. It's a little more artistic because you know those facts. You need to know where the weak points are and attack them. And it develops where these are higher level prosecutors. Looks like they're older folks and they should know what they're doing. But if they haven't been through the defense world, they don't really have an understanding. It gets so easy because they win so many. They're used to winning, and they sometimes don't see the where the inflection points are in the case. Whereas a defense attorney is a little bit more sensitive to that. So I think that just goes with the nature of prosecutors, that they win all the time because most of the people that are arrested are guilty and they do get convicted. And so when you got a case like this, it's close or it doesn't compute. It doesn't go in their head as much, and they seem to react a little differently. And now we've got to actually be lawyers and deal with legal issues, and so they get hussy and they threaten and they cajole.
Well, it certainly seemed in this trial, like often. Am I muted again? Did I do it to myself?
No, you're good. You're good.
That often the prosecution would do direct on their witnesses, and they'd be like, "Yeah, that all felt good. Yeah, we're good." And they'd sit down, and then the defense would just rip them apart. with those prior depositions and the inconsistent statements. And you'd think, but the state has to know that's going. I mean, they've had a 2-week self-defense immunity hearing in this case. They've actually already tried the case.
Well, and as a prosecutor, that's stupid, because if you know where your witness is going, then you clean it up and direct. You don't give that to the defense. So that's the kind of thing I'm talking about. But if you aren't used to that, then it's like, well, I'll throw it up there. It's like I win because they're guilty and all. You just get sloppy. So that was sloppy to me.
There was to me the best evidence for prosecutors have life on easy mode or lawyering on easy mode was it was during the election stuff, when all of the election lawsuits were coming up. And there's I don't remember his name, but he's a conservative speaker, but he's a lawyer, former prosecutor for a long time. And one of the election cases got dismissed, and he goes on Twitter and he's like, "This is an outrage. Never in my 20 years as a lawyer have I ever seen a case dismissed pre-trial."
Was that Giuliani?
No, it wasn't Giuliani. It was some guy I didn't know of, but I mean, he had a pretty significant following, and he's on the circuit. Like, he's a guy who probably shows up on Fox News from time to time to offer commentary. But I'm like, well, yeah, if you're a prosecutor, I guess that's possible that you've never had a case dismissed pre-trial.
Well, closing arguments, they'd fall into the traps with these glasses. They'll say something like, "We only bring cases against the guilty," which of course is improper closing argument. But they fall into that trap because they convince themselves that I only prosecute the guilty. They think that, and they don't see the other side, and then that's how they lose. You have to see all sides of it. A good lawyer will see all sides of it and weigh those relative risks and strengths and weaknesses.
Yeah, it's
Let's see, it's good here.
It's not many people who can genuinely see all sides of an argument. I mean, not even all lawyers are able to do that. And you look in the comments and you see this kind of stuff all the time. It's like, well, he shouldn't have started a fight then if he didn't want to, get attacked by that 43-year-old 6'4" dude. As if asking someone in a movie theater to turn off their phone is starting a fight. But these people get that conception in their head. And then because he requested someone in the theater to turn off this phone, that means everything else that follows is invariably his fault. No matter who the initial aggressor was, no matter what the degree of threat was, nothing else matters.
Well, and even as a defense, being a trial attorney and also have been on second chair, it's hard because I get into trial mode. And when I'm trying a case, I believe in my case 100%. And, whatever negotiations and whatever I've given to the state before, on trial day, I'm at war and I'm right. And that oftentimes you get that tunnel vision. That's why it's good to have a second chair, because when you have an objection or a legal issue, it disrupts your I'm right thinking, and you can't comprehend what the other side is saying, even because you're in that trial mode.
Yeah, no, absolutely. And it's weird because we're trained to be zealous advocates, and to do that, to have that tunnel vision, go to war. But it's also part of it is assessing the quality of the opposition, and like you said, that's why you have a second chair, or that's why you hire outside counsel to come in and make the other argument, because you might miss something in your tunnel vision. Plus, you as a lawyer develop relationships with your clients. I mean, no matter how long you have them as a client, you've got to get to know them. And when you see them, they're not stabbing someone, right? So you get this other view that all of the witnesses to the case do not have. Last time they saw someone, they were holding someone by the shirt collar and pounding their face with their other hand. But you see them as like, a dad or a guy coming in from the factory or whatever it may be. And so you get this this other perspective, and you need to have someone sometimes bring that reality back. Remember, though, this guy was beating a guy to death just 2 weeks ago, and you're going to have to deal with that issue. That's a small thing. Bryce Hamilton says, I assume that the cell phone defense was made up after the fact, but now having heard it on the police interview, my view on the trial has changed. Yeah. It's
that's why we have trials, right? Before juries who can hear all the evidence. I mean, it's amazing how when you contrast media reports to watching coverage like what you guys do, it's a different thing completely.
Yeah, I
Yeah,
mean, I've told
remember
this story before,
Rittenhouse.
but from time to time, I teach at the FBI Academy down at Quantico, and I talk about these high-profile cases and how basically they're propagandized to death to the point where it's almost impossible to find a jury that can be fair and impartial. And I'll be talking to an audience of 200, 300 FBI agents, senior law enforcement from all over the country, and I'll ask them questions like, who believes this happened in this trial? And every hand goes up because they saw it in the media 10,000 times and they've repeated it themselves. So now they're emotionally invested in that quote unquote fact. Then I demonstrate beyond a doubt by showing them the actual evidence that that view is mistaken. And maybe half of them are able to accept that's true. The other half, their faces just go blank. They're emotionally incapable of accepting that the narrative they had believed 150% is actually just propaganda.
Yeah, they have a sunk cost fallacy now. Like,
Well, that's
no,
why, I mean,
I
looking
believe
at the
this for so long.
January 6th defendants, I don't know why, and they got to get them out of DC because, I mean, those people are facing a jury of people that have already got their minds made up. I don't see how they could ever get a fair trial in DC.
Well, they just may never get a trial.
Yeah, that's right. Just lock
They'll
them
just
up
keep them
forever.
locked up forever. At this point, shouldn't they just release some of them? Like you might be guilty. I don't know, but you've served now. You're coming up on well over a year for a trespassing charge in many cases. It's like, okay, come on.
It's unbelievable that whole thing is very bad for our republic.
Yeah,
Those
and
prosecutions.
I want to know what happened to the judges, because there were some judges out there saying, hey, if we don't move these prosecutions along, I'm going to start dismissing cases. And that was 6 months ago. And I don't see any judges dismissing those cases. I just see people whose rights have been very, very suspectly handled, we'll say
Well,
nicely.
do you practice federally?
No, I'm a small town lawyer, and I don't practice much at all right now. This is what I do now. But I would do some criminal defense, but it's all petty stuff, petty drug charges, some domestic assaults, stuff like that.
Because to me, there's a big problem with those prosecutions in that the disclosures from the government are not being forthcoming. I mean, if you hear about the Ray Epps revelations and a lot of the federal instigations, and and there's a lot of evidence about who opened the magnetic doors, who took down the barriers, who was instigating the rioters. All of those things are federally instigated, and that seems to me that should be coming out, being provided to the defenses. But I don't think it is. I think it's being concealed. But when you have a judge and a prosecutor and maybe even the public defender's office, I don't know, being bought out by the or being compromised, you don't get justice. We had a case where I had one case in particular where the person was actually innocent. And we had a prosecutor and a judge that were just not playing fair, and they got a conviction. And, if you have a prosecutor playing fair and you got a good judge, you can sometimes ameliorate that. But when you have a judge and a prosecutor, very hard for a defense to do anything.
Oh yeah. And I've talked about this a couple times, but there's also in many cases, the judge and the prosecutor share a hallway for their workplace when they're not, in court, their office is right down the hall in the same building. And that, they're going to run into each other at the break room and stuff like that. And that's a weird dynamic for defense attorneys to have to compete with, because you're not going to get it. And even outside of that, when they do these cattle call hearings, a prosecutor will sit down with a stack of 40 files that they're going to go through, and you can sit in that courtroom and listen. And if you do it sometime, what you'll hear is a lot of banter between the judge and their coworker who's sitting at the prosecution's table, where defense attorneys will rotate up throughout the day, representing maybe one to five clients or something like that. The prosecutor and the judge are going to be joking back and forth, talking about what they're doing on the weekends. And it's a little uncomfortable that's the situation we're in.
It goes way beyond that. It goes also to the fact of who's their bailiff sitting next to them. Oh, you're from the Volusia County Sheriff's Department, right? And so now this defense attorney is arguing, I want you to say that cop from Volusia County Sheriff's Department is lying. And then they look over, here's the bailiff that they hang out with and go to lunch with that protects them. And they hang out with all those sheriff's department employees. And then they're being asked to rule against the sheriff's department. That, very, very difficult uphill battle for defense, oftentimes dealing with those issues.
So far, I've slated you for a show on January 6th. I've slated you for a show on what I call the blue bias. We've got a long, storied future together.
Funny. Well, I appreciate that. Actually, everybody talks to me about law stuff. I used to do radio with a fellow called the Mark Bernier Show. I don't know if you're familiar with him, but he was our local radio. Mark Bernier.
I've heard.
He passed away
guy
recently, and he was one of those conservative radio talk show hosts that died of COVID.
Yeah.
But I know a little more about that than the media would have you say, but let's just say that the media is wrong as usual. But we used to talk about all kinds of stuff, but I always said my favorite stuff is talking about music. Let's talk about rock and roll and, thrash metal.
I'm game for any of that too. I like talking to people about anything. Mark Bernier, he used to I used to listen to when I went to law school, especially, I was driving 2 hours each way. And so I would listen to Glenn Beck a lot. And I'm pretty sure he sat in for Beck or maybe Mark Levin a couple times. So I know I've heard the guy's name. And I've heard
he was a radio guy for 30 years. He's really good. So we used to have long, we'd get these call-ins. This is typical. I'd call in and then he'd say, "Yeah, I need to get you in, Gosney." And then I'd be sitting there for 3 hours talking with Bernier. But but it's always fun. I enjoy. I see. I don't have this outlet now that Bernier passed away. See, so.
Well, maybe you do.
I'll be your Huckleberry.
Well, one of the things I found, and just generally commenting, this is a little outside of the legal box, but is that the media, the monolithic media that reports and doesn't do the reporting, like when you're seeing these details, what you're doing is such a service because people can see what's really happening. But that also goes to all local issues. Where do people get local media and local news? It's devoid. We don't have local newspapers anymore. And there's no local news sites. So that's why, these kind of shows, these internet shows that focus in on something very specifically, you get so much more detail and in-depth commentary. We need to have more things like what you're doing on more topics.
Well, that's why I want to remind everybody that Law and Crime sucks because what they're trying to do to me right now is claim copyright over these court proceedings. And
this is a public broadcast, isn't it?
Well, this one is, I'm not sure what's going on with this one in Florida, but Law and Crime is hosting the pooled media feed on their site, but other people are hosting the pooled media feed. It's the exact same feed for all of the channels, right? Because there's only 2 or 3 cameras that are allowed in the courtroom. Otherwise, you'd have 50 million cameras and it'd be a disaster. But yeah, so they're hosting it. They're not doing it for this trial. I covered the Chandler Halderson trial up in Wisconsin a little bit. That was the kid who shot his parents and chopped them up and may have eaten them. I don't know. I think so. Look,
yeah.
If you've already chopped them up, why not just grill them up a little bit and take a bite? But no, that's half a joke. I actually, we're not going to get into it.
There's another problem with doing this. Death stuff and criminal law is you get so many dark images in your head. I actively avoid looking at things like that because, you see it in your regular work, doing murder cases. And it's really, I get sad. And then that image sits in your head. It's really a downside of doing capital stuff and murder stuff.
Kids stuff
and child porn stuff. In fact, and one of the reasons I specialize in death and destruction is because I don't like the sex.
Yeah.
Because I'd rather deal with the death and destruction than the sex cases, in all honesty. So I focus on firearm stuff and beatings.
Yeah, no, it's way better in my opinion. The kid stuff is soul crushing. It is, you hate humanity whenever that comes up.
It's just hard on your heart because you see innocent children, being abused, and it's just hard because you, as a parent, you can't protect them.
Yeah,
you know, And
exactly.
that's sort of that instinct. It's the parental instinct comes out, and it's nothing you can do about it.
How many kids you have?
I have one. He's going to college.
Oh,
He's-
goodness.
Yes, he's 18. Well, he's 17. He's going to be going to Embry-Riddle
Very
University.
cool, man.
Engineer. I said, stay away from law.
I have 5, but they're 4 to 14. So
Are you Catholic also?
I was raised Catholic, but now I'm just some off brand of Christianity.
Okay.
So, we went generic. Okay. Gates of Above says, except Chandler's lawyers knew, this Chandler Halderson knew he killed, chopped, and ate his parents. That was actually my theory. They put up one of the most anemic defenses. It was a tough case because they had the kid dead to rights. And they put up a very anemic defense, but I about halfway through the trial, I think I was on the theory that he had disclosed to them that they did it, or that he had done it, and they were going through the trial motion as just, well, we'll see if there's any procedural defects that maybe we could capitalize on. And there was nothing. I mean, they weren't cross-examining most of the witnesses. It was very much one-sided.
Well, but all defense, there's a list. Have you ever seen the 5 defenses everybody has? I'll have to send that to you. But
Yeah.
one of them is, if you have nothing, they didn't prove it. I mean,
Right.
that's, so you just say, well, sometimes you don't have anything. And I think that if you have that case, sometimes you just have to say, they didn't prove it, and sit down. Now, a good prosecutor, again, there's good and bad prosecutors. A good prosecutor can really keep a defense attorney in their chair.
Yeah.
Like this prosecutor who's you're expanding into areas that you shouldn't. You're causing objections. You're arguing things that aren't the law. You're given the defense issues. But if you've got the case, you've got the facts, and you got the law on your side, there's never any reason to go outside the law. But why would you ever give that to the defense?
That was actually the probably the most dramatic moment of the trial, was during closing arguments rebuttal, when the prosecutor, who had been very good, his opening argument was phenomenal, great storytelling, all of it was good. But then he and throughout the trial, he's very good. But on this rebuttal, the defense had said, if they don't prove beyond a reasonable doubt, then you got to find not guilty. He says that the defense attorney is lying to you and asking for you to lie for the defendant. And they objected and went back into chambers, and the judge came out and really mitigated that a lot, as much as possible. But it's like, dude, why are you doing this? You're spiking a corpse, and you're jeopardizing your case. I mean, this kid was gone.
Yeah, it always happens in the prosecutor rebuttal argument. I wrote an article on this actually on Florida prosecutorial ethics in closing arguments, and how to do it right and how to not do it right, and all the instances of reversals in Florida based on improper closing arguments. That's one of those articles on the SSRN page. And it always comes up in the rebuttal. Because the state, what they do is they present their case and they do the thing that they're trying to do, and then the defense gets up and makes their case, and it annoys them so much,
right,
that they unleash and they lose their brains in the rebuttal.
Yeah, it's crazy. Tom Grawl says, got COVID on Sunday. Last night went to eat ham. I thought I had bad mustard. Today tried hot dogs. No go. I now understand how you feel. I think this is God's way of putting my fat ass on a diet, a cruel one. Dude, it is the worst. It is the worst. Steve, I have this parsomia where it's like the lingering effect from having COVID a couple months ago, where now food that I like tastes like garbage. So basically any cooked meat, especially fried chicken.
I had it a while back, and I had a 99-degree fever for 2 days. I didn't even know I had it. So, top 3 metal bands, by the way, from the chats. You got to talk metal. This is the thing. You want to get you got to go with Anthrax, Megadeth, Testament. Well, now I'm going more than 3. Iron Maiden, Judas Priest. Come on.
How do you like Sabaton?
So I'm not into Sabaton. I'm
Oh,
lately
really?
into, I just went and saw Tool in Orlando and they were awesome. And
Oh, okay.
Ginger and Mastodon, great stuff.
I didn't know Tool was still alive.
Yeah, my wife
they-
just saw Tool here in Denver a couple weeks ago.
One of the loudest concerts I've been to in a long time.
So glad I
Great,
didn't
though.
go.
It was really loud.
Man, I see. I used to listen to I didn't listen to a ton of metal, but I listened to like metal adjacent stuff. I've been to several Slipknot concerts. Pantera, I guess, is probably metal. Went to
Yeah, for
Pantera.
sure.
Went to saw Black Sabbath at one of the Edge Fests or X Fests or Warp Tour. It was not Warp Tour. But yeah, it's
Yeah, everybody wants to know why Branca's wife went to a Tool concert. I want to know about that too. That's fascinating.
Well, she's quite a bit younger than me.
Quite a Tool fan, huh? That's cool.
Oh yeah.
Yeah.
why aren't you singing Lateralis right now? Come on.
Perfect circle.
New album is great. New Tool album is great.
Is it?
Yeah.
Oh yeah, Rob Zombie. Been to Rob Zombie. Been to Power Man 5000, Rob's little brother.
Okay.
Static X. Oh, Static X was a good show. They're arguing at Sidebar that we didn't even get to see them do. Anthony Zink says, now I know why that detective is a pest control guy after seeing this Mickey Mouse investigation. Hopefully he's better at killing mice than being a detective. It was bad.
It was bad.
It's pretty bad.
But sadly, we see that. I mean, that's not uncommon. I mean, I've seen some great investigations. I've seen some investigations on a murder case. Boy, they solved that case. I can't talk too much about it, but it was really good police work, and they solved the case based on good police work. So it's not the rule, but there are a lot of detectives out there who just mail it in like this guy did.
Ian Smith says, here's my tip for more great trial coverage. Thanks to you and the panel for the hours and hours of content while I'm pretending to work from home. Reticent, welcome to paralegal status. Thank you for joining. The Redneck Ram says, my dad used to like peanut butter and syrup sandwiches. My grandfather too. And yes, I mean pancake syrup. Thankfully, I just inherited his love of peanut butter part because the syrup part just sounds nasty. What my grandpa would do is he would mix up a bowl of maple syrup and peanut butter, and then he would get a loaf of bread and he would take 2 pieces at a time and just dip them into the slurry and just eat that. Apparently, I don't know. That's my mom talks about that. That was his go-to snack for a while. He never did that while I was around. But if he did, my grandpa was not a large man, so I would assume he would have become 700 pounds if that's what he was doing all the time. Danny Rendon says, EVS said he wasn't in a lawsuit anymore. Did you cover what happened somewhere? I'll go watch it. I did on a live stream. He was dismissed out of the case without prejudice for improper jurisdiction, as was the correct decision. He was not acting in Texas. He'd not been to Texas. He didn't make statements in Texas. He didn't send the information to Texas. So he was dismissed out of that case. The case is still ongoing against DA Talks and Vicky. So that, when there's some updates there, I'll give it a shot. But I did talk about it. I don't know what live stream it was on. I think it might be in the title, and it would have probably been in the last 2 months. That's a lot of streams. Good luck. Jessica Aaron says, hypothetically, if I'm a sociopath and don't feel emotions, do I have a right to self-defense despite being incapable of being reasonably fearful?
Yes.
Yes. Andrew clarified this yesterday. They say reasonable fear, but apprehension is a better
But it's also an objective test. It's based on a reasonable person, not the actual individual. So if a reasonable person would be threatened, particularly in a situation, then that's sufficient. It doesn't matter that the person was actually felt threatened.
Well, I thought you also have to have the subjective there, because if the person doesn't feel subjectively scared, then scared.
We got the expert right here. What's the expert say?
Yeah, you need both. You need the subjective, genuine, good faith belief. You need to act in self-defense, and that subjective belief has to be objectively reasonable.
Excellent. We'll get started directly. You want to call Mr. Turner back in?
Yeah, call back, Mr. Turner.
But now does but you say you need the subjective, but the question was, what about the sociopath? What if they're acting objectively reasonably, but the sociopath doesn't have any fear necessarily? But
It
is
doesn't have
acting
to be
according
fear. It has to be apprehension of harm. So you don't actually have to be scared in an emotional sense, but you have to have a subjectively genuine apprehension of harm. So somebody, can, I don't know, a comic book hero with no fear, right? But someone's trying to shoot him. He has a reasonable subjective apprehension of harm.
That means that all Superman self-defense is unjustified because he can't be harmed.
All right, Mr. Turner, I'll
Is that
remind
Superman's
you
a criminal.
still under-
Is it the
Right.
trial?
Arguably, he's always acting in defense of others, right?
Was it the trial by Camus? Is that the one where he's acting in third party, looking above himself, and he shoots the guy? You read the
I don't know.
I
Yeah,
didn't see that one.
it's a book. It's
Or
a-
didn't read that one. Sorry.
Yeah, that's really a good book. It's all told in the third person. So Camus is basically saying, I shot the person. He came at me. My finger pulled the trigger. The person fell down. It's told in this very third party objective way, and he's ends up getting convicted. And he's very kind of matter of fact acting in the present. And the question is, did he have intent?
You a comic book guy too?
I am. I like everything, man. I like Silver Surfer. I've got a Silver Surfer #1 in mint condition from '67.
Dang.
So that's pretty cool.
Yeah, that's awesome.
Yeah, but I don't really collect them anymore.
No, collecting
still-
comics now is a disaster because they're people found out they were collectible, so they started printing them for collectability, and they're not. That makes them not collectible, which is
Right.
great.
I collect guitars too. Guitars like basses. And I used to play bass. Actually, I played Rush and Iron Maiden. That's all I played back in the day. I want to be a rock star, but they got stuck in this lawyer thing.
I'm gonna have to remove you from the stream because it's like you're cooler than me.
No. Believe me, if you met me in person, that would not be your opinion.
I'm putting the, yes, off the record.
Nova Amp says thoughts on the Quintez Brown BLM shooter case. I haven't really looked into it, but if I understand right, he was a guy.
He
I
shot at a mayoral candidate. Is that the guy up
Yeah.
in Louisville, Kentucky? Well, and he got bailed out by Black Lives Matter. They paid his $100,000 bail, and he's out. How about that?
They've got a habit of doing that with some people. They tried to do that with the Waukesha guy. They remember the Waukesha, Wisconsin, the parade guy who drove over the kids
Oh,
and
right.
stuff.
Crazy.
They had a fundraiser for that guy.
Well,
and
you
it
and I
got
know
shut
that
down.
they should be spending every bit of that money on lawyers.
Yeah, that's right. Hire me. I'll cover all your cases.
Right.
Let's see. Nascafar, thank you for the donation. FOG Smitty says, Dad, check your Discord messages. Much love. Will do, buddy. Will do. Night of Nice says, one of the best law channels on YouTube. Hey, thank you.
Thank you.
Petey Warren says, hey, Andrew, I loved your scene in True Romance.
Okay.
Tor Theo says, have you ever thrown a cat? No, Alinity, I haven't. If you haven't thrown a cat, you haven't owned a cat. Look, I'm not saying you do it on camera or whatever,
There you
but cats are
Thank you
jerks.
again. Just did a little practice run there and make sure you were all awake after lunch. So, all right, we're ready to begin again. And I did remind Mr. Turner that he's still under oath. Mr. Escobar?
Good afternoon, Mr. Turner.
Good afternoon.
Mr. Turner, you're retired,
I am.
and how old were you back in January of 2014?
59.
59, okay. You went with your wife to the Cobb Theater, is that correct?
Yes, sir.
Okay, and I believe you indicated on direct examination that when you first went in, the previews were already playing,
Yes, sir.
is that correct?
That's correct.
Okay, and so you walked up the stairs with your wife, and you all took a seat at the very top row, which I'm just going to call it row A for identification purposes, okay?
Yes, sir.
Is that correct?
That's correct.
And so if this is I'm going to use this as a screen. So if this is the screen, you were all the way to the right on row A. You were seated at the very last seat.
Correct.
Of row
Facing the screen.
Facing the screen.
On the
Just think
right.
that's a theater screen right there.
Yes, sir.
And your wife would be to your left.
That's correct.
Is that correct?
Yes, sir.
Okay. And you normally like to sit, obviously, at the end. Is that correct?
Yes, sir.
So that you can go to the bathroom whenever you need to.
It's more to be able to stretch my legs, but yes.
Okay. I know that you've had some, I guess, problems with your legs in the past. Is that the issue?
Is that because you're old?
Were you using a cane back then or not?
Intermittently, I did.
I know you had fallen quite a few times,
Yes, sir.
and sometimes you were in need of a cane,
Yes, sir.
and sometimes not. Is that correct?
That's correct.
Okay. And so you just don't recall whether that day you had a cane?
I'm pretty sure I did not.
Okay. Now, when you went into the previews, since they were already playing, they were loud.
Yes,
And when we say loud, that's the word that you've always been using in your testimony, correct?
as I recall, yes.
You haven't been using historically the word dim. You've been using loud, right? Or low. You've always said loud.
For the vocal, yes,
For the vocal.
yes,
For the previews being loud.
yes.
And you've always used the word dark in reference to the lighting.
No, sir, I don't believe that's correct.
Well, let me show you, man. Let's go through what you actually saying. Man, they're having upload issues. Stream is choppy.
You want to 2486 lines 22 through 25. Okay.
You can also do 24/7 lines.
Yep, we're going to talk about all that here. Now, you would agree that you've used the word darker, right?
I've used dark, I've used dim, darker, yes, sir.
Okay, and so let's talk a little bit about what that means. This is not the first time you've been to a theater, correct?
Correct.
Okay, and there's a reasons why the theater turns down the lights, correct?
Yes.
It's for the experience, right?
Sure, sure.
Okay, so one of the reasons why in previews they're loud for the experience, right?
Well, that and for commercials, they're trying to get your attention. even
Forget about the
further.
commercial. I'm talking about the previews,
Right.
the previews of the movies.
Right.
They're loud because they want to get your attention to go see RoboCop and Terminator and those types of things, correct?
Okay, yes.
Really
And you,
seem to be hung
you
up on
remember that
RoboCop
on
and
that
Terminator.
particular day, that's exactly what the previews were. RoboCop, Terminator, they were action-packed, shoot 'em up type of previews.
Right.
And they were loud.
Yes.
Now, when you first sit down, your wife is to your left.
Correct.
She's seated, you're seated. And the first thing that you notice is that you notice that there's a man standing up, correct?
Yes.
And Mr. Reeves is not in his seat, correct?
Correct.
And you notice this man standing up with a phone in his hand, correct?
Yes, sir.
And he's kind of seated, where Mr. Reeves would be seated, but one row below. He's standing up,
Yes.
right? And not only is he standing up, but this tall man, right?
He was tall.
It was a guy that you later came to know as Mr. Olson. That's your recollection, right?
Yes, sir.
And he was actually facing you.
Yes.
So he would have been facing you, right? You were right. So you got a good look at his face, your recollection is.
Yes, sir.
And he was just standing up in the middle of the theater while the previews were going. You found that a little bit odd, right?
Yes, sir.
Because you certainly wouldn't have been standing up in the middle of the theater with people behind you while the previews were going, right?
I would not have.
Well, did you see who was behind Mr. Olson as he was just standing up in the middle of the theater?
You're asking me, did I see?
Yeah, did you see who was behind Mr. Olson?
In my row?
Yes,
Yes. At that time, no one.
no one. So those seats were all empty?
No. I thought you're behind him. That seat was empty. The rest in the row, of course, was occupied, if that's what you're.
So the one seat right behind him was empty, but what about the seat, if I'm in that back row, right? And he is here in the lower row.
Hmm.
Was there an empty seat here? You know where Mr. Reeves was sitting, right?
No.
Was there someone sitting here?
Yes,
Boom.
his wife.
So he would have been standing up in front of his wife when you first came in. Mr. Olson facing you with a phone in his hand.
Yes, sir.
And that's what you saw and that's what you recollect.
Yes, sir.
And Mr. Reeves was nowhere near there yet.
No, sir.
And so you're seated and you're seeing Mr. Olson standing up, presumably in front of Mr. Reeves' wife.
Yes, sir.
And he's just standing there playing with his phone.
I don't know what he was doing with his phone, but he had his phone in his hand.
And he's facing in your direction.
Yes, sir.
And according to your recollection, he is there for quite some time
Yes, sir.
while the previews are playing.
Yes, sir.
And then after some time passes, your recollection is that you see Mr. Reeves walking up the stairs. Correct?
Correct.
And they're the stairs that actually lead right to your seat,
That's correct.
right at the far right.
Yes, sir.
Is that correct?
Yes, sir.
Correct.
Steve, is it your experience that attorneys cannot pronounce the
You
word
also had
correct?
noticed by that point in time that you thought that there was about 70 to 75 people in the theater, correct?
That was a guesstimate. Yes.
And you noticed that Mr. Olson had this.
They've gone 13
phone
corrects without a
that was
sidebar.
black in
It's a
color,
new record.
black.
Yes, sir.
And so as Mr. Reeves comes up to you, you're seeing him, right? Pretty close to you, he's walking up.
Yes, sir.
You see Mr. Reeves and you see him walking, and he's wearing, according to your recollection, a loose London fog waist-high jacket, light colored tan.
I think I said a light waist jacket, similar to what a London fog would be, or an old members only jacket or something of that nature, but it was
Long sleeves, jacket, kind of a tan area, right?
light colored, I
Yeah,
think I
and
said.
so you saw, well, I think you said tan, right?
I think I said light colored or tan.
Or tan, okay. And so that's what you see Mr. Reeves actually walking up the stairs wearing.
Well, to be more clear, I saw him as he approached my aisle.
Mhm.
So it wasn't as if I was looking at him as he was walking up. He was pretty much in my face.
So
at
even
that
better,
point.
you
Well,
even got a better view of the London fog type jacket.
well, I wouldn't say that. I would say because he was so close, I was staring basically at his midsection. So I wasn't, it wasn't as if I was seeing him in full stature.
He was junk gazing.
Saw the long sleeves, right?
I saw the waist jacket or the waist.
So you mean to tell me he was right in front of you and you didn't see anything but his waist?
I saw a cross section of his midsection as he was coming up.
Well, didn't you see him as he was walking up?
Once he approached me,
Okay. And what he told you at that point in time,
Were you enthralled
as
by
he
his
approached you,
midsection?
is he said, "Sir, excuse me, I'm going to try to get
well, he said, "Excuse me."
polite," right?
Yeah, politely.
Politely. Okay. It certainly didn't appear to you to be grumpy.
No.
And as he's scooting by, you're able to see more of his person, right?
No, not really.
Oh, really? So he's walking down the aisle, and you're not able to see his person. You're not able to see his back. You're not able to see his sleeves. You're not able to see any of that?
No, what I'm telling you is when he approached, said, "Excuse me," I turned away from him, facing away. He walked by me.
Okay, let's stop there for a second. I thought you just told the jury during direct examination that you turned in the direction of his seat. to
That's
let
what
him
I,
by.
that's what I just said.
Okay, and so then
Okay,
he's passing
I
by.
turned and then he was behind me. So he walked past and he walked on down to his seat,
So if you're
passing on
turned,
my right.
so if you're turned in that direction, you're seeing him as he goes to his seat, right?
Yes.
And you're able to see his full body, right?
At that point, I could see most of it. Yes.
And you saw that London fog type jacket with long sleeves.
Actually, I don't recall that I ever said he had long sleeves, but I did say it was a waist type of jacket or, yeah, I think I said a waist type.
Okay.
A short sleeve jacket?
A waist
Now,
type
you
jacket.
see him
Whatever that
actually
means.
walk to his seat, grab the bag of popcorn from his wife and sit down.
Yes.
And certainly you wouldn't think that someone that's going to his seat to grab a bag of popcorn is ready to get into a fight with anybody, right?
Speculation, or just speculation.
Where we
Sustained.
go. And while all this is happening, you're saying that Mr. Olson is still standing up. He's still standing up right there in the theater. Nobody else is standing up, right?
Correct.
He's the only one in the theater, according to your recollection, that's standing up.
Correct.
Objection, asked and answered.
Sustained.
Sustained.
And as Mr.
Lower
Reeves is
energy
getting
than
close
Regina
to
Chu.
his seat, that's when you first hear Mr. Olson speak, correct?
He had already sat down. And there was a communication between them. And that's when I heard Mr. Olson say, well, what he said.
You remember
What he said.
having a hearing here, Mr. Turner, and it was back in 2017. And you remember the following question and answer. It's on page 2494, lines 1 through 6. Remember the following question. Is it at this moment, somewhere around this moment, after Mr. Reeves had gotten close to his seat, that you first hear a voice, correct? You said yes. A voice, one voice? You said Mr. Olson's voice. Question, and the previews were on? Yes. And the previews were loud? Yes. So before that Mr. Reeves got to his seat and sat down, as he got close, you heard Mr. Olson speak, correct?
I don't know that it was before he sat down.
Well, you would agree that your recollection would be much better in 2017 than it is in 2022, correct?
Well, perhaps, but I guess I would ask the question.
Perhaps.
Well, we can't have the witnesses can't ask questions. I'm sorry, Mr. Turner, but
Unfortunately.
you can certainly give me many answers, okay? And I'll try to follow up with you with some of those, okay? So you would agree, would you not? Okay, that your recollection would be better in 2017 than it is in 22, especially since you were under oath in 2017.
I appreciate that, but I'm not sure how,
You took it seriously in 2017, did you not?
as I do now.
Okay, and so would your recollection be better in 2017 than 2022 or not?
Well, it most likely would.
Okay, that's all I wanted to
And
know.
people have a habit of their memories getting better over time, especially as they age.
Now, you're still looking around, right? You're still seeing, you have your focus on Mr. Olson, who's still standing up, correct?
Correct.
And this is when Mr. Olson starts to exchange his loud voices towards Mr. Reeves, correct?
I'm sorry, say that again.
That's when he starts yelling at Mr. Reeves, Mr. Olson.
I didn't hear him yelling at Mr. Reeves.
Well, let me ask you a question. Back in 2014, January,
Axe you.
and I don't mean this with any disrespect.
Not B. Ivory.
Were you hard of hearing?
Yeah, I'm not sure if this aggressive
No, I wasn't
questioning
hard
is
of hearing.
appropriate for this
The
witness
previews were
particularly.
loud, correct?
They were the same level as they were in 2015 or 2017.
Yeah, they don't change.
Right.
The loudness, it was there, right?
Yes,
Okay, and it was an action-packed type of preview, as
Yes.
we've talked before.
Your Honor, asked and answered.
Sustained.
Now, you say, because Mr. Olson was looking at you, right? And you say that now Mr. Olson squares up. Now he's looking straight at Mr. Reeves, right?
he turns to his right. Yes,
He turns towards Mr. Reeves.
that's correct.
He squares off to Mr. Reeves's chair.
Okay,
That's your recollection, correct?
yes,
And you would agree at that point in time, Mr. Olson was pissed.
yes, he was agitated, he was pissed, he was
Well, let's
frustrated.
Let's
I mean,
focus on,
well,
first of all, the word of pissed. That's what the word you used, right?
Yes, I've used all of those words.
However, your definition of pissed is not anger. That's what you're telling the ladies and gentlemen of the jury here, that if someone is pissed, they're not angry. Is that your understanding?
It can be, it can be frustration, it can be irritation, it can be a lot of things, but
And it can be anger, right?
well, your body language is trying to suggest something, what I would perceive to be way beyond.
Well, we're gonna
Yes.
get to body language because that's coming up next.
Okay.
Okay, but it could be anger, right?
You said pissed. Of course it could be
Yes.
anger. Why are you doing
Is
this?
that hard to say?
Objection, Your Honor.
You know, if this is going to be about you and I, then it's, you know. I'm not
See,
sure.
this witness is going to be listened to by the
Well, let me
jury,
ask you.
and he's treating him like a cop.
After you're seeing Mr. Olson pissed, you decide, I'm gonna get up. You're gonna stand up, right? You decide to get up out of your seat, correct? You felt the need at that point in time to get out of your seat. Am I right?
Yes, I got out of my seat.
And you stayed standing, right?
Yes,
And as Mr. Olson is making his statement while pissed, he's moving closer to Mr. Reeves. Correct? Closer to Mr. Reeves. Is that correct?
he turned toward Mr. Reeves. That's correct.
Is he getting closer to Mr. Reeves?
Not at that point.
Page 2499, lines 5 through 11.
I'll give the defense this. They got all their notes in a row.
Question,
Yeah, he's prepared for
same
his,
hearing.
he's prepared for sure, knows his case.
Place under oath.
As he ought to. He was retained the day after the
Place
shooting.
under oath.
Yes,
8 years to prepare.
Yeah.
Question, you realize that after Mr. Olson is making that statement, he's moving closer to Mr. Reeves, correct? Answer, yes. So now, not only is his voice elevated, he is now moving closer to Mr. Reeves. Your answer. Yeah, he's leaning towards Mr. Reeves, perhaps a 10 to 15 degree angle.
that's correct.
Question, you don't know whether his seat, meaning Mr. Olson's seat bottom, is up or down. You said, I don't. So you would agree here today, he's getting closer. And there's an angle now in the getting closer, meaning that Mr. Olson's body is now moving in an angle towards Mr. Reeves.
Yes,
This is dangerous what he's doing here. He's got to be careful on how he crosses this witness.
Yeah, he's bordering
In other
on
words,
being
leaning towards Mr.
badgering,
Reeves.
bullying.
Well, he's turning him into hostile
The-
witness when he's an eyewitness.
difference between what I'm
Impartial,
saying and what
supposedly,
you're
unless you can
talking
show
is
bias.
I've taken it in segments. He made the turn. Once he made the turn, he leaned forward. I had expected that you were going to come back with that part and ask, and I would say, yes, he
Well, you
leaned
just,
forward.
you just got it out for us. You leaned forward, right?
Right, that's,
Okay. And you're thinking that Mr. Reeves is going to get punched?
no, sir.
$24.99.
Oh, well, there you go.
This is why.
I mean,
though.
listen, he may know he effectively is a hostile witness because he's
Yeah.
got that deposition and his answers in
That's-
court are so different.
This is why
You
you,
remember that
this,
same hearing in 2017?
I remember the entire exchange.
let's hear what the answer, let's hear the cross.
Remember the following questions and answer. Question. So in your mind, for the first time, you're thinking Mr. Reeves could get punched. Answer. Yeah, I'm thinking that did cross my mind.
Well,
Good.
Well, let me ask you a question.
Your Honor, I'd ask the
well,
witness be permitted to finish his answer.
he is, I'm going to let him, but I got to make sure that that's what he said. That's what you said, right?
I don't believe that that's all that I said.
Oh, no,
I
we're
think
going
there's
to.
context there.
Okay, well. Would
You
like
just
to
said a
read
minute
the
ago
other
that you didn't say that.
Couple of sentences after?
Well, Your Honor, I think instead of doing that, I mean, the witness can explain what his answer is.
What is your answer, sir?
Ask me the question again, please.
Okay, that you thought at that moment that Mr. Reeves could possibly get punched?
I think I testified that I was paying closer attention because I thought that this could develop into something further. Initially, I
So you
didn't,
never said what
Let
I
him
just.
finish his answer, please.
initially, I didn't
Trying to
know
dodge
if
the
they
fact that
were,
he said
if
this,
the
though.
exchange between them was because they knew each other. I didn't know if they were together. I didn't know. It was only at the point where it appeared to get more heightened that I thought something could happen here. I never expected what happened to have been actually what happened, but I certainly paid attention because there was obvious tension between the two.
Well, you hadn't heard Mr. Reeves say a peep. Up until that point, you had not heard Mr. Reeves say a peep. Isn't that correct?
That's correct.
So how could Mr. Reeves be guilty of anything if he hasn't said a peep?
I wasn't judging either person.
The
I
only
couldn't-
one that you, sir, you heard was Mr. Olson, correct?
That's correct.
And the only one that was leaning towards Mr. Reeves was Mr. Olson.
Yes.
And Mr. Reeves was there quietly, not saying a peep.
Well, I didn't say that either. I said I didn't hear him say anything.
Okay,
So he could have said a lot, but I
Yeah.
didn't hear it.
you didn't hear.
Yeah,
But you certainly
can't
heard Mr.
pretend
Olson.
that
That
you-
was not a problem.
I heard Mr. Olson.
But you do see Mr. Reeves doing something important here, right? You saw Mr. Reeves trying to create some distance from Mr. Olson as he was leaning sideways. That you saw.
I don't recall that.
2,500, 7 through 13.
This has been every witness. Their stories have changed pretty significantly from 4 years ago when they did this hearing. You're muted, Steve.
This is very tricky to do. This is a very hard thing to do for defense attorneys to cross this type of witness.
Yeah.
We can talk about that next break, but because the jury is not going to perceive him as being biased. They're going to listen to his perception
Yeah.
and not see him as a hostile witness. They're going to hear him as the witness, right?
Yeah.
So how you approach
Let me
him
phrase
is
it
real
this
care. You got to be real careful.
At that moment, you're seeing now Mr. Olson's hands reaching towards Mr. Reeves, correct?
Yes.
Okay, and so tell me how Mr. Reeves's body is positioned as Mr. Olson is reaching now into Mr. Reeves's space. You would agree with that?
Yes, sir.
Okay, so tell me how Mr. Reeves was positioned, his body.
He was sitting back in his chair.
Okay, meaning, those chairs have some mobility, right?
Mm.
Not much in that back
Not
row
much
because
in
you
the
have a wall, right?
Correct.
But it has a tiny bit, right?
Right.
And so you can pull back a tiny bit,
Right.
correct? And that's what you saw.
Well, I don't know that I saw that. It's possible, but I don't know that I saw it
So
because.
this is one of the most
chairs go
dangerous
back
witnesses
a couple
for the
inches.
defense narrative,
But I
because
can
this is the guy that basically says he heard Reeves
Clearly, at that point
say,
in time,
after
Mr.
he shot
Olson
him, throw popcorn
is
in my
reaching
face, will
over.
you? Which
Yeah.
certainly
Instead of
sounds
Mr.
like a
Reeves'
malice
face.
killing,
Yes,
right?
correct?
that's correct.
None of the other
The
witnesses
theater's still
testified to anything like that.
Correct?
The theater was dimmed and dark. It
And
was,
the previews are still playing loud.
yes,
And as you see those arms of Mr. Olson's coming towards Mr. Reeves, that's when you hear the gun go off, right?
no, sir.
You didn't,
His arm came across and grabbed the popcorn.
right?
He pulls the popcorn back and then flicks it.
Okay.
That certainly looks like something that could be reasonably perceived
Other
as
than
blows
that
coming in.
movement, going with this arm towards Mr. Reeves
Yes,
and then grabbing the popcorn. You're telling this jury you didn't see Mr. Olson previous to that, maybe 8-10 seconds beforehand, trying to go over the seat, the back of the seat. You didn't see him leaning over the back of the seat then. I'm talking about 8 to 10 seconds before. You didn't see that.
I didn't see that. The leaning over of Mr. Olson was everything to do with him leaning forward to grab the popcorn.
So the gun goes off. Is that correct?
Yes, sir.
Okay. You're still standing.
Yes, sir.
And by this time, Mr. Olson, according to your recollection, must have been standing for quite some time. He never sat down, right? He was up there standing up, and right before Mr. Reeves came, while Mr. Reeves was going down the aisle, the whole
Objection,
bit.
This has been asked and answered several times.
Sustained.
You indicated to the members of the jury that you saw Mrs. Olson's hand on her husband's chest, correct?
Yes, sir.
And you believe that Mr. Olson's hands were down at his side when he was shot? Yes or no?
No.
Scribble, scribble, scribble.
We can make band music from all these noises, right? The
tell me.
judge can come in with her pen.
Exactly where you believe Mr. Olson's hands were at the time that Mrs. Olson had her hand on his chest.
What I recall was when he threw the popcorn, his hands came back to here. And then his wife's hand was already up. So it came to here, her hand would have been behind his. And then the gun rings out and his hands fall.
So his hands fall after.
That's correct.
You didn't see anything in his hands, right?
No, not at that point.
In either hand, because you had a view of both hands.
Well, initially he had a cell phone in his left hand.
That was when he was standing up,
Right,
right?
that's
Okay.
correct.
And so now his hands are down to his sides, right?
They fell to his side.
Okay. And I think you've already testified that at that point in time, Mr. Olson made that statement and then collapsed, correct?
Yes, sir.
Okay. Now, I think you also testified that you had some contact with Mrs. Olson. Is that correct?
Yes, sir.
In assisting her on various aspects,
Yes,
correct? Okay. Now, you then decide to go, I believe you testified on direct that you went into the theater, to a section of the theater where there were people milling around. And you think maybe as many as 40, 50, 60 people in that area of the theater.
Yes,
And you went to that area And in that particular area, people were talking about what happened.
People were talking. Yes, I can't say specifically. Some probably were, but I don't recall. If you asked me what they were saying, I couldn't tell you.
You can't tell me today in 2022.
I probably couldn't have told you in 2015 or 17.
Well, while you were there with those 50, 60 people, did you have any police officer that you remember coming up to you all as a group and saying, do not talk to anybody about what you saw?
I do not recall that.
Do you recall any police officer coming forward and saying, hey, all of these 60, we're going to separate and we're going to put you in a row and you're going to have 4 empty seats in between all of you and don't talk?
No, sir.
And so you were there for quite a long time, right?
Yes, sir.
And you were concerned because things seemed very disorganized in that theater as far as law enforcement was concerned.
That was a personal opinion, yes.
In fact,
Yeah,
they
that's what he
hadn't
asked.
even given you the voluntary statement forms. You had to go find some officer to go hunt something down so that you could write and the others could write a statement, right?
Well,
Hunted down like Chad Olson hunted down Curtis Reeves.
There that apparently had brought some forms in.
State stipulates that the
To go to
investigation was sloppy.
you'd write 'em up.
Okay. And so
We
you
don't
do
accept
that.
the stipulation. We want to
And
prove
then
it.
you go to
Facts
a
in
concession
evidence.
area, which is outside of Theater 10, correct?
Yes,
And there's a bunch of people there at the concession area, right? And tables and what have you. And those people were talking about amongst themselves, correct?
there was talk. Again, I couldn't tell you what the subject of the.
Well, they were talking about what had occurred, correct?
I couldn't say that.
Why not? Who got to you?
They're talking about what they're going to have for dinner after being present when a man was shot dead in the theater.
Are you saying all of the witnesses are using the word flick?
Yeah.
All of them.
Interesting. Talk about
it-
that.
At least that was your assumption.
It is very interesting.
You know, I'd object. to the
I'm not sure.
assumption.
Has the defense attorney been asking these
How
witnesses
many
whether they've
people would
talked
you
to the
say were
state?
there in that concession area?
Well, I think they've all been deposed by everybody.
Yeah, but
Yeah.
when was the last time you talked to the state attorney's
And you
office?
were
Oh, yeah.
in that group.
It's true.
And so you were there for some time, right?
We weren't there, I'm going to say 5 or 10 minutes.
Okay. And then you're taken to another room. Is that correct?
That's correct.
And in that particular room, again, people are talking about what just happened.
Again, I couldn't say that definitively.
But you think so?
No, I think it's possible. I don't know what I don't know.
And you were in there for quite a long time
Yes.
with, how many people would you say?
I don't know, 30, 40 maybe. I don't recall.
And it wasn't a real big room.
Right.
And there was no police officer that went into that room to tell you all, do not speak about this case amongst each other.
Not that I recall.
And there was no police officer that moved you into different corners of the room so that you all would not have access to each other.
Not that I recall.
Oh my, did you see him? Did you see him shoot that guy? Oh man, he didn't have any reason to do that, did he?
I
Yeah,
heard
that
it was all over
crazy.
popcorn.
Yeah, I saw his popcorn go flying. I think he threw the popcorn before shooting the guy. Distract him. Pocket corn. Ha ha. And this is the
You
idea
believed that
why the
day,
cops should have split people up.
while Mr. Reeves was seated in his seat and Mr. Olson was yelling and moving in his direction, you believed that Mr. Reeves was in the most vulnerable position, correct?
Well, just to be clear, I didn't hear any yelling, but I recall this question from previously when
Yeah.
you asked me, and it led to him being in a vulnerable position because he was seated.
Yeah.
Yes, if you're having someone over you, then yes, vulnerable position.
Someone over you.
That's a good question. I like the way he put that.
Yes, sir. Thank you.
Oh, you could end it on that. Interesting.
He just got the guy to say someone over you.
Yep.
Yeah, he's in a
Beautiful.
vulnerable position.
On several different occasions, the fence kept going back to a single word description, and the single word description was dark, and the single word description was loud. So instead of focusing on the single word, every time that
We
you
use
refer
dual
to
word.
dark,
Did you say
dim,
not
dimmer,
dark?
darkest, whatever that
Extremely
is,
dark. It was light dark.
Was the lighting condition sufficient enough for you to see in that theater?
Yes,
When we hear loud, okay, was it so loud that everything was deafening inside of this theater?
no,
And just for the sake of argument, we're hearing about different movies playing. So is there a break between different previews where it's not loud at all, actually?
yes,
And you were asked to assume, and we probably both agree it's not a good idea to assume in court. Would that be a fair statement?
I would hope so.
Okay. And so you don't know for a fact that people were in fact discussing anything about what they may or may not have seen inside the theater.
I do not.
And you were asked about how many people were in the area. Did you hear people generally just talking?
I heard some talking, yes.
Okay, but you can't say specifically what they were talking about.
Chatter,
I'm gonna
System.
object.
Could you hear what they were specifically talking about?
no,
Did you see or hear anyone get together and compare notes about what they observed in the theater?
no, sir.
Did you see or hear any people getting together to conspire to make up a story against the defendant here?
No, sir.
May I have a moment, Your Honor?
You may.
Could you just try and ask some questions without leading? Just try it.
And it's so weird. So many of the state, the state continues to elicit negative evidence, things people didn't see, didn't hear, but no positive evidence.
Word.
So since you could see so well in there, the one thing that you can tell this jury that you're 100% certain of is that Mr. Olson was standing the entire time.
Your Honor, I object. We probably done this 5 or 6 times.
Sustained.
In fact, I stipulate that it was true based on the 5 or 6 times he said it.
I don't think you can stipulate the facts like that.
May this witness be released?
I stipulate that's.
We'll keep him on standby.
All right.
Yeah, you
I
just
don't know.
stipulate
You're
to
free
any
go,
negative
but if
things
you
to
Yeah,
your
I'll-
case.
phone call asking you to come back, you'll have to come back. Okay?
Thank you, ma'am.
Thank you.
Yeah, I just stipulated about what he said to the guy before he killed him. It's fine.
I would say that witness is tough for the defense. You know, I mean, he's got to be careful because he's credible. He doesn't have a bias or anything,
A
any
perceived
stake
bias,
in it.
yeah.
Right?
Perceived bias by the jury. So they're going to be listening to. He was there. The attorney wasn't. So as a defense attorney, you have to be real careful how you question that person, and not make him as just like you're out there and you're in league with the state. I mean, that's a hard bag to sell.
Yeah, I think the approach that they've been going with is not that they're in league with the state. It's that they're just, for whatever reason, now saying something that is more detrimental to Curtis Reeves than they said previously. And they've been hammering them on those prior statements because all of them, without exception, every witness has mitigated their testimony so far from the previous hearing.
That they should be emphasizing it's been 8 years. This is a long time, and memories fade. And come at it as like you're mistaken and your memories change rather than you're a hostile witness and you're making it
Mr.
up.
Rosenwasser?
All right, good afternoon.
Hi, good afternoon.
Can you please state your name and spell your first and last name for the court reporter?
Yes, my name is Derek Friedhoff. My first name is Derek, and last name is Friedhoff, Friedhoff.
All right, and can you turn to the members of the jury and tell them what you do for a living?
Hi, I'm a
Poor
registered nurse. I work with Advent Health.
Is he the
And
only guy
back
with a
on
mask in the
January
whole court?
13th, 2014, were you a registered nurse at that time?
I was.
And were you working at the same location or different location?
At that time, it was a different location.
On that particular date, did you go to see the movie Lone Survivor at the Cop Theater?
I did.
And do you
Pressing
recall
exit
just
out on this guy
approximately
going
what
to see
time it
Lone
was that it was starting?
Survivor.
I believe it started approximately around 1:20.
Boyfriend took him.
And who did you go to the theater with?
My girlfriend at the time.
A girlfriend, Got you on that one.
Yeah.
When you arrived at the theater,
Gonna
did
peach
you,
him on
Objection,
that
Your
one.
Honor. Witness is
Say that
clearly
again?
did
lying.
you purchase tickets?
Yes, we did.
Do you remember if you went to the concession area or not?
We did not go to the concession. We went straight to the movie theater.
All
There's
right.
been a couple people
Recall
in
where it
the
was you sat in the movie theater.
Yes.
observing the
At
trials
the
have
time
been
that you
wearing
were
a
sitting
mask.
down,
Just a
do you
couple.
Yeah, that's
recall
true.
What the lighting
Look at the
conditions
audience. None of the attorneys,
It was,
none of the judge.
it was dim, but you can still see where you were walking or where you were going.
And we're in
Looks like I can
Florida.
hear
too.
him through his
concern
mask.
when you walked into the theater that you could not see?
Well, if I had that kind of
where
immune
your seat
deficiency,
would
I'd
be?
wear a mask
No
too.
concern.
Did you have any concern that you would trip and stumble and fall on people because it was too dark?
Nothing of that sort.
When you walked into the theater, could you see the rows clearly?
Yes.
Could you see people in the seats?
Yes.
Could you see the aisles?
Yes.
Was it dark like it is when the movie starts playing?
No.
All right. Did there come a point in time when you became aware that there was a shooting in the theater?
Yes.
And did you later learn the name of the person that did the shooting?
I did.
And what was that person's name?
The name of the shooter was Curtis Reeves.
All right. Did you learn the name of the person that was shot?
Yes.
And what was the name of that person?
Chad Olson.
All right. Did you know either of them?
I did not.
All right. So we'll just refer to them by name. So when we talk about it in the positioning of the theater, it'd be easier. Let me ask you this. Do you remember what row it was that the defendant Curtis Reeves was sitting in?
Yes, I believe he was sitting in the farthest row, the very far back one.
Okay. So the last row.
Yes.
Where was Mr. Olson sitting in relation to where the defendant was sitting?
He was sitting in the row in front of him.
Okay. Where were you seated with respect to Mr. Olson?
In respect to Mr. Olson, I was one row ahead to the left. So if I'm Mr. Olson sitting in this chair, I'd be one row ahead towards the left.
Okay. And then said another way, I know it's going to sound silly, is that if you looked over your back right shoulder, you would be seeing the Olsons.
That's correct.
All right. Was Chad Olson with somebody?
He was.
Okay. Do you know who that person was?
Yes.
Who was that?
Nicole Olson.
Okay. And you learned about her later on, meaning you learned her name later on?
That's correct.
You didn't know her prior to
I had no idea until afterwards.
With respect to the time that you sat down, do you remember if the Olsons were there first?
I didn't notice them or anyone till later on.
All right. Did there come a point in time when your attention was focused somewhere in the theater?
Yes.
All right. So let's talk about the lighting at that time. Is the
What a
lighting the
vague
same as what you were
question.
describing before?
Yes.
All right. And what about the volume in the theater at that time?
It varied. It depended on what was either on the previews or if there was no previews at the time. Like if it was in transition, there was nothing come out speakers. So it really varied depending on what was on.
I hate masking in the courtroom.
Did you have any-
How can the jury assess his credibility by his facial
I was
expressions
looking
with that mask on?
Could you hear?
Nobody's
what was
wearing a
happening
mask in the whole
theater,
courtroom.
even though the previews were playing.
Yes.
Could you specifically hear?
I'd
what
say he's lying just by the rapidity of his
Unless
replies.
I focused on it, not really.
Sounds completely
So
rehearsed.
the reason you couldn't hear it was
It's like a bad actor in a college play.
The reason-
Right.
Objection leading.
Sustained.
What was the
She's just
reason?
laughing at how bad the leading questions
What was
are.
the reason that you couldn't?
Prosecutor knew it too.
We're saying.
I wasn't interested.
All right. What first brought your attention to someplace in the theater?
Hey guys, was there a
I
time
heard
at a
some
movie theater
bickering,
where
coming
your attention
from
was directed
behind
in a
me on
particular
my
place?
right side.
Okay. And would
Like
that
the
be the
screen?
area where the Olsons were?
Yes.
Okay. And would that be the same general area where the defendant was?
Yes.
When you say bickering, how many voices did you hear?
I heard two.
Once you heard that bickering, what did you do next?
I kept my focus on that area because it just seemed out of the norm. And then until it went away, I went back looking at the screen.
Okay. So when you looked over, tell the jury what it is that you saw.
So when I initially looked over, I saw, is it okay if I visually show? I saw.
Billy Witch Doctor,
Chad
yes, this is
Olson,
the only witness to wear a mask
his
so
body
far.
was facing the screen, or had a cell phone out. I saw the screen illuminated, and it looked like he was talking to someone behind him.
Okay. So the way your position was his.
See if he says the word flick.
At that time.
If he uses the word flick, we're in trouble.
Screen.
Right.
It might mean something different in that community.
Could you hear what was being said?
I could hear them talking, but I couldn't hear exactly what was being said.
We have to ban Branca from the
After you
screen.
heard the talking, what's the next thing that you remember seeing?
So the next thing I saw was someone leaving from the top row, going down the staircase towards somewhere. And then once I saw that, the bickering stopped, and then I just started watching the previews again.
Okay, so once you saw someone leave, it was quiet again.
Correct.
Did you see that person come back?
I did not.
Did something bring your attention to that area again?
Yes.
And what was that?
It was the bickering.
It'd be funny if after he testifies, he takes off the mask and he's
Did it
got
sound
like
like
clown
the-
makeup on underneath.
Sound like the voice of one person or two people?
Love
The
me.
prosecution made him wear the mask so he wouldn't look completely insane.
Could you tell if they were male or female?
I could tell they were male.
Both of them?
Yes.
I'm a clown nurse.
Like Patch Adams, right?
And prior to that, when one person had left, it was quiet.
That's correct.
When you heard this bickering again, what did you do?
So it caught my attention. So I continued to look over in that area again where the bickering was coming from.
Okay, and what'd you see?
So at that point, I saw the outline of a person stand up and then say something along the lines of texting my daughter. There were some other words I really couldn't understand what was said, but it was like an annoyed voice, like texting my daughter.
Okay, and who was that person?
That was Chad Olson.
And were you looking over in that area then at that time?
I was.
And then what'd you see happen next?
So almost immediately after that, I heard something. It's like something being crumpled, and then I saw like movement of something being like something. Can I act it out? Is it okay?
Sure.
I saw someone stand up, say something, text my daughter, and then like they reached to grab something and then throw it.
Okay,
So there was something being crumpled. I didn't know what it was at the time.
okay, and then what happened right after that?
Immediately after that, I heard someone say something along the lines like it's like it was mumbled, like they were mumbling. It said something like "show you," followed by like throw popcorn at my face. It was like more like declaratory, like out of anger.
Okay, and was it the same voice that mumbled and said throw popcorn?
Yes,
All right, so it was, the mumbled part was from the same person that said throw popcorn in my face.
that's correct.
At any time prior to the movement that you indicated, and you heard the crumbling,
Correct.
did you hear anything that sounded like a life or death struggle happening?
I did not.
Did you hear anything that
Do you
would
know
lead
what a
to
life or
believe
death
that the
struggle
defendant
sounds
here
like?
More of this negative
violated?
evidence.
I did
Yeah.
not.
Did you hear anything from anyone yelling words?
Did you hear two lesbians arguing over coffee?
Anything that would give you
I would have objected to
something
that
going on?
question. It's
I
life
don't
or
hear
death
anything else.
struggle is not the
Did you hear
self-defense
anything
standard.
physical, like if someone were to try to jump over a seat in the theater and the seats would pop up? Did you hear anything like that going on?
Nothing of that sort.
Did you ever get the impression prior to the crumpled sound that you heard?
These are
that
also
there was a
leading
struggle
questions.
happening?
Right.
Other than that, no.
Yeah. Life or death struggle is
Did
not
you ever
that.
see Mr. Olson throwing an object, a cell phone, anything at all prior to?
Nothing. I only saw that one movement of something being thrown, the initial,
Okay. And that was the crumpling.
the crumpling. Yes, sir.
So he didn't see the popcorn being thrown. Some other thing being thrown. The crumpling.
Yeah.
Oh man.
Did you hear the sound of the gunshot?
I did.
All right. And what did you see after that?
So once I saw the actual gunshot, I saw the muzzle flash and I heard the gunshot. My initial was focused on that area, and then I looked away to see like where the exits were in case there was a continuous shooting. So I looked away, see where the exits were at, looked over, and then I saw someone collapse.
Okay. What'd you do when you saw that?
I waited a couple more seconds because I wasn't for sure if someone was going to continue firing. And then once I felt like it was safe to go, I went to go assess whoever was shot.
Okay. And then who did it end up being that you were assessing?
Chad Olson.
So tell the members of the jury what
So it's
it
your
is that you
fault
saw
he's
when you
dead.
walked over there.
Yeah.
So my initial reaction was, of course, I
What kind of
wanted to make
nurse
sure
are
he was
you?
safe
Couldn't
before
save
I
him.
went over to check on Chad. So once I saw that there was no more shooting and that there was no more any type of violence occurring, I went to Chad's side. It was still a little bit dim. I saw blood coming from his shirt, and then at that point, I called 911.
Did you lift up his shirt or look at him?
I did, yes. So I initially looked for an exit wound. I didn't see one. I just saw the initial entry wound. And then once I saw blood starting to pool, I lifted the shirt up, took my shirt off to apply pressure.
Did you do anything else to try to?
Because
help him?
I'm ripped.
At that point, I was on the phone with 911, speaking with the operator, and I was trying to assess Chad's condition while at the same time speak with the 911 operator.
And what were you seeing from Chad?
So at that particular moment, Chad was still breathing. He had some like involuntary movement, and it sounded like he was trying to breathe. And at that point, I was just trying to keep an eye on him, make sure he, wouldn't go into either shock or get worse. So we're just holding pressure while I'm on phone with 911. And as the 911 call progressed, I noticed that Chad's pulse started to decline, and I could no longer feel a palpable pulse on his wrist. So where I was at, I wasn't in a spot where I could do CPR properly. So there was someone at, I believe, at his feet, and I asked if anyone could do chest compressions while I was on the phone with 911.
So there are other people that were helping you?
There are the people that were helping me, yes.
Was there a point in time when deputies from the Pasco County Sheriff's Office arrived at the scene?
Yeah, about 15 or so minutes later.
Okay. And were you still in the theater when they came in?
Yes.
Was there a point in time when you were given a piece of paper that some people call a written statement to fill out?
Yes.
Did they give you any instructions about how to fill that out?
They just said just fill it out. There was no clear, concise way to fill it out. They just said just fill out what you saw, and that was pretty much it.
Okay. And did you assume that at some point you talked to a detective or a
Yes.
deputy? Did you in fact talk to a detective or a deputy?
I did, yes.
When you were in the theater, did you talk to anyone other than law enforcement about what you observed?
No, I did not.
Did you get together with anyone to conspire to make up a story?
No, I did not.
I'd object to that.
Yeah.
Are you testifying to what you personally observed
Yes.
and what you personally heard?
Yes.
Are you being truthful? You're not a
Right.
liar.
First question on cross should be this girlfriend. She's from Canada.
Did you ever?
How long
hear
have you been dating your
anyone
internet
yelling,
girlfriend?
No, or whoa, whoa, whoa.
You guys
That's
are
exactly
funny.
right.
Oh my
You have
god.
to reinflate her at any time during the movie.
Your girlfriend's name isn't on the witness list. This is very strange. We do have a Todd, though.
You have a moment, Your Honor?
Peter says, I need to constantly remind myself that fact witnesses are not in the courtroom and have not heard prior testimony. That reminder helps overall credibility. Is it more natural for jurors? Is there any instruction on it?
Well, they're not in the courtroom, but we're not in the courtroom either, are we?
No, but he's
Well,
saying that
they don't-
that he's reminding himself that the people who we are watching all the testimony, but the jurors who are coming in, they haven't heard the other person.
We don't
give
we
their
don't know
testimony.
that. For all we know, they're home watching on TV.
Well, that's
No,
true.
but didn't they invoke the rule when they first started the case? There's
I'm
a
sure
rule
they've been told not to watch.
right, but yeah, generally they follow that. I don't know. What do you think?
And of course, we already had that 2-week self-defense immunity hearing.
Right, and the news media. This is such a high-profile media case, but usually they're not
When
watching
you were in the theater, was the
testimony.
only thing that you heard Mr. Olson say was something about texting his daughter?
That's correct. That's the only audible thing that I heard.
Okay.
Like I said, he was
Oh,
talking
audible.
prior, but I could not understand. what
So he
said.
was saying other things. You
You
just
didn't
couldn't
hear
hear
any
it.
loud threats towards anybody else?
I did not.
I don't have any further questions.
I don't think this witness is too bad for the defense, though. What do you guys think?
Go ahead, Mr. Michaels.
I guess we'll find out now. Mr.
Yeah.
Bowtie is up.
What did he? Yeah. What did he say? What did he say at the last hearing that isn't coming out right now?
Right. Here's all the depots. Have you
Look at that.
changed?
They
your
always walk
testimony?
up. They got the giant book of death. It should just be labeled Book of Impeachment.
Yeah.
I have before me all of the taxes you've ever filed in your entire
Right,
life.
at the time,
Volume 1 of 10.
January 2014, January 13th, you were a registered nurse
That's correct.
and you worked in trauma at the time, right?
That particular time, no, I was doing neurology and orthopedics.
You worked trauma previously.
Previously, yes, that's correct.
And you're pretty exact because you actually purchased your ticket at 1:16 p.m. that day, right?
That's correct.
And you actually entered the theater, you remember, at 1:19 p.m., right?
Yes, because I looked at my cell phone prior to getting to the movie theater.
And so what happens is when you get in there, you describe where you sat and your then girlfriend, Jenny Monero, was sitting
I was
next to you.
checking my grinder.
She was to your right.
I believe she was to my right.
And so when you're looking back at where Mr. Olson and Mr. Reeves are, and Mrs. Reeves and Mrs. Olson, you have to lean back in your seat, right?
Yes, the seat reclines a little bit at the movie theater, so I was able to look past behind her head and see what was going on behind me.
All right. So you answered my question. I was going to ask if you have to look behind your girlfriend's head to look back up, right?
That's correct.
I missed it. Did he use scare quotes when he said girlfriend?
It's just,
Now, what you heard that was audible to you was loud enough to be concerning to you, correct?
It caught my attention.
And it was concerning to you.
It seemed out of the norm, so it caught my attention.
Okay. So are you telling me that I'm mischaracterizing what you thought? You don't think it was concerning at the time?
It caught my attention. Like it just sounded like two
He's
people,
already
bickering,
flipping to the
arguing. Like,
page
it just seemed like
where he
out of
said
place.
concerning at the previous hearing.
I'm asking you a direct question.
Objection, asked and answered.
no, it's not
Page-
us.
2477, line 23.
Like if you
Completely
just see his-
ignored the objection.
If you see his fingers go to the page in the book, just say, you know what? You're probably right.
At this point, they could just bluff it, right? Just stick your finger in there anywhere.
Sorry, 2427.
I love their use of this stupid binder. They have to special order that thing. It's like a 4.5-inch binder.
Lines 20,
Every time this guy sees a 3-ring binder, he'll have PTSD for the rest of his life.
it's like line 23. Okay. This was a hearing back in 2017 that you were present for and testified in. Remember that?
I recall being here at some point in the past. I don't
Okay,
remember
the same
exact date.
courtroom,
Okay.
right?
I don't know if it's the same courtroom. I really don't know which, if it was A, B, C, or D
But he remembers to the minute when he walked into that theater.
in the past.
8 years ago.
You remember it 2017?
I remember the year. I don't remember what date I was here.
Okay, that's fine. So you remember in 2017.
Okay.
There's a court hearing like this where you face the clerk and raise your hand and tell the truth. You remember that?
I'm probably sure I had to.
Well, you remember that you walked into the movie theater at 1:16 that day.
Called it.
I didn't walk in the movie theater at 1:16.
I'll overrule.
You bought your ticket at
I
1:16.
bought the ticket at 1:16.
And so
This
that's-
demeanor is much better. The cross
Is
demeanor
there
is
a
much
reason
better.
why you remember when you bought your ticket, but you don't remember whether you faced the clerk and swore to tell the truth in 2017 in this courtroom?
Because I still had the movie stub, the movie ticket stub.
How do you remember that you walked to the theater at 1:19? Does
Because
that
I,
somehow indicate on the movie stub?
because I looked at my phone prior to going to the movie theater. I wanted to make sure that we didn't miss the previews.
But you
Did
look at your phone.
calendar before
Right.
the hearing in 2017?
Here's how you know that whether or not you missed the previews. You walk into the theater
So
and
you're
see if the
saying you
previews are
don't
playing.
remember whether you took the
Your
oath to
time is
tell
not
the
going to tell you
truth?
that.
I said I recall, I just don't remember what the date of taking the oath was.
So now, because I asked you before, so let me just ask you the question again. Do you remember facing the clerk, raising your hand and swearing to tell the truth?
Yes.
Okay.
The past hearing must have been very confrontational with some
The
of these
context
witnesses
is-
because they kind of seem standoffish to
I'll
the
start
defense
at-
immediately.
Line 1, question. When
Lie
you
one.
first heard
I
the
mean
bickering,
line.
could you hear what was being said? Answer, line 3. Most of it was inaudible, but at one point,
Your Honor, I would object. You're going beyond what your question was. I think your question is 20 to 23 or 20 to 25.
Why would you
I'd
object
be
to
happy to
this?
go to that section. If I'm asked to put it in context, then I'll do that, Your Honor. It's not a problem. Page 2427, line 20, question. And that's at the hearing. And you indicated that you were kind of leaning back in your chair and looking to your right. Answer, that's correct. It was loud enough to raise to be concerning to me. Right? So you were concerned.
Concern, I would agree.
You didn't 5 minutes ago. Could have skipped all of this.
You might be right about
That's
the
when you saw the
past
light of the cell phone.
hostility.
Is that right?
Yes.
And you showed the prosecutor, you kind of gave an example.
Yeah, this
where
guy
you
looks
were
like Daddy
holding-
Warbucks
showed in
from
your right
Annie.
hand a cell phone.
That's correct.
So do you know whether it was in Mr. Olson's right hand or you just,
So when I saw the cell phone,
Right.
it was kind of like just hovering. So I just saw like this a cell phone illumination, and I just saw Chad talking to someone behind him.
the question is, you held up your right hand because you wanted to do a physical demonstration for the court or whomever. You held up your right hand. So is your testimony it was in his right hand or do you not know for
I
certain?
believe it was in his right hand because I saw the cell phone screen. So it'd be kind of hard if it was in his left hand for me to see that illumination.
Okay. Did you see it in his hand physically?
I saw his cell phone. It's not going to float magically. So someone would have to be holding it.
Okay. So did
Are
you
you
see
sure?
this? My
I
question
saw
is
the cell
again,
phone.
Mr. Friedhoff, listen, we need to be able to allow me, number one, to finish asking my question
Okay.
before you answer. This lady here takes down every word on that machine. She cannot take it down if we're both talking, okay?
Okay.
Thank you. And so my question is, did you physically see it in his hand?
Yes.
Okay. And did you physically see it in his right hand?
Yes.
Okay. And that's your sworn testimony.
That's my sworn testimony.
Now, during the second preview is when you heard that second part of the bickering with the texting my daughter sort of thing, right?
That's correct.
The second preview was, I think, sabotage. Do you recall that?
That's correct.
And that's when you described this whole, you heard the crumpling of something, right?
At some point, I heard the crumpling, yes, but it may not have been during that exact preview. I just
Okay.
remember the second bickering occurred during the second preview. They didn't last the entire, or it wasn't like from the start, the beginning of the second preview. It occurred during the second preview.
Okay. My question was to you, did that occur during the second preview?
I want to say it was towards the end of it.
Question, listen closely to the question. I'm not asking you when or in what part of the preview. I'm asking you, did that crumpling that you described happen during the preview?
I believe it was after the preview. The bickering occurred during the preview.
The crumpling that you heard, I'm talking about the
The
crumpling,
crumpling itself, okay.
happened during the preview.
It happened after the preview,
After the first preview,
after the second preview.
Oh my God.
the second preview is over,
Oh boy.
right?
Correct.
What are we doing here?
That's correct.
Now, when you look back in the row, what you see is you can't actually make out Mr. Olson, but you see a silhouette, right?
I see a person standing, but I can't make out what they were wearing.
It appears to be a silhouette to you.
More of a silhouette. That's correct. An outline.
And then what you see is you see somebody going forward with full momentum.
They were reaching for something. It looked like they went to go grab something, and then I saw the motion of something being thrown back.
And when it gets
It
thrown
said
back, you
thrown,
see the person
no
at
flick.
full momentum.
They were just not. When I say full, I say their arm at full moment. I don't see their full body at full momentum. I just see something being thrown.
The arm is at full momentum.
Yes, they were throwing something.
Okay, let me ask you the question again.
Well, Your Honor, I object. He answered exactly what he was being asked.
The question is, it's a yes or no question.
Well, I object. If the witness needs to explain, I ask you to have the ability to explain.
Sustained, move on.
Your Honor, cross-examination, I can call for a yes or no answer.
Yes.
I disagree with the prosecutor.
I would object.
We know you would object. You
So
just
describe
did.
then how you saw the popcorn being thrown.
I saw the person standing, looked like they reached over to grab something. I heard something being crumpled, and then it was
Defense was right
this
there, by the way. The
forward
judge
motion of
was
something being
wrong.
thrown back.
Prosecutor was wrong.
And do you have any other description of how that was done?
As far as they stood up, I heard texting my daughter. And at that point, I saw someone reach over, heard something being crumpled, and then saw movement of something being thrown back at.
Okay. Page 2451, line 20. Same hearing, question. Then the third thing that you observed is a movement or a motion of something being thrown. Answer, your answer. Full forward momentum.
Okay.
Well,
That's your answer?
well, here's my objection. I would ask that you read.
Your Honor, if he's gonna do a speaking objection, and we're gonna have,
Okay.
Let's go.
I don't know what the legal objection is at this point.
Well, please, read the entire sentence.
You want to come up?
Yeah, Your Honor, I know that the prosecution likes to do cross-exam on direct, but when it is cross, I still get to do cross, Your Honor. I get to ask yes or no questions and demand yes or no answers. Branca, you're muted.
Yeah, the cross didn't get used up on direct. It's not how
I
it
want to make
works.
sure I read your entire answer, okay? So let me ask the question again. I'll read you the question. You're under oath. You're in sworn testimony during a hearing. Question. Then the third thing that you observed is a movement or a motion of something being thrown. Answer. Full forward momentum. I couldn't see what was thrown, but I saw movement of something of like an arm reaching out and then heard something impact, right? So the full forward momentum that you're talking about.
You heard
right?
something
So
impact.
the arm is going back.
I didn't see a pitch.
You don't hear popcorn
It's
impact.
Full forward momentum.
Full forward momentum is you just see something moving forward
Well, why is it full forward momentum?
because it was full. It wasn't like it was done. It would look like someone reached over,
It's another
grabbed,
band name.
and then thrown
I saw Full Forward Momentum open for Led Zeppelin in 1974.
to throw something.
When
And
every
so
answer is
full
a
meaning
progressive
what?
rock
Like,
band.
Let's say it was, what's slow, no momentum, half momentum?
Maybe
full
no
Saw
momentum?
Full Forward Momentum.
Dad just
Open up for
grabbed,
back that thing up.
thrown,
All right, so not a flick, in other words.
not a flick.
Not a flick. Oh my God.
Now let's talk about some of the things that happened afterwards. Now, before the shot rings out, you hear
Shoot me, Flicka.
Hear something to that effect before the shot.
Something along the lines of show. Sounds like it was mumbled. Mumble is hard to
Flick
understand.
me,
It sounded like
Binga.
show you, throw popcorn at me, and the throw popcorn at me was more out of like it was a raised voice, and it sounded like it was out of like anger,
Okay,
and annoyance.
and then the shot.
I believe the shot came as he was saying that.
Okay, so Mr. Olson throws with full momentum. In this case, we know it's popcorn. We didn't
Okay.
know what it was then. Into Mr. Reeves' face, right?
I didn't know where it landed on Mr. Reeves' face.
Okay. Towards Mr. Reeves. Teach you to throw popcorn at me, then bang, right?
I heard show you, throw popcorn at me, and I believe he shot while he was saying that.
Okay.
So I heard show you, gunshot, then after that, throw popcorn at me.
All right, let me ask you this question.
After he shot him, he blew the smoke off his
Again,
gun and said,
you
roll
know
credits.
exact. This is a court of law.
Okay.
Testifying as a witness. You're sworn to tell the truth. It's a truthful answer if you don't know the answer, or if you're not sure of the answer. You're telling me you're sure of the answer, so I want to know what the answer is.
Okay.
Did you
Is it
hear
set
the
up?
statement regarding I'll show you or to throw popcorn at me before the shot or not?
It was at the same time.
So it wasn't before the shot.
It was maybe a second difference. One, it was so close in time as far as when it was said and when the act occurred. It's really hard to recall exactly. It was maybe a half a second or a second within each other.
Okay, I'm concerned because I'm a lawyer, and so I don't want it to seem like I'm picking on you.
Okay.
My concern is I'm asking a question and I'm not getting an answer.
Your
I
Honor,
want to know-
give the best answer he
How do you know that?
No, no, no,
Fuck
no.
off, prosecutor. Oh, I hate that guy. God, I would want to.
Your Honor, we're happy with his non-answer.
38 Lines 23, 20, let's see, lines 16 through 23.
Completely improper objecting by the state. That is not the way to properly object.
I'm sorry, that's 383.
That's just whining in court.
It's like objection in the colloquial sense. Your Honor, we find that objectionable.
Right. I don't like what he's saying, Judge. Stop him.
Mom,
Robert-
Fino's being mean again.
Robert Simpson says cutie pie on the stand. Yummy, yum, yum to me.
That's one. Let's start at the 383. That's fine. 383, lines 16 through 23. You remember the bond hearing? That was February, about a month after you were at the theater that day. You remember coming to court then, soon after that?
That was at the office upstairs, correct?
No, that was a bond hearing, again in court, right after that, within weeks.
Okay, I don't really recall the time, but I remember coming in for something along those lines, yes.
Well, do you remember having a court hearing with a judge and everything?
Is this the same one before as the one you described? Like coming in to testify? Is that
Yes.
This
Yes,
is actually good questioning in a weird way. This guy's memory is not credible at all. And they tried to bolster the credibility. Oh, you remember the exact time you bought your ticket. You remember the exact time you walked in the theater. Oh, yeah, I looked at my phone. This guy does not remember legitimately, apparently, going to court hearings, which would be major events that he had to be
Or he was
bored
sworn.
at.
Yeah,
for
he was sworn
hours.
in. Most
Yeah,
people will remember being sworn in. It's a notable event in their life. It doesn't happen very often.
And cross-examined by a bald asshole, right? Like that happened at the other hearings too.
But
You remember 2014, the last time I crawled up your ass?
But I do think this guy's demeanor, the defense attorney's demeanor, is a lot better than it was on that last one.
Okay?
This is the
I think
way
that was
he
the other
should be
guy,
framed.
wasn't it? It was the other
Question.
defense
Other
attorney
guy,
on the
yeah.
other one.
The
Oh,
one
what?
that
Confusing?
tribute to Mr.
For
Reeves.
the Mr. Clean
That you
twins.
indicated it was something like throw popcorn on my face was after the shot or before the shot? Answer, before the shot. Question, so before the shot, you hear him say, throw popcorn in my face and then the shot? That's correct, right? You remember saying that?
I remember saying something along those lines. That's correct.
Those exact words.
If that's what the statement says, that's probably what I said.
All right, let's talk a little bit about what happened in the theater that day. Now, after, first of all, after the shot rings out, you eventually make your way towards where Mr. Olson is.
That's correct.
When you get there, there's already a gentleman that's applying compression to Mr. Olson's chest, right?
It was dim as far as I couldn't exactly see what he was doing, but there was someone at his side.
Okay,
I think he was applying pressure over his shirt, but I don't, because his shirt wasn't up.
okay, well, you don't remember exactly what was happening, right?
I just remember someone being at his side.
Pardon me?
I just remember someone being at Mr. Olson's side.
Did you see somebody actually putting their hands on Mr. Olson's chest?
I can't recall.
All right.
This witness is doing pretty good, though, I gotta say. For his lack of memory, he's being pretty calm. This is typical. This is a typical witness, wouldn't you say? I mean, he's knows certain things. He doesn't. He's trying to be.
Yeah. Oh, and after 8 years, I mean,
Yeah.
I'll show you something would help you refresh your recollection.
Oh, here it comes.
Okay, deposition, page 60, line 25.
the only problem I have is this idea that he doesn't remember these court hearings. It's like, well, do you do these all the time? Because most people remember something like this. I was part of this thing. And again, he watched a guy get shot. That's a trauma. And then every time he goes into court, it's got to be associated with that. I'll call it a trauma, but I mean, it's this event that it's a big thing. It's a big imposition to be dragged into court and have to sit there for hours waiting for your name to be called, only to be interrogated about this thing that you saw and you didn't want to see that. You just wanted to watch a stupid movie.
Well, the problem is that they're not used to testifying or being in court.
Yeah.
So, it's like they get rattled. They're like, well, I'm not sure. And I got to answer. But he's doing pretty good. I got to say, for a witness, I'd like to have him on my side for the state. I mean, he's doing pretty good. Although this defense attorney is prepared to cross, isn't he?
The next page, please. Okay?
Just
Okay, read
read
the whole page or
To yourself.
To yourself.
okay.
Sword and Scale says, Nick, I got it. The ultimate grift. I'll live stream your live stream of Law and Crimes live stream of the courtroom shared media live stream. I'll make it transformative by chiming in every 5 minutes with "that's dumb" and then sit back and profit. I dare you. I double dog dare. I will strike your channel twice. Strike you like you struck at my heart.
Now, just to be clear, there's 2 bald defense attorneys.
Yes.
Okay.
Yeah, there's different. One is
There's
a bow tie
bow
man.
tie.
Yeah, and the other one is a long tie. C. Neal says his girlfriend always drives, and most times Joe Logic sits in the back seat because he's kind of like a Labrador. He's just happy to stick his head out the window while his wife drives. And
Now you're
Scarlet
able
Hawk.
To look at that deposition.
Thanks for the donation.
You remember now there was somebody else there attending to Mr. Olson, right?
Yes, after reading that, I agree with that.
A gentleman in his 30s.
I think maybe 30s, 40s. He was older than me.
Okay. And at the time you were 20 something?
I was 23 or 24.
All right. And that gentleman, did you know that that was Matthew Reeves, Curtis Reeves' son?
I did not.
At any rate, you took over from him. Is that right?
That's correct. The chest compressions that he was doing didn't seem adequate.
All right.
Were yours?
And so what happens next after you're finished with that, at some point, police take you to a room and swab you for DNA and kind of process you a little bit and have you clean up, right?
Yes, I believe it was the like activities room near the concession stand.
Okay. And I know you talked to the prosecutor about giving a statement, but what happens in between is that you are actually taken with a group of other people, or at least directed to an area down by the front of the theater where the movie screen is.
Yes, I recall I don't know if it was a detective or a police officer. They told us to wait in an area here and don't talk. I remember they said, don't talk about what you saw, but you can like just hang out in this area.
Okay, and they may have said that, but the truth is that you actually heard people talking to each other about this, about what happened.
I heard someone say out loud said something like they were brave about the people who went in to help. But other than that, I can't recall anything that was said other than that.
Okay, let's talk about that. So when you got there, they were talking to you and your girlfriend, Jenny Monero, at the time, and they were saying, you're brave, you're a hero.
We were away from the group. I remember seeing maybe about 6 people in the group. And then there were other couples that were kind of like to themselves away.
Okay, and so your testimony today is that you don't remember whether other people were talking or exchanging views about what happened.
I can't recall what they were saying.
The question again, we'll get to that second part. The question is, do you recall people as you were in that group waiting for police to interview you? Do you recall people exchanging views of what happened?
No, I do not.
Let me show you your deposition. Maybe that will refresh your recollection. You think that sworn testimony would help you?
Sure, visually it would help.
It's why it's so important to do a good job prepping as a
Page
defense.
71,
Because
will direct you to.
Scar said, no one ever said anything. And then now they're going to show, actually, back then, you said someone was talking to people about the
lines
events.
9.
Yeah, these defense attorneys are very well prepared. And they definitely did their homework and they're ready to go. So that
And this is
notebook,
crazy because it's not just the notebook and the preparedness there. They have to know where to like do this in that notebook. They're turning in, they've got a plan for all of these questions. It's really impressive.
yeah, they did a good job. That's a trial notebook. A trial attorney should prepare a trial notebook before every case like that. That's where your time crunches you're talking about. That's where time crunches can come in.
Okay.
When you've got a team like they've got here, maybe Mr. Funderburk is prepping the book. I'd like to think so, because they've obviously got they know their case. And that's really
So
impressive.
you will agree with me that people in that group were exchanging views about what had happened, right?
What I heard from the group initially was they said that the nurses were brave about what happened, and that was it. I don't know anything else other than that. I didn't hear what else was said.
Okay, you read your own testimony.
I did.
So now you remember?
I saw what I said, but I don't know what else was said other than that. So
Then what?
other than those nurses were brave.
Okay, so when you say that they were exchanging their views about what happened, you were talking there about nurses being brave, right?
That's correct.
Okay. And nothing else.
I can't recall anything else
What
that
a
was said
weird
other
way
than
to
that.
say nurses were brave
If you can't
years
recall,
ago.
let me try to refresh your recollection again. Same
Good.
deposition, page 71. This time go to lines 1 through 5.
Okay.
So now you remember that you heard people talking about what they observed, right?
I recall, other than that the paper that you provided for me, the only thing I recall was talking about the nurses being brave.
Okay.
I don't recall that part of the conversation, but if it's documented, it's documented.
All right. You deny it?
I'm not denying it.
So you agree that what you said was that,
Object, he's already asked and answered this.
okay,
No, he didn't say that. That's
Yeah.
Judge, I'm asking, we're talking about what he said.
yes.
What
Thank
he
you.
said is that the people were talking and what they said
you
was,
got
I
that
think
one
it was
right.
over popcorn, something like that, right?
Okay.
Did you say that?
If that's what's written down, it's what I said. I don't recall saying that. I mean, I can't remember saying that, but if it's written down, it's written down. I must have said it
You remember walking into the theater 119?
because I looked at my
I
phone.
object, this is an asked and answered.
Sustained.
You don't remember giving that sworn statement because it's different?
I didn't say it. I just don't recall exactly everything that I said.
So then to say that the only thing people talked about was that you were a hero is not true. You don't recall everything,
That's
right?
right. That's from today's perspective. The only thing that I recall, what you asked, is about the nurses being brave. That's all I remember.
And then now that you see your statement. now you-
Self-glorifying
you see there
statement.
were other
Oh
things.
yeah, he remembers that. That's good.
All right,
I
let's talk
remember
about
being
something
called
else.
brave.
Now, once you're there in that group, people are obviously talking about what happens. You hear the word popcorn, you give a statement to police after that, right?
Okay.
Right?
And then whatever was said, it didn't change my views because I heard and I saw what I experienced.
You gave a statement after that. That's the question.
Yes.
And then when you're walking out of the theater, you and Miss Monero, one of the detectives introduces you to Sheriff Naco, right?
Okay. I believe so.
What are these
You
names?
remember that?
Dude,
I'm
so
not
based, he
police
dates
officers. I don't know-
cryptocurrency.
I can't recall what Sheriff Naka looks like.
You remember shaking his hand and introducing himself?
I honestly, I've met several police officers that day. I really don't recall.
Okay, so you don't recall whether is what you're telling us. You don't.
Yes, I spoke with several police, law enforcement. I can't recall who I saw and spoke with.
All right. Do you recall this then? Sometime after that, you get a communication from the sheriff's office. They want you to come to receive a plaque for heroism.
Okay. I remember that.
Do you remember that?
Yes.
Oh, he remembers that. Yeah, of
And you
course.
received the plaque, right?
Okay.
Well, did you receive the plaque?
I did.
Okay,
Yeah.
it's not yes.
Yes, that's great. I'd say, yeah, I got a plaque for heroism.
And
All the
plaque says
statements
something
and
to
things
the
that he
effect
remembers
of,
are about how he
Yeah.
was cool that day.
Right.
for your brave, quick thinking in aid of another person in the event of a life-threatening situation, right?
I believe that's what the plaque says.
And I imagine when you made the acceptance speech, you said,
Do you polish that plaque every day?
I don't deserve this. There was somebody there before me. Did you tell them that?
I don't recall saying that.
I don't think this is great cross. So you're saying you were rewarded for being a
Did
hero.
you tell anybody that there was?
Is that a
something
good
there for you
cross?
helping this man?
I can't recall that.
And so now you receive a plaque from the sheriff's office. So really you're kind of beholding to the sheriff's office and state attorney's office.
There we go.
aren't you?
I don't know about
Can
doing
you-
this, but
can you
okay.
phrase that,
I don't
please?
know.
Not understand the question?
No, I'm just trying to say what you're trying to get at.
I don't have any other questions, Jim.
I don't know. I don't know about that
That
one.
was a gambit.
Yeah, that's
Mr. Olson,
high
look
stakes
around.
gamble.
Or let me rephrase that. Where were you working on Mr. Olson?
So when I initially went over to Mr. Olson, I was at his head side. Sorry, I was at the top near his head.
Okay, and where was that located? Where was Mr. Olson's head?
Mr. Olson, if the aisle, if the stairway is to the right, his head was towards the middle, like pointed towards the middle part of the aisle.
Was he on the ground?
He was on the ground,
Completely on the ground?
completely on the ground.
Because during cross, you mentioned that it was dim. Was that because he was on the ground?
I just think it was just the lighting conditions.
Because he was on the ground?
He was on the ground, yes.
What?
Because at that time, I don't think the full house lights were up yet.
Don't you think this is a little beating the dead horse? I mean, this witness has been on the stand way too long.
Yeah, this is not that big of a deal of a witness. Also, just let him.
He says what
dim
he
because
says.
he's on the ground, right?
I
Yeah,
think
because he
you-
was on the
you
ground.
answered this on cross, but when you made the statement either before or simultaneously with the shot about throwing popcorn on the face, are you, because I think this might have been the question on cross, are you making that up because you received the plaque for helping save Chad Olson's life?
Objection,
No.
that's the problem.
Well, that was what the implied. Were you making up about the popcorn
I did not
because
make
you
that
saved
up.
Chad Olson's life?
I did not make that up.
Or trying to?
I heard those exact words. Throw popcorn at me.
And then you were asked whether or not you were aware that someone else was doing CPR. You remember that question?
Yes, because I remember when I was on call with 911, someone was doing, I asked someone to do chest compressions.
Okay, here's what I'm asking you. Was it important to you to look around and see how many people are helping you and maybe get their name? Or was it more important to help save Chad Olson's
It was
life?
more important to save Chad Olson's life.
I don't have any further questions.
Thank you. May this witness be released?
I'll be keeping my standby.
Okay. Mr. Friedhoff, you're free to go, but if you get a call and they want you back, you'll have to come back, okay?
Okay, thank you.
Thank you.
Thank you.
That last question by the defense was a screw up. He
Yeah,
shouldn't
I
have done
think
it.
so. I don't think that was a good move.
Yeah.
But this witness isn't the worst witness for the defense, though. You know, there's no need to hammer on him like they were hammer on him. I mean, wouldn't it be better to say, wouldn't it be better to sort of like to contain his testimony? Like, okay, but you weren't witness to everything. You didn't see
Okay.
everything, to allow for the
You may.
possibility of other interactions that he did not witness, right? I mean, instead, they're trying to make him into a liar, and I don't think he comes across as a liar. In fact, you just made him out to be a hero, right?
Yeah.
I
Yeah,
don't
that was
know.
a weird strategy there at the end. I mean, they were going for "you're not a hero, you were bought," which is
I don't
plaque's
see it.
not buying many people. I don't
No.
know.
I think it makes you look good, and I think he came across pretty good, even if a little bit odd in whatever ways that Andrew is saying.
Lengthy, so don't worry.
Up your mic's off, Andrew.
Your mic's always off, Andrew.
I'm not implying anything.
You're not. What, Trudeau's not Fidel Castro's son?
What are you talking about? Of
I'm
course
not
he is.
implying that.
I was wondering though, maybe this guy's girlfriend is actually the cop with the crazy eyes. I mean, they have the same barber.
Could
Oh,
be,
gee.
yeah. Could be.
Andrew's got zingers, just endless quiver, full of zingers.
They come out rapid fire.
That was a lot of hammering on that witness, and I don't know how much it really got anywhere. I don't know. I'm very that one wasn't the greatest, I don't think. But I am impressed by the defense attorney's preparations. I mean, they really know their case, and they've got every witness lined up exactly what they should say, which is what a good defense attorney should be on top of it. And I'd put that, I'll tell you that. We've done that. Public defenders do that, and really good ones. We have ours that do that. But having a team like what they've got right there, you've got to have a team to be able to put that together, or
Oh,
one
yeah.
really great attorney. I mean, that they've clearly, they're working together. I mistook the two bald defense attorneys, though. I thought there was one. I'm like, this guy's completely different.
To
Switching from-
Odyssey, I don't think I said a plaque doesn't buy people. I said a plaque doesn't buy me. Right? Maybe I said people. I meant me because I'm selfish.
All right, at this time, stay with us.
All right, thank
Oh,
you,
state
Mr.
rest.
Rose.
Whoa.
Whoa, state
Wow.
rests.
Ladies and
Wait, did they
actually,
disprove self-defense beyond a reasonable
I
doubt?
was gonna let you go take a recess, but
I don't think so.
I think we'll,
Are you going to call it for the day?
the attorneys and myself will have some work to do.
No, this will be JOA argument matter.
Rest by the state, so good time to let you go, correct, for the day? That's-
Whoa.
no? Okay.
Winner.
All right, so
Good.
I know it's early for you guys.
They're going to make a
but,
motion
it
for dismissal.
Really is the best use of your
right?
time.
I would
Well,
think.
it's a JOA judgment of judgment acquittal, but it'll be denied because that's
Yeah.
light most favorable to the state.
It's gonna take a while, but we have to talk
And then
about
their juries, well, they'll
no
in
sense
question about
hanging
testimony
around.
of the,
for that. So let's be back at 8:30 tomorrow morning. Tomorrow is Friday. Whew. All right. Just be back at 8:30. Remember my instructions during the recess. And thank you for your patience this week thus far, and we'll see you in the morning. Enjoy a little bit of
The
afternoon
jury's
off.
out for
Any
the day. We'll
questions?
see if the
Okay.
cameras
Thank
stay
you. I
on
think
for
the weather's
the
nice out there.
while the jury's gone. They're going to have some
Yeah, I hope so.
discussions.
You guys, I guess I keep forgetting, come a little early to do your stuff with the clerk. Thanks.
so this is a judgment of acquittal motion, but basically all the evidence must be taken in the light most favorable to the state. And
Yeah.
so it's almost an automatic denial. I mean, there's clearly enough facts for the jury to draw an inference that he's guilty. So, but the defense has to make it in order to preserve it.
There would have to be zero
be
evidence on some
seated.
critical element.
Maybe have 15 minutes.
Sure,
Get our
it's-
arguments and everything, maybe 20 minutes to get our arguments in line.
Yeah,
That's
and
fine.
remember the
Come back
state
at,
basically
say,
just has
10
to
till.
prove that he
That'd be
pulled out a
good, or-
gun, pointed it,
Okay.
pulled a
All right,
trigger,
we'll
and
be in
killed a
recess
guy.
till 10 till.
Or that that a jury could believe that a guy was killed and that you might not have had a reason to do it. And it's a really low bar for the state to pass
Right.
here.
Almost never does this get granted, but it's required to make the argument in order to preserve appellate issues. So you get pro forma thing. The fact that the stand your ground hearing was denied is going to be enough. But I mean, just the evidence, just that one witness, he shot him. And I didn't
Over
see over
popcorn.
popcorn. I
Yeah.
mean, that's enough right
Yeah.
there. You could get it to the jury.
Because the jury's privileged to ignore everything else and just buy that.
Yep. So
But then they'll probably inquire of the defense about whether he wants to testify.
Yeah, they said at opening that he was going to testify. Of course, I
Okay.
guess they could change their mind, but that would be a weird thing to do.
But it's
After
also
telling the jury
it's-
you're going to hear from them.
it's a defendant's right to choose.
Yeah,
I'm sure they've
sure.
counseled him, but the judge has to inquire of the defense because that's
Right.
his right, not the defense lawyer's right to decide that.
yeah. Well, while we have a little break here, and I'm only assuming that they're gonna come back for the argument, but they may not. I haven't seen the media order in this. I looked for it, but it's possible that they've done sidebars and other legal arguments off camera. They may do this legal argument off camera, and if they do, well, then that's what we got. But let me read these chats that have come in. Stephen Oglesby says, "Can someone tell Tiny Lawyer that children should be seen and not heard?" God, his objections got more and more unhinged as they went on. I'm not a big fan of the objections from the state.
I agree. They're basically whiny. They're not specific. They're basically,
Right.
I don't like what's going on here, and that gets tiresome. But the judge is allowing it, so they get away with it.
I like the shrugging objections by Prosecutor Martin. It's like, Your Honor.
Yeah. Now,
What's
is
that
there
mean?
is there a particular Florida rule on speaking objections, or is it courtroom to courtroom?
it's courtroom to courtroom. It's basically the judge. The judges do what they're tolerating. One thing I noticed about this judge is that she puts a lot of emotion on how she rules, which I don't like that from a judge. But she's like overruled, or she makes this kind of emotional spin on the statement when she rules, and I don't think that's proper. If you're going to discipline the person, the attorney, for making the objections, then be a little more in control of your courtroom rather than expressing emotion, and you got to pick up on my emotion. Give me a break.
Yeah. So for the chat, the difference, a speaking objection versus sometimes they'll do a rule, like just a rule objection or a number objection. That's where you object, Your Honor, hearsay, or object rule 404 or whatever. Some courts want that, and then others allow speaking objections. Objection, Your Honor, this is irrelevant to this thing. You get to make a little bit more of an argument on a speaking objection. Some judges don't like that because you get to color how the jury perceives the question with the objection. Whether it's sustained or overruled doesn't really matter, because now the jury's like, oh, okay. I hadn't thought about that until now.
As an aggressive defense attorney, if a judge let me to do speaking objections, boy, I'd abuse the hell out of that. Your Honor, objection. The state hasn't proven anything that's a speaking objection. And who cares what the judge says? The jury just heard you make a little opinion about what was being said. So I'm educating the jury on what they're not allowing, right? So speaking objections, most judges don't like it. This judge is allowing it, which is, I think, sloppy. But and the emotion on her rulings, the way it should be done is objection, hearsay. And then the judge would say something like sustained or overruled on those grounds. Something like that. But or if there's discussion, then counsel approach, and then you have the discussion off thing. And then afterwards they say sustained, the jury will ignore, the rule is this. That's the way it should go. But it's loosey-goosey.
Overruled.
Right. That's terrible.
Sustained.
That's a bad habit she's got there.
Yeah. I'm not a big fan of her courtroom demeanor in general. It feels like she doesn't care to be there, which is weird, because I don't suspect that she would, but it feels awkward.
Well,
Phantom.
Go ahead. Go ahead.
Oh, I was going to read a chat, but what were you going to say on the topic?
Well, I was just going to say that, you do want a judge that's impartial, and so that their distance demeanor is not bad. Like if they're bored, that's not a bad thing, as long as they're on top of the law. It's a little random how she's controlling the courtroom. So I'm not sure if it feels to me like the lawyers are running the courtroom, not her.
I like the full-on hate rage of Judge Borkowski in the Edgecombe trial. He just hated everybody.
We've watched this video 100 times for hours and hours and hours. No, we're not going to watch it again. No, it's cumulative.
Oh yeah, I saw that.
I'm tired of it.
Fire, man. That was great.
Ashley, get the fuck out.
We're going to stay here until midnight, right?
You just
You're
made her
not
a
going
witness.
home. Yeah.
You made her a witness in this case. She has to get out of the courtroom. She can't be in here.
And by some accounts, she impersonated a police officer, and that's a felony.
You want me to prosecute her? I'll prosecute her, and you as an accessory, you scumbag. Phantom Hive says, if R said, throw popcorn in my face at any time, that's bad. The defense is arguing that he said it before, but would indicate that R was not expecting punches, right? If he said it after the shot, that's straight up bad. I don't think the defense is arguing that he said it at all. I think a witness claims to have heard it, and they're trying to deal with that fact as best as they can. And part of the way they're trying to deal with that fact is you literally don't remember anything else. You're in a room overhearing people say, I think it was over popcorn. My guess, they got that fact out of this witness, by the way. So my guess is they're going to try and use that to tie in the idea that this popcorn line was fabricated in people's memories.
Yeah.
By the chatter that happened afterwards.
Easy to see how that could happen, right?
Yeah. So So that's what I think is going on. But I think that the defense is not trying to argue particularly where it occurred. They're just having to deal with the fact that it's there,
Right.
that someone has said it.
Right. Because shooting somebody over a popcorn spill does not seem like a reasonable response, right? So they've got to deal with that fact that the witnesses are saying it. So how do you deal with that? I don't know. Do you call them a liar?
Empty tables.
Yeah,
Sorry.
you got to deal with the fact. And what do you say? I mean, how do you deal with that as a defense lawyer?
Right. And you just have to work through it. The cameraman's putting in work right now. Messing with their hotkeys, I guess. Nathan Lai says, I've met plenty of cops. At least I thought they were cops until the bass dropped and they started stripping. Brave nurse with a totally real girlfriend, February 2022. KF Joy says, watching this nurse's testimony back in 2017, quick skimming roughly talks at the same points and using similar words like dim. It was loud, but you could still hear people talking. P.S. He had a pink shirt and black vest. So there you go. That's where that was. Now I have to find where my spot was earlier. Yeah, whoever was watching that back, you don't have to super chat, but if you could tag me and just let me know, was it hostile? Was it a hostile exam or cross exam that happened in the old one? Because all of the witnesses that have come back have seemed to be standoffish with the defense. And I just wonder if the defense went all out in that hearing, tried to rake the witnesses over the coals, kind of a no holds barred thing. And that now the witnesses sit down apprehensive to when the defense starts talking. Morgan Babcock says, jot down on paper, get shredded. David H. Message retracted. By the way, the shredding of the notes sounds really offensive or whatever, but that's a common practice of police. They don't have to preserve. In fact, in many cases, they don't have to preserve audio recordings. They can actually get an audio recording of an interview, memorialize the audio recording in their notes, and destroy the recording. It's amazing what they're allowed to do. And then they characterize the testimony that was in there. You don't do that in a murder case, but it happens all the time in smaller cases, at least in Minnesota. They're allowed to actually do that. And you may not get a copy of the recorded conversation of any video or audio that was taken at the time of the interview, because the police officer memorialized in their notes, and therefore they didn't need to preserve the whole recording.
What jurisdiction is that?
It's Minnesota.
Wow.
I mean,
I haven't heard of that in Florida.
Yeah, I hate it, but it's amazing how you can they can kind of characterize this stuff. But the destroying of the notes, I'm actually more in favor of them destroying notes that have been recorded in a thing or on like a physical media. That would be better personally. But yeah, it's not unusual for police to destroy parts of the investigation if those parts aren't going to be preserved as evidence, which I don't like that. But that is sometimes how it goes. Fun. Ryan Keeler says, who's more competent, this guy or Barney Fife? This is the detective earlier.
The detective was bad. But it doesn't really matter what he did. It goes to the witnesses. That's where I'm coming from. I think that these witnesses that were in the theater with him, that's who the jury is going to make their decision off of what they saw, how they measure what happened in that theater, not how sloppy a job that the detective did. Sadly for us defense attorneys, we'd love for it to be like, we killed that guy on the stand. Let's do it not guilty, right? But cops can screw it up. It doesn't mean the guy walks.
Jose says, wasn't that hearsay, asking what he heard from another person? Yeah. You explained this in the chat, Steve, and you're right. Hearsay is only hearsay or only excludable if it is used to prove the matter that is asserted. So if hearsay is used to establish a present sense impression, to establish what the person
In that
Right.
instance, it was effect on listener. So they were saying you responded in this way because you heard this. So it's not saying what was said was true or not. The reason that hearsay was allowed is because he reacted to it, and so it had an effect on the listener. So it's kind of, hearsay is ridiculously complicated and needlessly so, but that's why that came in.
Yeah. And the best part about hearsay is a lot of lawyers don't understand it, and a lot of judges don't either. Because in the moment, the simple answer is if it's not a statement made by the person who's sitting there, it's hearsay by logical definition. But then when you get to that proving the matter asserted, it adds a layer of thought, and usually decisions are made very quickly. And so it gets bungled all the time. 11 Bravo Crunchy says peanut butter on one palm, jelly on the other, unbreaded Canabro PB&J. Disgusting. Josh Fabian says, thanks to your peanut butter, and jelly sandwich, I expect to be full gunt butt in 2 months. Yes, it's so good. Greg Bellotta says, question for Branca. I've heard of cases of self-defense against cops breaking into a house, wrong or right, but are there any cases with U.S. soldiers instead? I assume it gets screwy with martial law.
Wow.
Yeah, I mean, those aren't normal cases. I don't even know where they might end up in the rare, use of force cases that end up in federal court. I don't know of a case where soldiers go in. Cops going in and getting met by gunfire, either by bad actors or people who genuinely believe they're defending themselves against bad actors, happens all the time.
Yeah, with soldiers, it'd be weird because you'd have to
Why
have
would
a
they
soldier.
be doing that?
They'd have to be acting in a law enforcement capacity, which would be really rare in general. And then even if they are, that's typically they're on like some sort of crowd control or emergency response. So I guess maybe if you have soldiers entering a house during like a hurricane, like National Guard is called in to help evacuate. They enter into a house, they believe someone's trapped inside. They could get shot at. It'd be a really weird edge case, but typically you're not.
The fundamental
not
legal principles would be the same. I mean, it doesn't matter who's coming into the house, really. If the homeowner reasonably perceives an unlawful, imminent, deadly force threat, he's allowed to use force to defend himself.
There was a really good case. There was a really good case out of Greenville County. Active Self-Protection is a website that reviews police body cam videos.
Yep.
And they did one called A Big Mess Out of Greenville County that you need to look at if you're interested in that type of thing, about a cop shooting into a house. Basically, they got a call out to a house, and the homeowner went to the homeowner came to his door with his gun of his own house, and the cop shot through the window and didn't kill, but hit the homeowner who was armed in his own home. Very interesting analysis. They got it wrong the first time. They had to redo the analysis.
I've seen a number of cases like that, especially when cops are responding to a violent domestic, for example. Often they're either going to the wrong house or the wrong apartment often, or so a person in the adjacent apartment hears screaming and calls the cops, or they're just watching a movie with screaming in it and gunshots and stuff, and the adjacent apartment hears it. But the cops are on a violent domestic call. So when they get to the door and they're knocking, they have their guns in their hands already, or they're really ready to present their guns. Meanwhile, the homeowner inside hears someone banging on the door. He's like, oh, shit, this is a sketchy neighborhood. I'm going to go to the door with the gun in my hand. He opens up the door with the gun in the hand, and often there's confusion. So you can have two cops. They're seeing different things. One of the cops starts shouting, gun, 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 and the other cop responds by shooting the apparent bad guy with the gun.
Yeah, that happened a couple of years back. A video I covered on the channel. It was down in Arizona, and sketchy-ish neighborhood. It was 11 p.m. to midnight, something like that. Guy and his girlfriend were up. They were watching TV, making some food, and the neighbor above them called in a noise complaint, and then on the noise complaint call, the dispatcher's like, okay, well, it's a noise complaint, whatever. And the guy's like, are you going to send someone out? She's like, I mean, I'm not really, if it's just a noise complaint. He's like, well, it's whatever. He's beating her, whatever you need to get somebody out here. And so then they send two cops to the door. Guy opens the door, gun in hand, sees the cops. He goes, whoa, 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 and goes to put the gun down. It looks like to me he's trying to put the gun down, and the one cop behind him plugs him in the back of the head, and he was done. and it was a really, really ugly case. But I don't think charges were even filed on it. But it was that exact situation you described.
You're muted, Andrew.
Sorry, I'm doing some audio video work here in the back end. I don't want it to play over the connection. Yeah, I'm sure that's exactly the case I'm thinking of, Nick.
Yeah.
The case I was talking about was Greenville County, South Carolina. So it's really a dramatic video. And the guy's like, "Why'd you shoot me? I'm in my own home. I'm coming to the door with a gun and you shot me through the door." But cops aren't perfect. And like I said, we're lawyering and we're always looking back with 2020 hindsight, right?
Right. And real quick, to finish up on that question, does it get screwy with martial law? I mean, you're a civilian. You're not under the Uniform Code of Military Justice. So you're not under, you're not going to get court-martialed on that type of thing. That would be handled in civilian courts. If you're on base, right, and you've got military police coming into the house and you're shooting at them, different story. That's a whole different sort of fiasco. But typically in the situation you provided, it sounds like U.S. soldiers may be being deployed for emergency response, going into a house and being shot at. That's going to go through the normal courts. And like Andrew said, it doesn't particularly matter who's coming into the home. It's all, is your belief that you're in danger justified or reasonable? Colin Helmut says, if the jury is half the sloths the rest of the court is, there's no telling which way this will go. How about peanut butter banana pancakes? I've never tried those. They don't sound the worst, but peanut butter and pancakes sounds weird.
As an aside, the UCMJ, Uniform Code of Military Justice, self-defense law is very traditional self-defense law. There's nothing weird about it.
Okay, perfect. Let's see. Stephen Oglesby says that lag wouldn't happen if you were on Rumble. Okay.
Yeah.
Okay. Yeah. Gotcha. Real quick about the slots, the rest of the court. The thing I like about this case is that it is so divided. I mean, we've got our poll results here from after lunch, and we have 28% guilty, 36% not guilty, 15% say guilty, but jury says not guilty. So that brings the not guilty side from 36 plus 15 right to 50% almost. 51%. And then not guilty, but jury says guilty is 20%. So we've got 20 and 28 there. So we got 48 to 51 or 52. The rounding is always screwy on this stuff. That's amazingly close for the cases that we've been watching. So this case is interesting because of that.
It is an interesting case. And I know that these are the type cases that are really difficult because people, and in Florida, there's a 10-20 life statute. So he gets convicted, he's going away, mandatory.
Yep.
So, it's basically a life over type thing. And it is close. That's why it's being tried. State's not going to drop it.
Yeah. I mean, under 10-20 life, it's 25 years mandatory minimum for each of these charges, right? Because a gun was used in which death resulted.
Yes, be life.
Right.
Yeah. Life. He died, right?
Yeah. Oh, yeah.
Yeah. And this guy, life sentence is 10 years anyway.
Right.
Right.
I mean,
well, I think that's one of the reasons for the delay, wasn't it? That they're hoping he'd die so they wouldn't have to try it.
That's what I suspected.
Yeah.
Ankit Pal says, what are Nick and Branca's thoughts on Frank backing off from the Blakely arguments and asking for a guideline sentence for Potter?
I mean, it's really a political decision. So I don't know. I'm not that familiar with the politics of that area.
Yeah, it's hard to say. Here's the annoying thing, of course, is that all that Blakely evidence should have been excluded from the trial, and it got in, and it was like, oh no, well, these are for the Blakely factors. And then it's now in the trial, was used to make the decision and probably shouldn't have been. Susan Bortz Brettel says, what was the explanation for the deceased phone being on the floor in front of the defendant? He didn't even know. There is no explanation. No one knows how that phone got there. Maybe it was thrown and hit Curtis Reeves. Maybe the guy got shot and it was in his hand and he dropped it. Maybe it was in his pocket and it slid out of his pocket as he was rustling around and flew, kind of went through the back of the seat. That's happened to me with my cell phone. It could have gotten there any number of ways. No one really knows. But one possibility that is reasonable is that cell phone was thrown at Curtis Reeves and struck him in the head, which would be consistent with his testimony.
I wanted to ask you this.
Go ahead.
Well, I wanted you guys to kind of give
All
a
right.
short version of what the defense
State
theory
having
is that
rested, are there
justifies
any
the shooting when
motions?
you get a chance.
We would make under rule of criminal procedure.
Best in light, most favorable to the defense, right?
In this matter, if I may argue from the seated position.
You may.
We'll talk about it after the arguments.
Go ahead.
Your Honor.
I wrote up a quick summary of it yesterday.
We have
I'll
a case
pull it up.
of Morgan v. State, which cites many cases for its proposition. It's a 5th District case. It's located at 127 Southern 3rd, 708. It's a 2013 case. And so this is why this case is unusual. To be honest with you, I was quite surprised that they were going to introduce Mr. Reeves' statement in this case, because normally, and I agree, this is what this case says. The question of whether a defendant acted in justifiable self-defense is generally a jury question. And that's normally because that first comes up when the defense does the presentation. What I was quite surprised that they did is that they put Mr. Reeves' statement in their case in chief. And that creates, I think, a problem for them. And this is why it creates a problem for them. That statement of Mr. Reeves has not been refuted by any single piece of evidence in this particular case, period. Let's look at what justifiable use of force is. Under the law, under both 776.012 and 776, as the court recalled, it refers us also to 776.013. And so I'm going to read those again because I think it's important for us to keep this in mind. A person is justified in the use of deadly force and does not have a duty to retreat if he or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or to herself or another, or to prevent the imminent commission of a forcible felony. And so that's 776.012. As we know, there's a second section, which is B, which it says, under those circumstances also permitted under 776.013. So I'm going to read that.
Oh, don't read the whole thing.
Engaged in an unlawful activity and who is attacked in any other place where he or she has the right to be, has no duty to retreat, and has the right to stand his or her ground and be forced with force, including deadly force, if he or she reasonably believes that it is necessary to do so to prevent death or great bodily harm to himself or herself or another, or to prevent the commission of a forcible felony. And we know that the law is clear that the danger does not have to be actual. So let's make that abundantly clear. I don't think the prosecution is going to disagree with this. The danger that Mr. Reeves perceived does not have to be actual. The only thing it has to be is that Mr. Reeves reasonably believed that he was in imminent danger from that observation. That is it. And so when you take his particular statement, it was 2 statements as the court recalled. There was the first statement that was about 30 minutes. There was a second statement that was much shorter. He laid out the groundwork that this was a self-defense case and that, he was scared, and the reason that he was scared and that why he had to.
But the jury's free to disbelieve that evidence.
The phone was thrown at him, and the fact that, those particular hands were coming in his direction. So let's talk about the phone, because clearly the phone is a deadly weapon. Hey, their lead detective testified. The phone can be a deadly weapon, hands can be a deadly weapon, and both of those can kill. There's absolutely no doubt that there is evidence here that
Typical JOA argument here.
Was in between Mr. Reeves' legs immediately after he fired the shot that resulted in the death of Chad Olson. Immediately, because we know that Mr. Hamilton came quickly over to Mr. Reeves' side, looked down, and there it was. It has not been refuted. It has not been refuted in this particular case that Mr. Reeves says, I think that phone hit me in the head. That is an aggravated battery under any circumstance.
No.
You don't have to have serious bodily injury. You don't have to have any of that if you're throwing a deadly weapon. to an
What do you think
individual
about
and
that Florida
strikes an
provision that
individual.
makes
It's
a
got
simple
clearly
battery on someone 65
an
years
aggravated
of age or
battery that
older
has not
a
been
felony?
refuted under any
Its
circumstances. We also
application
have
here.
a regular battery.
Yeah,
We
well,
have
that goes to
felony
knowledge of the
battery
decedent,
on a
right?
person
Did he know he was
65 years
65?
of
You don't
age
have to
or
know.
older.
The statute
On
says you
two
don't have to,
occasions.
the attacker does not have to know the age
One
of the victim.
occasion, obviously, is
I don't know.
the throwing of the phone. The second occasion
I'll
is
get back to you on that
when
one.
he grabbed the popcorn and threw that popcorn at Mr. Reeves. That's a felony battery. You know, to be honest with you, I'm sitting here and arguing this, but that's the law. I wish the law was a bit clearer, you know, in differentiating, you know, that particular, but it's a battery. If it's an unwanted touching, it's a battery. You know what else it is? And again, I almost feel a little silly arguing this, but
There he goes.
it's a robbery. Because if you're threatening someone and in the act of threatening someone, you grab
take
that
something,
popcorn
attaboy.
and you pull it and you throw it back at the individual's face, that is a robbery. Now, you don't even have to go there. You don't have to go to the robbery. In my opinion, you don't have to go anywhere because we have clearly a phone being thrown that Mr. Reeves says hit him in the head, and it's been not refuted. If the prosecution tries to argue that it was refuted because nobody saw it, that's not refuting.
Good argument.
That's
Yeah,
not
that's
refuting
the whole negative
that
evidence
particular
problem I've
fact.
been
So,
mentioning.
you know, I think, Your Honor, and I'll be honest with you, I think the prosecution put themselves in a very bad position.
Stephen, I put that
placing
Florida
that
statute about
particular
65 years
statement
or
of Mr.
older
Reeves,
in the private
you know,
chat here in StreamYard.
trial
I
in
put a
their
link to
case
the
in chief.
statute.
Because otherwise, you know, we would be sitting here saying, okay, well, you know, what do we have at the end of the day? We have a bunch of their witnesses saying this happened. No witness talking about self-defense. This is very unusual, and we were, frankly, yesterday very, very pleased that they did what they did, because I think now it's clear, even in the light most favorable to the government, it is crystal clear that none of their evidence has refuted what
It's a
Mr. Reeves said.
good argument.
in that
I
case.
like this guy.
So I would ask
These
the
are good
court
defense attorneys.
to grant us our judgment of acquittal. And by the way, on Nicole Olson, whatever intent Mr. Reeves had in defending himself against transfers to Nicole Olson. So he can't be, at this point in time, guilty of the aggravated battery of Nicole Olson either. And
The
so
problem is
it hasn't been refuted, Your Honor. I know that
the
it's
use
a
of the weapon,
decision for the court to make any time.
whether it's a
the court is
deadly weapon.
rendering a decision on a judgment of acquittal. But this record is crystal clear.
Whether it's a
no
deadly
way.
weapon, whether it's a deadly weapon is an issue of fact.
I have
It has to
agree
be
with Mr.
used in a-
Escobar that this record is crystal clear. Unfortunately, I have to say it's crystal clear in the opposite direction. In taking the evidence in the light most favorable to the state.
Well, he did get a cop
of
to
course,
testify
is
if
the
he threw a
burden and
cue
the
ball
judgment of acquittal
at a
argument.
person's
The
head,
state
be a
has
deadly
put
weapon.
forth sufficient
and the
evidence
phone was
to
the same
go
weight as a cue
forward
ball.
to the jury on murder in the second degree as well as aggravated battery. I think Mr. Martin's going to handle the aggravated battery. It's kind of tied in just a tad with murder in the second degree. All the elements of murder in the second degree have in fact been proven. We have the child Olson was dead. It was done by a criminal act of the defendant, and it was done through an act that was imminently dangerous to another, evidencing a depraved mind with ill will, hatred, spite, or evil intent. I have some case law if the court wants to read it just about those other elements, but I don't think based on the arguments it's necessary. Really what the defense is indicating is that the state has to somehow rebut the defendant's allegation of self-defense, and because every single
introduced his
eyewitness
allegation.
indicated it didn't
Right.
happen, somehow we have to accept the defendant's word. And I'm having a hard time wrapping my head around that.
Yeah, that's
The
right,
evidence
because you're
in
a
this
prosecutor.
case that every single witness that we called said the defendant's version of events simply didn't happen.
That's not what they
There's a
said.
video and evidence that the court
They
has
said they didn't
reviewed
see.
and has seen in the past, and it's been played again during this trial, that absolutely with 100% certainty contradicts the defendant's story. There's a case that I can cite, and I can also present a copy to the court. It's Leisure,
His story is his perception. So actually,
and I will.
it doesn't
Yes.
refute his
No.
story.
For defense counsel, it's Leisure, 105 Southern 3rd.
What they've done is they have raised self-defense in
It's
the
a
case
section
in chief. So
ECA
defense doesn't have to put on
2002.
anything and they'll get that instruction.
And
So now the
basically
state
what
has to
this
disprove
case
that defense
states
beyond a reasonable
is
doubt.
that the jury
Right.
can outright reject any claim by a defendant. And we've put forth sufficient evidence, especially at this juncture.
Right. So in the light most
arguing
favorable
about
to the
judgment
state,
of
have
will,
they disproved
to
self-defense
rebut
beyond a
the
reasonable doubt?
defense
Now,
allegations.
is there any evidence that's
there was
before
just-
them
Right.
in which they
I
can
guess the
say that the
defendant,
defense
according
was
to the
proven
defense's
disproven?
argument, was definitively struck by a cell phone. The court would recall there has been no testimony or evidence of that whatsoever. In fact, the defendant himself doesn't know if he was hit by a phone. He says it
Defendant
might be
hasn't
possible.
testified yet.
And the reason I think it might be possible is because, well, something happened and I looked down at my feet, there's a cell phone. I'm putting two to two together. I guess it was a cell phone. Looking at it logically, and there's no secret in this case about this, had the defendant been struck with a cell phone, I think it'd be reasonable, and especially for an argument of JOA, that there would be some form of injury. Now, this some form of injury.
He
certainly
testified
is
to an
the
injury.
left corner of the eye or eyelid injury, especially if it's being used as a deadly weapon. The definition of a deadly weapon is as follows. I'm sure the court knows this. A weapon is considered a deadly weapon if it's used in a way. I'm gonna try to slow down.
Not that causes
And it's used in a way like
grave bodily injury, but can cause grave bodily injury.
So a cell phone in and of itself is not a deadly weapon.
But
It's
see, this is where the defense
If
loses
he were
right
to
here, I think.
toss a cell phone, that wouldn't be an aggravated battery.
Because
That would be a battery because it touched or struck him against his will. Because he was over 65, it would be a felony battery, which is going to
It
be my
doesn't have
other
to
argument.
be a deadly weapon.
So-
It has to be reasonably perceived.
But he just argued a forcible felony. The state just argued a forcible felony because he's over 65.
That's instruction. There is an applicable forcible felony section, but there's just another section that only talks about the generic felony. Okay? In that section that talks about just the generic felony, I'm going to read it because I don't want to misquote it.
But this is a forcible felony. It's not a generic felony.
It says, the use of deadly force is justifiable if the defendant reasonably believed. Let me stop there just for the JOA argument. There is no evidence at all that would support the defendant's contention that he reasonably believed at the time of the shooting he was going to die. I mean, that's
not the
basically-
standard.
He has to disprove self-defense
So there is
beyond a reasonable doubt.
absolutely no
What evidence
At
is
the
there?
time he fired that shot, he could reasonably believe he was about to die or suffer great bodily harm. At the time the shot's fired, there is no way in the world, based on the evidence presented through the witnesses in the video, he reasonably believes he was about to suffer great bodily harm.
That's not
what the
true at all.
No,
instruction
no,
is.
that's not
So the
right.
use of deadly force is justifiable if the defendant reasonably believed. I submit all the evidence so far shows he certainly did not reasonably believe it. But anyway, going on, believe the force was necessary to prevent imminent death or great bodily harm while resisting. He's not resisting anything.
Yeah, he does when he
And then it
pulls out a
talks
gun and
about
shoots.
an attempt to commit a felony upon him. So let's say the felony that's being suggested, which was what Mr. Escobar was arguing, is battery on someone over 65.
But this would apply to any effective use of a firearm, because if
Not
it's an
resisting
effective
anything.
use of the firearm, the attack stops.
What
There's
happened
no
was his popcorn
successive
was tossed
attack.
on him. That was done. Mr. Olson's hand was coming back. The act was complete. There's nothing he's resisting. It was done. And he decided, based on the evidence, that he was going to shoot and kill him at that point. So he wasn't resisting anything at that point. The robbery conversation, or I guess argument that Mr. Escobar made, the defendant himself states in his own tape statement, when Mr. Olson jumped up, the popcorn went by the wayside immediately. I don't know if it fell out of my hand or if he knocked it down. I don't know. There is no robbery. There was no force, violence, assault, security, and fear that he was aware of. So that certainly
No.
wouldn't
The
apply.
creation of the fear
And that would
actually
be- that's
did
gonna be
happen.
my argument
He just
later
doesn't
on
know
when we
if
get
the
to
thing
jury
was stolen or
instructions.
not.
In the case
If someone
references-
knocks you unconscious and steals your wallet, is that a robbery?
And I already alluded to it. And this case is even better for us than the argument I'm advancing, because in that case, the Leisure case, it states, even when there are no other witnesses to the event beside the defendant, because a lot of times there's a homicide and the only witness is the person who has passed away, a jury is not required to accept the defendant's testimony to support his or her self-defense theory as true. It must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. Leisure's
You
numerous
have to establish it by
inconsistent statements
evidence.
cast significant doubt on her assertions. And that's exactly what we have here, except for the fact that we have multiple witnesses who are saying what the defendant's stating took place didn't happen. And even if you discount all of those witnesses, the video indicates that it never happened. So there is no justifiable use of deadly force here, because at the time of the applicable battery, he wasn't resisting anything. But even if that argument was to be made, he could not, based on the facts and circumstances introduced in the evidence so far, reasonably believe that killing Mr. Olson was necessary to prevent his own death or great bodily harm occurring to himself.
These are so routinely denied.
Facts
It's
just
good,
repeat
good argument from the defense, but he's going to get denied.
for just
Oh,
other
yeah.
elements is that
Yeah.
there
It's
has
The
been
just
interesting
pro
thing is
forma.
he made a
within
compelling
which that
argument.
the defendant
Yeah,
did,
I was impressed. That's hard to make a
involved
compelling
in
argument in
the-
JOA.
Mr. Olson, it was about 4 minutes between the initial encounter and the time of shooting. And again, there's absolutely no evidence whatsoever that this was a lawful use of deadly force. And therefore, I would argue that the defendant's motions for judgment of acquittal should absolutely be denied.
Judge, if I may just have a couple of points here. Again, I think that, their problem, they're talking about this video. This video supports us, doesn't support them. If you look at the video, you'll see that about 8 to 10 seconds before the actual grabbing of the popcorn and throwing it back, you actually see Mr. Olson actually coming over the seat with a hand. It is at that time that Mr. Reeves in his statement is saying, hey, listen, I see him coming over. You can see it on the video. Take a look at it if you like. We've got it in circles that our expert has actually circled that particular area. It was at that point in time that Mr. Reeves says, hey, listen, I believe that he hit me either with a phone or with a fist or something, but it hit me on my face. It knocked my glasses askew, and I was a little bit dazed at that point in time. That is an aggravated battery that has not been refuted. Guess what? There's not a single witness that they presented in this trial that refutes that. But then there's a second.
Not one.
Then what happens is about 8 to 10 seconds thereafter is when the hands start coming through. And I want you to look at the fractions of a second that it takes for the shot to take place. It's fractions of a second. It is an absolute impossibility for Mr. Reeves to have shot Mr. Olson because of popcorn. It's a human impossibility. But it doesn't matter because of the fact that nobody has refuted what Mr. Reeves said in that tape. Frankly, when we went home last night, we were shocked that they had put those audios in because they were good for us. We were going to sit here on a judgment of acquittal and say, okay, well, Judge, we have a judgment of acquittal, and that's my argument. But when they put that in, I thought that they had made a huge mistake, and they have. Think of the witnesses that were presented before this court. Nicole Olson didn't see anything, okay? Nothing whatsoever. Mr. Cummings doesn't refute what Mr. Reeves says in his statement.
Good argument.
Mr. Hamilton does it because he's only seeing silhouettes, okay? And certainly the lead detective doesn't. There is not a single witness that they've presented that refutes Mr. Reeves's statement in that oral tape, in that recorded tape. Nothing. And so what does that do? If you look at the Leisure case that they're talking about, I think Leisure, that motion of a judgment of acquittal that they're talking about happened at the end.
He wins here. He
the
deserves
state
a
and the defense
Ferrari.
case. We're talking,
He's
not
probably
gonna
earned
win.
one already.
Not going to
8
win,
years of
but
billables?
not going to win, but it's great argument. This is
some of the
appellate
language is
stuff.
not good because normally in situations like this, may I approach?
You may.
More. And can you get one to the same? Normally, Your Honor, in these situations, if you look at Morgan starting on page 8, I'm going to read what the court says. The question of whether the defendant acted in justifiable self-defense is generally a question for the jury. I agree with that. It's a Supreme Court case that they're citing, Rimmel versus State, located at 532 Southern 2nd, 16.
Parasite, they don't have to prove
Look what it
self-defense.
says at the very bottom. However,
The state
a motion for
has to
judgment of
refute
acquittal
it.
based upon
Yes,
self-defense
this is-
should not be granted unless the evidence is such that no view which the jury may lawfully take of it favorable to the opposing party can be sustained under the law.
this is an interesting
And the
argument
law,
because it
again,
has to do with the shifting
danger
burden of
doesn't
proof
have
back
to
to
be
the
reasonable.
state.
It only has to be reasonably perceived by Mr. Reeves. They have not one scintilla of testimony that refutes his version on that. And so they're stuck with that particular tape. They put it on. They didn't put anything on to specifically refute his perception. And therefore, the court has to take that perception what it is, because it hasn't been refuted. And this jury can't do anything with it because there's no evidence to contradict it. So I would ask the court,
Right.
again, to look at 776.012.
There's no way he gets it, but he
No way
should.
he gets it, but it's great.
776.013, and understand this. The law does not punish one that reasonably believes that they need to use that force to protect themselves against great bodily harm or death. They don't have to be right. They just have to reasonably believe. There's a big difference. That's the beauty of this law, because you can make a mistake in that whole process, and the law still's not going to punish you as long as you reasonably believed at that time.
I wonder if he's read my book. I make this point all the time. You don't have to be perfect in self-defense. Mistakes are forgivable as long as they're reasonable
Again, it was
mistakes.
never refuted. And they didn't bring in any police officers to say, hey, Mr. Reeves wasn't a very good police officer. He didn't know anything about use of force. He was not commander of the SWAT team. He didn't know it. Just the opposite. They were silent on that. And so, Your Honor, we're looking at every single witness here. They haven't refuted this, and they're stuck.
And it's the burden of proof question is essential here.
Thank you.
This is the burden of proof question. It was just changed, and the judges and nobody's caught up with it yet. Whether or not the law has changed this is a very interesting legal point. Be subject to appeal, which will get denied probably, but
As far as the statement
she's going to deny it here.
claimed of the interview of Mr. Reeves, I found that there was a great deal of evidence that refuted some of his statements. For
Really?
instance, the whoa, 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 oh, no, no, no. Pretty much every witness
Didn't hear that? That
That's
doesn't
not an
mean he
element of
didn't say it.
self-defense.
seems to have heard or seen something said they didn't hear that. And I know you've said several times now since the beginning of the trial about the 10 seconds prior in the video. It's clear to see that the defendant came over the decedent came over the chair and, was taking a swing or something at Mr. Reeves. I didn't see that. I looked hard as I could look, and I did not see that in the evidence that's before me at this point of the trial. I think that evidence refutes the claim that there was the first attack that it's been called. And the lack of any marks that somewhat, but I agree with defense that wouldn't be enough on its own.
It's easy to agree with them when you've already obliterated their argument.
Mr. Reeves' own statement, he says in the second part that he's not sure. He's not sure if he got hit.
Doesn't have to be sure if he got hit.
He's second guessing himself.
I don't believe he ever equivocated about getting hit. He doesn't know how he got
I
hit.
think with all of the evidence that's been presented, the state has.
And second guessing yourself after the fact doesn't mean you didn't have a reasonable belief in the moment.
Oh, defense attorney's pissed.
Well, he's got that preserved for appeal, though.
About today?
The only judgment acquittal I heard was for second degree murder.
Oh, sorry. Yeah.
We argue for both.
Yeah. And
She's going to deny both.
the same, you correctly identified the fact that with transferred intent, if you prevailed on the judgment of acquittal as to the second degree murder, I think that would apply to the aggravated battery, and you probably disagree, but okay.
It doesn't.
Right, okay. I don't. I think,
I think we
okay,
agree on.
okay.
All right. Do you need any further argument then I'll count?
No, I'll deny the motion in its entirety as to both counts. All right, do we have any other smaller motions that are still outstanding?
We're gonna
Motion
try
for you to
make
get
it
bent,
smaller
bitch.
later.
Okay, the main ones regarding the experts. Okay, I thought that was all we really had outstanding.
Yeah. We'll do the heavy lifting.
Okay.
outside of our room, see if we can narrow it down for-
All right. There's a lot of case law, on these issues, so hopefully you can do that.
Well, it's not gonna be much more
Judge
than
Craig T.
a
Nelson.
100-page Doubter motion I filed in probably case law. So you read that, you know what the case law is as far as the basic. That's what the state will be run like.
If you've read my case law, you know what decision to make, Your Honor.
Very few judges would ever grant that. I mean,
Okay.
I couldn't imagine them granting that JOA. That this is
Yeah,
You
I
know,
the
figured.
standard is so anti-defense.
To do our presentation.
Okay,
We'll see if maybe there's, yeah, we'll get you a list, absolutely.
I think he said they have 85 witnesses.
Squeeze in a sixth if we find.
No, you didn't hear him say that.
Don't
Okay.
say
Said that?
We normally were supposed to give them a day ahead notice.
right.
So
They appreciate
we
that.
got five, for
Okay.
sure.
If they're local and, retired or can get off work or whatever, but
There seems to be a lot of retired people in this class.
fortunately so. All right, so how are we looking then for time realistically?
I think it's gonna take us next week.
Do you think you can be done by Thursday?
He might not have said 85. That's just what I thought I heard.
8 to 5.
We will try our best.
Someone in the chat, does anybody have it open? Could rewind it?
I can tell you more tomorrow. We'll talk about it.
Okay.
We'll
Yeah,
what
see
the
how
lineup is
tomorrow
gonna be
goes,
for
yeah.
Actually, when she dismisses it, we'll go back and listen just for a second.
Monday
Mm-hmm.
and see if we can get our list of witnesses. I'd like to try to, put as many witnesses, quickly. The problem that we have is we have Dr. Foley, who is a practicing radiologist, so we're gonna have to fit him in somewhere. And we've got our Jacksonville expert that,
Is that
coming from
Dr.
Jacksonville.
Cohen
That's a Knox.
or Knox? Okay.
And there's still an
Coding is
issue,
easy.
there's still an issue with Mr. Knox because of those, my doubter motions haven't occurred on him.
Okay,
So, and
Right.
it wasn't be during trial, so.
right, I know. So, yeah,
The
that's,
transcripts. You got the transcripts.
Did you
I
know the
do.
prosecutor before his chin was
You have
removed?
that. Both sides have thoroughly briefed the issue.
yes, you have.
So.
Yeah, so
if the
hopefully,
court has read and absorbed that, then the court's decision
yeah,
with the testimony is just.
hopefully we can get that with minimal delay. But yeah, that certainly will help, the fact that you've briefed thoroughly and I've read the transcripts. So,
Because my argument's not gonna be any more than what's.
okay. All right. Keep our fingers crossed.
This judge is a hoot.
All right, well, I guess we'll have an early.
All
break
these
today.
sighs.
And I'm sure none of us mind that.
I had to read the whole transcript.
I just want to take the opportunity, thank you all. He's so far so good. Everybody's been doing a great job.
For the short
It's a
guy.
tiresome job on you guys' part, but you've all done really well. So I appreciate that. Thanks. All right, we'll see you at 8:30 in the morning then. Thanks, everybody.
Okay, let me see what he actually said.
And by the way, Nick, it looks like I'll be here for the whole thing. I'm going to have to reschedule my motorcycle trip anyway.
He was not
Okay.
commander of the SWAT team. He didn't know it.
Here we
Just
go.
the opposite.
She denies it.
That
Back too far. But
prevailed on the, but I'll, that are still outstanding. That was all we really, not a case we can.
We've got, I think, 5 witnesses.
Oh,
Okay.
you had it.
And Judge, I think
Here
we've
we go.
got, I think, 5 witnesses who will be here tomorrow.
Okay.
oh, so he was
Five
just talking about
tomorrow.
tomorrow. maybe 5. I thought he said 85, and I thought he was talking about his full roster. I was like, they said there were a lot of people in the courtroom, or in the theater, but oh my God, they're gonna call every person, every employee, all of their boyfriends or whatever. Ugh, kill me. Okay. There we go. So that's the hearing for the day. I don't think there's anything left. It looks like they've exited the courtroom, and so it's over early. So we can have some discussion and then do super chats and wrap up.
Well, I wanted to ask Andrew, because there's an interesting legal question that was brought up in the JOA that I'm just thinking about now. Maybe I'm just shooting off, but this is the way the brain works. Issue spotting, right? And that is that the law has recently changed that places the burden to disprove self-defense beyond a reasonable doubt. So the state has the burden, once it's validly raised, to disprove beyond an exclusion of every reasonable doubt that self-defense was an issue, right? So the burden of proof is on the state. Now, what the defense attorney is saying is that the state, in their case in chief, brought up self-defense, brought up reasonable use of deadly force, right? So that, therefore, it is in play. Now the state has to point to some positive evidence, not negative evidence, positive evidence that exists within the record that refutes the reasonable use of deadly force. So now I've got a question. I mean, I've got a next thought on that about whether the phone was actually a deadly weapon, but what is your thought on that burden shifting and how the law has changed in relation to the JOA argument?
Well, I don't think the burden shifting you're talking about now is new. I think that once a prima facie case has been made for self-defense at trial, the burden shifts to the state. That's been Florida law for a long time, I believe. Now, there was a burden shift.
Oh, I
just want to point out real quick.
Yeah, self-defense immunity, there was a burden shift.
Yeah, right. That's what I'm thinking.
Real quick to the law and crime copyright cucks. You're using the court TV feed for Bonnie. Just so you know, when you inevitably come bitch at me that we outperform your numbers today, just want to point that out. Okay. Anyway, sorry guys.
Okay.
My own pettiness coming through your argument.
Yeah, and so for self-defense immunity, it was basically a preponderance of the evidence threshold before, and then several years ago, the legislature shifted the burden for immunity onto the state to disprove self-defense by clear and convincing evidence, which we can mostly understand as being unambiguous evidence, but not beyond a reasonable doubt.
Right.
And then if immunity is denied, you go on to trial, and there at trial, the state has essentially, well, for as long as I've been following it, in Florida, had the burden to disprove self-defense beyond a reasonable doubt, which is true in every state. The last state that still had the old school, truly classic affirmative defense, where the defendant actually not only has to raise the defense but prove the defense by a preponderance of the evidence, was Ohio, and even they joined the majority of states and shifted the burden to the state to disprove self-defense beyond a reasonable doubt 2 or 3 years ago. So effectively, self-defense in all 50 states now at the trial level is a negative element of whatever the criminal charge is.
So what is the evidence that was raised in this case that disproves the self-defense case beyond a reasonable doubt?
Honestly, the only evidence that they could point to, and the judge struggled to find anything. The judge, it was negative evidence.
Right, that's what I'm saying. Yeah.
Yeah, because the judge said, well, I didn't see that punch at the beginning of the video. But by the way, the movement at the beginning of the video coming over the chair is very clear if you're actually watching. It's hard to see what exactly it is, but you can see it's an infrared camera or a night vision camera, and you can see something break the plane of the chair in the direction of Curtis Reeves. And then it's just, I don't think it's 8 to 10 seconds. I think it's more like 3 seconds, but that's the next thing is when he grabs the popcorn very clearly and throws it. And so her saying she disbelieved that, and then her saying no one heard the oh no or no or whatever.
That's completely irrelevant as far as I'm concerned.
Because that's not an element of self-defense to say oh no, or if you believed you said something or not. So
I mean, think about the elements of self-defense that the state can attack, right? That they would need some evidence on to support this motion just now. The element of innocence, that Curtis Reeves was actually the aggressor. Certainly in their opening statement, they repeatedly referred to him as making first contact, unwanted contact. Now that was verbal contact, not physical contact, but and of course the opening is in evidence. But could a jury interpret some of this testimony about that interaction as Curtis Reeves being the one who actually starts the confrontation, therefore loses that element of innocence? I think it's pretty weak. Then you have the element of imminence. They definitely argued that just now, that whatever threat existed was over by the time he fired the shot. I don't buy that argument, but might a jury buy that argument that the shot was fired after the last?
If the evidence is viewed in the light most favorable to the state, then you could argue that's what the JOA standard is.
Right.
So, that's interesting. So keep that 5-point analysis is brilliant. I keep going with that because
so we have innocence. I covered imminence. They spoke to directly here. Proportionality, whether the threat he was facing was reasonably perceived as a deadly force threat. They're attacking that. They're saying, hey, a cell phone's not a deadly force threat. A jury could conclude that it's not a deadly force threat.
That's what I was thinking there. Yeah.
But I think what always is going to catch you up in this argument is this question of reasonableness, because it's so subjective on the part of the jury. And they could look at almost any piece of evidence and say, no, that makes his perception of a threat unreasonable collectively. So I really think it's an impossible pitch.
And you're right.
Even just in his own recording, when he says he's second guessing himself. I mean, frankly, from a technical analysis, that doesn't bother me because I don't see a problem with someone second guessing themselves later if what matters is what they believed in the moment.
Right.
I mean, for example, someone might try to rob you with a fake gun, a real looking fake gun. You perceive it as a real gun. You shoot them dead. Later, you find out it's a 15-year-old kid who had a fake gun. Might you feel bad about that afterwards, that this didn't have to happen? Maybe I should have been a little slower on the trigger. I mean, you can second guess yourself 1,000 times after the fact because it turned out to be a bad outcome, but that does not mean it was an unlawful use of defensive force.
And a lot of people will second guess themselves even if it's a good outcome.
Sure.
Because they wish the person didn't die. They don't want to kill somebody. Most people don't want to kill somebody. They're not happy about it. You heard Curtis said, if I could do it, he said in his thing, if I could do it all over, this never would have happened. Because if he would have known that complaining about a phone would have caused someone to die, he wouldn't have complained about a phone. But
or he would have changed seats, or there's 1,000 things. He wouldn't have gone to the movie theater that day, right? If you know you're going to get into a gunfight, none of it would happen. But you don't know that ahead of time. You only know that afterwards. And that's why you second guess yourself.
See, this is why JOAs never get granted.
Right. But see, the interesting thing is they only don't get granted because I think because we've accepted sort of a non-technical approach to these things, because we're not asking a jury here. And Andrew, you bring up really good points. What could a jury find? But the burden's on the state to prove beyond any reasonable doubt that exists. So sure, a jury could find that there's not reasonable doubt, but would another jury find that there is reasonable doubt? And if there is reasonable doubt, then it should be over at that point. And so we do this on these motions where we get out of the hyper-technical when we're asking the court to be hyper-technical. We're saying, Judge, okay, so maybe you don't believe that the arm came there. But that alone is not sufficient to defeat the self-defense argument, because the subsequent attack could be still justification for self-defense. That's not a problem. You have a forcible felony going on, and that's in the law. And so, I mean, whether you see that or not, first of all, would a reasonable jury have a possibility of perceiving the same thing? Yes. Do they refute it? No, they don't. In this entire case, they have only provided an absence of evidence for his claims. Now, I know that sounds, there's a super chat from Tor Theo, which I don't have pulled up right now, but he basically says that's bullshit because I can shoot somebody and then I can claim nobody saw me not defending myself. Therefore, I was defending myself. But there is still a way to show evidence that there was nothing to support the story that you have.
And by the way, that happens all the time, and it's lawful self-defense and found to be lawful self-defense.
Right. Because if they can't disprove that story, then and the story is reasonable, then it is reasonable, and then you have reasonable doubt. And that's how the criminal system is supposed to work. But we've moved the goalposts on reasonable doubt so far downfield that it's insane.
Yeah, no, you're right on the money on that. That's a good observation. And it is, the thing is that there's no ultimate check, because we have this group responsibility. The judge says, I'm not going to make this because the standard is so high, right? And then the jury makes this group decision. And then the judge on JNOV, I'm not going to disturb the jury verdict. And then, we'll let the appellate courts deal with it. The appellate courts don't have any check. And then, so it just kind of, the buck keeps getting passed. So if there's any scintilla of evidence that can get in front of that jury, then it's up to the jury.
Right. Once there's 1%, one hair of evidence, anything more than zero evidence, it's tossed to the jury for their consideration. And they can ignore the 99.99% of counter evidence, just decide it's not credible, and go with the 0.1% of evidence, decide that's credible.
Yep.
Yeah, it's crazy. I just want to clarify one thing for the chat. These are almost never granted. We discussed this in the Kim Potter trial. We discussed this in Rittenhouse. These things are almost never, ever granted. However, what made this one really interesting and compelling was the idea that the defense attorney kept going back to. Normally, the self-defense argument is introduced in the defense's case in chief. It's not it's there. They know that self-defense is going to be part of the case, but until it's actually put into evidence, it's not in the case. And if the defense were to fail, even if this is a self-defense case through and through, and they've made motions on it and everything, but if before the jury, they fail to have some testimony amounting to self-defense, or leading to evidence of self-defense, then they will fail on that self-defense claim. And so normally that is not brought up until the defense has the opportunity to call their witnesses and say, I was afraid for him. I was afraid. I perceived the attack. I saw him getting attacked, something to justify all those elements. In this case, the state brought it in their case in chief by introducing Curtis's statements, where he articulates in that statement all of the elements of self-defense. He articulates reasonable, imminent fear. He gets to the deadly force by saying that he thought he was going to be beaten up very badly because he's old. He's got arthritis. He's frail. He's worried about going blind. He testifies that he may have been hit by some sort of weapon. He believes he was hit by something. He was dazed. Head injuries are serious bodily injury. All of the elements are met by that statement. And that is really rare to see in the case in chief. So that's what made the defense's argument more compelling in this case. And why it was like, maybe there's a 1% chance that this goes through.
No, it was well presented. The defense team, I got to say, is doing great. For preparation, I don't think he can ask for much more from this defense team.
Well, a little bit better opening, but that's about it.
Well, and I didn't like the tenor of the cross on that one witness. I mean, I thought that it was too aggressive, because you got a witness. They're in the theater. You aren't, and he's coming across like he knows what he's talking about. He knows what happened in there, and you don't. But you were the guy in the courtroom, right? So you're better off taking the tack about soft, like, well, you're unsure about this, and making it more vague, because the attorney doesn't know what happened either. He wasn't there. That guy was there.
Right.
And so when you're hyper aggressive with somebody like that,
right.
I don't know. I didn't like that one.
Is it possible it was more like this than it was like that? Is that possible?
Right. Is it reasonable to say, so it's possible that other words were being said that you didn't perceive. Is that correct? Is that fair to say? Is it fair to say? Right. And so
isn't it ridiculous of me to ask you exactly what happened 8 years ago? I mean, if I ask you any other day, it's really hard to remember. So some of these things could be a little hazy.
Is it fair to say that memories fade over 8 years' time?
Right.
You would agree with me that the things that you wrote back then are more accurate than what you're saying today, right? When was the last time you talked to the state attorney's office? I haven't heard of that question yet. I'm surprised they haven't asked that.
Me too. I'm surprised as well. And frankly, they could have raised many of the issues that we've raised here in discussion, right? Have you talked with other people about this event often?
Oh, the prosecutor. Would you say this guy right here, over here, right?
Would you say it's true that stories are often embellished over time?
Yeah.
That your memories can change. Have you read about this? Have you read media accounts? Is it possible that influenced your recollection of the event?
Yeah, and if you're going to get real aggressive on that, you're going to want to ask that question, because
you could do it. You can do it in cute ways too. You could be like, Yes, as this thing was coming up, I'm sure you saw a bunch of news articles and news stories that you were going to have to be
What do you
back in
think of the
court with
media
us.
generally?
But just allude to the fact that they've seen it out there in the media as they're getting ready for trial. So it's like, oh, I'm sure you've seen this on the newspaper from time to time, knowing that you'd have to come back in. You know, so you're not like presenting it as this, you went out and searched for things, because that could put people in a standoffish kind of you know, attitude. If you're taking that soft approach, the soft approach can get in all the things. It can get in the former inconsistent statements too. And I think you're right on the older guy. He didn't come across as a jacket. The
Air
masked
Force.
nurse, I would have
Mhm.
gone after the masked nurse like crazy, because
I thought that tone was pretty good on him, actually.
Yeah.
But bringing up the hero, you're the hero. You got a reward from the sheriff's office.
Yeah.
That was a stumble too, I would say. But
Yeah. He wasn't playing it like, I'm going to bury you at the end with you being corrupt with the prosecutor.
right.
Yeah.
If he would have had to do the whole thing differently to get to there,
It
but
felt to me like that whole hero thing was suggested strongly by lead counsel Escobedo, because the guy didn't seem to have his heart in the question either.
yeah, and he walked away from it right away. But and he got nailed on it by the prosecutor on redirect too.
Yeah, he came back and it was allowed. The judge let them say, because he really didn't say it. He didn't go there all the way. But then the
Yeah.
state said, well, you know, you're not lying here, are you? You know, took it the next step.
Brittany in the chat says, do you feel that the assumption of juries tends to be that the state would not charge a guilty person? I think you mean the state would not charge an innocent person. So it wouldn't be the states to lose and the defendants to prove. So it would be the states to lose and the defendants to prove a crime didn't occur. Yes, that is the modern assumption. It is the opposite of the intention that was the presumption of innocence is long gone. And if you want any evidence that the presumption of innocence is long gone, look how many defendants, not Curtis Reeves, of course, but how many defendants show up in an orange jumpsuit and handcuffs. And when you walk someone into a courtroom in an orange jumpsuit and handcuffs, the perception from the jury is this person is so guilty that they're so dangerous that they have to be restrained in the courtroom. The presumption of innocence to me is a long dead concept that we pay lip service to.
Yeah. Well, in fact, can I plug one of my articles?
100%.
SSR. If you guys go to SSRN and download articles, it helps me. I don't know how. Somehow.
It's in the description of the video. You can click on Steve's SSRN link right there and go check out his library.
Nobody reads my academic writing, so I want people to read it. I don't even know why, but one of them is that you know, you talk about how far the bar has moved on the beyond a reasonable doubt standard. And I wrote an article on this about that, arguing that if you have a one witness case, you have one accusing witness, that is enough. So one person could accuse you of a capital crime and you could go to prison for the rest of your life based on the accusations of one person. And most people, if you said that, they'd say, no way. Beyond a reasonable doubt, they must have tons of evidence. No, one person can say something and put you away for life. Now, the article talks about if there is an inconsistency under oath on an element of the crime, then that should be a JOA granting, because that person cannot be trusted because they're saying two inconsistent things under oath on an element of the crime. It's kind of in the weeds, but it often comes up. We're talking about sex cases. It often comes up in sex cases. I had a case in which I had a client who got life in prison based on a person who got on the witness stand and said, well, he touched me once or twice. And then on cross, and then also in the same direct examination of the state said, he touched me every day for 4 years. And when they were asked, they said, well, which one is it? Is it once or twice or every day for 4 years? The witness says, well, that's pretty much the same thing. And the only evidence was that accuser's testimony. And that's obviously contradictory, right? So I'm saying the JOA should have been granted in that case. Actually, that person got out on a 3850 appeal and had to plead, but did 6 years of their sentence. But that's a longer conversation. But the point is that one person can testify against you and put you away for life. And most people think that can't be. That's not beyond a reasonable doubt. So anyway, That, and it goes to the JOA stuff. So if people are interested in that paper, they can talk about JOA should be granted in the case when you have an inconsistent testimony under oath of one person. Right? Makes sense?
Yeah.
Yeah.
I
I
mean,
convinced
you know,
you
beyond
guys?
a reasonable doubt is so vaguely defined. I mean, just look at the legal definitions. It's the degree of care a person would use in the most important affairs of their life and stuff. What the hell does that mean? That doesn't mean the same thing to every person.
Well, everybody
Yeah.
hates the reasonable doubt definitions. If you look at the jury instructions, it's just a bunch of gobbledygook. It's like, well, it's an undefined term, so we're going to throw a bunch of words at it,
Right.
and now we've got more words, so that means it's defined. No, it's still gobbledygook. And then the jury, once the jury gets it, they can ignore it. They can apply whatever standard they want. We're saying to them, use beyond a reasonable doubt, but they can use any. I think he's guilty. That's enough because they're the jury.
That's the struggle. That's the struggle. And really it's important to remember the perception of the general populace at the time that this was written versus now. At the time that this was written, policing, and particularly active policing, wasn't a real thing. Police were cleanup crews, investigatory and warrant servers. Basically, they would execute warrants from the court, but there wasn't a ready response or peaceful intervention force. There wasn't a beat cop that you became friends with for a really long time in the United States.
There were almost no professional law enforcement. I mean, there were sheriffs that basically worked for the courts. And
Right.
but there were no real police departments like we think of police departments. Maybe New York City had a police department, but you wouldn't find it normally in the country. The police were basically your neighbors.
Yeah, and so it's important to remember that at the time that this was written, and the presumption of innocence, and people's perceptions of the government were skeptical. People were skeptical of this new government that was coming in. They were worried it would be like the old government, where there would be trials where you couldn't have a lawyer, where you might not be able to be present, where the public couldn't see what was going on, all of that. And they wrote a bunch of stuff around that. And now we've taken it for granted for a really long time. And there are people with heavy biases towards police, heavy biases in favor of the court system and the government, heavy biases against anybody accused of anything. And it's the opposite of what it was. And that makes the system in some ways more dangerous. And it's why defense attorneys are more important than ever in the system, because the job of the defense attorney now is to remind, which is crazy. And they say this often in opening statements. My job here is to remind you of the presumption of innocence and the duty of the state to prove their case beyond a reasonable doubt. At the founding, we would assume that people didn't need to be reminded of this because they were more skeptical of the government. And they're like, okay, you show me.
You also have a point about the prosecutors. The prosecutors have kind of abandoned their role as being gatekeepers. You know, it's like the law enforcement is the prosecution. At the same time, because of the politics of it, the law, the cops are for this prosecutor, so they elect their pro-cop prosecutor, and then they basically do whatever law enforcement wants. And so then you get the prosecutor should be a gatekeeper to say, do I have doubts here? They should be working that out ahead of time and not bringing cases that they feel don't meet that standard. But instead, what happens is they can just bring it. Well, I can charge it, so I'll charge anything, and I can throw witnesses up there that I may or not believe, but I'll let the jury decide. And they kind of remove themselves from their role and their ethical duties to not bring weak cases.
Yeah, I have the same gripe generally with just probable cause hearings. I mean, I think they're bullshit in America. I don't think there's a real probable cause hearings. The state comes in and tells a story, and that's good enough.
Mm-hmm.
Yep. In Minnesota, the probable cause hearing that you get, well, the first probable cause hearing, the one on just holding someone until their first appearance, that is literally if you get arrested on a weekend, or Thursday, Friday morning, 12:01 a.m., you're going to be in there till Monday, and they have to call and justify holding you more than 48 hours. So what they do is there's a stack of those cases, and a prosecutor picks up a phone and calls a judge who's sitting in their underwear on the weekend in their house. And they literally read a probable cause statement, absent counsel, absent any party. And then the judge goes, okay, hold them. Okay, hold them. Okay. And that's literally it. It's a rubber stamp process.
Yeah.
It's like, there's no evaluation of this.
To law enforcement in really rural parts of America where they have like a magistrate judge who travels around the county, and the county's huge. Like the county is like the size of Massachusetts, and it takes him a month to do a circuit. So if he just left where you got arrested and you're being held for your first appearance, you could wait literally weeks before he gets back around to you, before you get that first hearing.
And the justification for holding you that entire time is a prosecutor picking up a phone, calling that magistrate judge and saying, here's what the police officer wrote down. That's enough. And assuming they wrote anything down, you're
Because
staying.
then
You're
they
in
have
jail.
sworn testimony that they can base their detention hearing. Well, and I'll say that, you know, from the public defender, I mean, I'm speaking for myself. I'm on vacation right now, but I will tell you, as a public defender and seeing the system from kind of the bottom, a lot of the battles about custody are the battles, because once somebody gets out, they don't have incentive to plea, and you got a free lawyer, so why not take them to trial? So these prosecutors fight like the dickens to keep our clients in jail because they're running up time. So it's like, what, after a while, it's like, oh, it's been 2 years. Well, I'll tell you what, I'll offer you time served if you plead to the felony, right? So then you say, well, I'll get out. So that's what they're doing with the January 6 people. It's like, well, you've been in for a year, plead to the misdemeanor. Why not? Right? Yeah. Because you're on there for a third degree, you're on there for a felony that gets you for 20 years. But I'm offering you a misdemeanor time served. You plea out and we've kept you in custody for a year. Once you're out, you got no reason not to fight. But when you're in, you got every reason to plead. They'll do anything to get out of jail.
Yeah, it's a mess, man.
It's a mess. The system is really, there's a lot of problems right now in the criminal justice system.
Yeah, and the other problem is if you're not immersed in it, and I'm so glad so many people are watching these trials and getting immersed in the system a little bit and getting that exposure, because most people, you're not getting a felony charge. The average American is not getting a felony charge that they have to fight against in their day. So they blissfully don't have to interact with the system in this way. You know, the worst most Americans get, it's going to be maybe a misdemeanor, probably parking stuff, and you hate it, but it's done, and you go home 99% of the time and everything's okay. But when you really start to look at the felony criminal justice system and how broken it can be, but you start to realize that the average person isn't dealing with that. And so when they vote for politicians who say tough on crime, those politicians are saying some sort of meme with no actual experience. And there's ways to be tough on crime, but still tighten up the problems in the criminal justice system. But that is perceived as soft on crime and pitched that way. And soft on crime candidates don't win elections.
Right. Well, it should be. The candidates should instead frame it as, I am pro individual freedom, individual rights, constitutional rights, rather than
exactly.
this, because that's, you know, like an improper process creates an unjust outcome. So you say, well, is he guilty or not guilty? Well, if you prosecute somebody using unjust means, the outcome is not reliable. If you have justice as the procedure and the process, and guaranteeing our individual rights is the fundamental basis of that process.
I talk about it all the time. We cover all these high profile trials. I don't know these defendants. They're not my family members or friends. It doesn't really affect me one way or the other if they get convicted or acquitted. I hate to sound cold, but really, I don't care about them. But I care a lot about the process, because the process that applies to them could apply to any of us.
Exactly. Yeah. No, like this guy, this trial we're covering right here. I don't know which way, if I had to be a juror, I don't know which way I'd vote. But I do care that the system is respected and the law is upheld and the evidentiary rulings are correct, that they're not bringing in evidence that they shouldn't. You know, those things are very important. As far as whether he gets convicted or not, that's up to the jury. But I really do feel strongly that the process should be fair and according to law. And I don't think, does that mean I'm pro-defense? I don't know. I mean, I think the prosecutors should be the same way, because that citizen in that chair is also a citizen of Florida whom they represent. Right. So, but they don't see it. They see it as like, I got to win.
Well, and the tough part about this case is if Curtis Reeves was justified, then he was the victim. I mean, that's what the truth was. And in a perfect world, if he was the victim, the prosecutors would be prosecuting Chad, who would still be alive. And that's in a perfect world where he didn't exercise self-defense, I should say. A perfect world would include self-defense still, I think. But but that would be the way. And the prosecutor should be in the same chair, but they don't come across that way anymore. They don't come across as it's possible that this guy was the victim and we're going to try and get to the truth of the matter. They frame it in their mind so that they can attempt to the best to win as, no, this guy is guilty and we're going to bury him.
Yeah, I mean, to pick one famous case, the George Zimmerman case down in Florida, if Zimmerman had not killed Trayvon Martin, if Trayvon Martin had killed Zimmerman, Trayvon Martin certainly would have been charged and tried for murder.
Yeah. Well, and even if he hadn't killed Zimmerman, it's very possible he would have been charged and tried for aggravated battery.
For sure. Yep.
Maybe even attempted murder based on bashing his head into the pavement.
Except we never would have heard about it because that wouldn't have been in the news.
Right. That would have just been one of a million assault cases that go prosecuted quietly.
And that's a good point that, we're covering these media cases all the time, and the media is like, does that. The vast majority of cases are not this case. Right. I mean, this is a close case, and I understand why it's going to trial and why it's got media interest, but most cases aren't this case. No. And so, but even in the cases that are overwhelmingly pro-state, they still need to respect the law.
Yeah, absolutely.
Yeah, I mean, I tell people all the time, just look at the duration of these trials. I mean, a typical murder trial is a couple days. It's not 3 weeks, 4 weeks. I mean, it's crazy. You don't take a week to do jury selection in a typical murder trial.
Yeah. All right, I'm going to start reading super chats. If anything pops up, or if you need to go at any time, please feel free. But if anything pops up you want to talk about, we can do that. Shredkowski says, been catching up at 2x speed. The lead detective is getting destroyed by the defense. I'd probably vote not guilty based on his testimony alone. Jim Tussing says, oh my God, notes that you shredded. This poor guy. I hope he invited his doctor to the courtroom and certainly hope he remembered his depends. Night of Knee says, holy crap, Russia is shelling Ukraine. Questionable says, there is a video of this showing the punch to Curtis Reeves' face. I'm not 100% convinced that the video shows contact to the face of the punch. It doesn't have to. It would be really helpful for his case if it did. But I mean, there is certainly a video showing movement directly at him that gets very close. I just can't say for sure that it hits him. Robin Lane says, the ex-cop bug guy makes me think of Deputy Dog. Mr. Steve VC, thank you. 11 Bravo Crunchy says, it's super Jussie. Kingslayer Damocles, I give defense attorneys a lot of leeway, but this over and over crap would start to grate on me if I was on this jury. Yep, and that's something they need to consider. DCV Titan says, about half of this cross is interesting. The other is just an echo of Lamar. You didn't investigate the White Claw. Well, the difference, again, the difference here is that the prosecutors were presented with evidence of self-defense and then didn't seem to actually investigate the self-defense. And that bit with the cameras was insane. Frankly.
Yeah, that was nuts because, I mean, road patrol guys, they seize video all the time, routinely on misdemeanors. It's like for a lead detective on a shooting involving death to not get the camera, it's boggling. And then even if you say, well, I'm an old guy and I don't understand technology. All right, fair enough. But you got somebody on your team who does. I mean, that to me is really bad. But, I've seen worse. I got to say, I've seen worse. But he's definitely did not acquit himself well on the stand on that point.
And all he had to say to the tech guy was, hey, get the tapes. Right. Get the tapes. And if the tech guy fails, then the tech guy fails. That's a different story. But hey, get the tapes. That's your job to say that as the lead detective.
The cops are trained that routinely. I mean, they come into a scene like an accident and they'll look around. They'll say, there's a camera here. There's a camera here. Go to that 7-Eleven. I mean, that's basic police work right nowadays.
Jordan we saw that in the Ahmaud Arbery case, right? And even the Kim Potter case. They went around to the local homes looking for, doorbell cameras and found some.
Jordan Crow says, this reminds me of the Broadchurch TV show with David Tennant. First season is him investigating a murder, and second season is the trial. Highly recommend the show. British version, not the American one. Ethan Flash says, is this guy actually Yellow Flash? He's beating the brakes off this witness. Cynthia Cotney says, Your Honor, Bama girl objects to his condescending way of saying Alabama. So there you go. Thank you for that. Rebecca Kalyani says, sad that many say, who cares about this sloppy inventory? Al Fiver says, the witness needs to take the morning after pill. Sean McDonald, defense hit him so hard, he's got early onset Parkinson's. He was shaking there. That guy, he put on a decent face, but you could see when he was turning the pages, man, it was a little jittery. 11 Bravo Crunchy says, this dude just Jack Murphy let someone else bone his career and called out by a $10 super chat. VFM0035 says, based on what we've seen so far, how did the defense lose the self-defense immunity hearing? Because it's actually the self-defense immunity hearing is a much higher standard.
And listen, the evidence is not absolutely clear here. This is an ambiguous case. There's evidence that goes both ways. This is not the George Zimmerman trial. In the Zimmerman trial, there was, to my eye, virtually zero evidence inconsistent with self-defense. That's not the case here.
Yeah, I agree with Andrew. Yeah.
The other thing about this is, going after the weakness of the police officer's investigation is good for a jury. It's not so great at a bench hearing trying to prove self-defense. Like the you weakly investigated this thing doesn't play that well, in my opinion, wouldn't play that well at a bench trial where we're trying to show self-defense, because they're not wanting that's negative evidence for the defense. You didn't find this and this and this that maybe could be there. Whereas for a self-defense hearing where you have the burden, you want to show positive evidence of the self-defense. So you're going to be more focused on Curtis Reeves' statement, Curtis Reeves' testimony, his wife's testimony, and favorable witnesses that could say that they see stuff. You get the experts in there to say, this is what the video shows and stuff like that. So it's different strategy, I think, as well.
I think, when you look at this evidence, if it's clearly a close call of the standard or preponderance, I could easily see it going either way. If it were me deciding on the immunity hearing, that's clear and convincing evidence with the burden on the state. So essentially the state has to have unambiguous evidence contrary to self-defense. I would have granted immunity. I think the evidence here is ambiguous. And certainly when you look at beyond a reasonable doubt, I don't think they've disproven self-defense beyond a reasonable doubt by any meaningful term of that. But once you have that more than zero evidence, the courts don't want to take that away from a jury. So it's going to go to the jury, and the jury's going to make the call.
Right.
Sword and Scale says, Nick, I'm confused about the fancy Cinebistro area of the theater being completely empty. Why are the geriatric theater goers in Tampa so cheap? Kevin Zulik says Reeves should have married Grambo. Yeah, she would have shot that guy twice for him. Hank Reardon says, interestingly, the Zimmerman trial was only 6 months earlier than this. Thoughts on if that played a role in the charging here? Could be. That Zimmerman was down in Miami, right?
No, that was over here. Stanford.
Yeah.
Oh, okay.
Yeah, in fact, but remember, they brought in the prosecutor from up in Jacksonville,
right?
Because there was a what was it? Forget why that was, and that prosecutor up in Jacksonville lost that election. She was lost in the Republican primary. I don't know if you know that, but Angela Corey.
Yeah. So actually, she won her next election, but she lost the one after that.
She was not a good prosecutor,
and she was going to lose that next election. That's why I'm convinced, based on lots of conversations with people who are in a position to know, that she aggressively grabbed that prosecution, because at the time she was running for re-election, a large part of her electorate was African-American. She had prosecuted several cases that the African-American community was very upset with her about, including Marissa Alexander.
The assault case, right? The ag assault case.
That was the ag assault case where she was looking, because of 1020 life, she was looking at 60 years in prison.
They changed the statute because of that case.
Right. There was also a 13-year-old African-American boy who she charged with and convicted of murder, which I think, frankly, was the appropriate charge and the appropriate outcome. I think he murdered the victim, but nevertheless, the media played it up in such a way that it made her look very bad. And there were protests against Angela Corey by the African-American community. Once she took over the Zimmerman trial, those marchers that had been against her had her at the head of the marches, because she was doing now what the community wanted. And she won that re-election. Now, I think she ran again 2 years later and lost. I don't know where she's gone to now. But she was, she was awful. All those prosecutors were I mean,
Horrible,
they were
horrible.
technically good prosecutors, I guess. But the way they conducted that trial was really reprehensible.
Yeah, and the defense attorney is excellent. That was one of the best performances by a defense attorney I've seen in a long time.
They were perfect. I've actually become
O'Mara.
Mark O'Mara and Don West. I've actually become very good friends with Don since that trial. In fact, I was supposed to see him next week, but I'm not sure. I'll have to because I'm rescheduling my motorcycle trip now because we have more snow coming. But anyway, that's the background on Angela Corey.
The interesting update, George Zimmerman's lawsuit was just tossed. It was just dismissed. His civil lawsuit against the Martin parents, Benjamin Crump, and other people for things like defamation or fraudulent inducement of testimony, suborning perjury, stuff like that. That was just thrown out yesterday because, quote unquote, he's guilty. This is a summary of the judges. The judges and the popular sentiment is that well, no, they could say he was a racist murderer because he was a racist murderer, even though he was acquitted, and there's no basis for the racism. But that's the way the law goes right now.
Ironically enough, all the actual evidence at trial was anti-racist.
Yeah.
Anti-racist. He'd actually led protests against the local police department that had beat up a black suspect because they beat up that black suspect. He had marches. George Zimmerman organized marches in favor of that black homeless guy that got beat up by the police. That's how racist he was.
Everything's racist. Don't you know that, Andrew?
Everything is racist. That's like that Lego song. Ed and Steph says, I'll take that bet. Somebody better warn Cheesecake Factory. Ann N says, can we get a body language expert to analyze how few fucks the defense attorneys seem to give about direct right now? Tyler Mueller says, Ben Shapiro leading this witness by the leash. Art and Soul. This case is a perfect example of choose your battles wisely. This was such an avoidable situation. Yep, it was.
That's true.
Lashed One says Morgan and Morgan for the reefer. 2A self-defense law says, Andrew, doesn't this case support Masayub's position on the tell little approach?
Oh, yeah.
Yeah, for sure. Yeah. No, he talked way too much.
Yep. Well, one of his statements just partially buried his motion. Well, I mean, the judge wasn't going to grant it anyway, but she used his statement.
She used it. That whole whoa, no. That did not need to be said in that moment, if it ever needed to be said, and it ended up being used against her. Not rightfully, but nevertheless, it ended up being used against him.
Well, another thing that people need to realize is that you cannot use it in in defense. So you give a statement to police and say, okay, well, but I'm just telling the truth. And you say you get into court like this and you're accused. Say, I want to introduce that statement. You can't do that unless you testify and you're subject to impeachment. So it's out there, but if the state doesn't want to use it, they can bury it. So
you only get to use the adverse party statements.
Right. Yeah.
No, the only reason I could ever imagine saying anything substantive would be to preserve evidence or identify witnesses who may have exculpatory.
Oh, this is my home, and I'm fearful for my life. I want to call my lawyer.
Right.
Timothy C says Dunn stayed in his car and fired into other car as it was driving away. Said guy was getting out to attack him. Forensics and video didn't corroborate story. Victim circled back into lot and no shotgun.
Dunn actually got out of his car. Michael Dunn got out of his car, took a knee in the parking lot, and fired 3 more rounds at the SUV as it drove away.
Yeah, I've seen that case. I've seen that video, I should say.
By the way, that's one of the examples where this is how too many shots becomes too many shots. When Michael Dunn was tried the first time, he was tried for murder. The first shots he fired killed somebody, and then 3 counts of attempted murder at the SUV as it was racing away. It was a mistrial on the murder charge. So at least one juror believed that self-defense had not been disproven beyond a reasonable doubt for those first shots that actually killed somebody. But they unanimously agreed that once the SUV had pulled out of the parking lot, was racing away, there was a long 6-second pause in the action, and then Michael Dunn fired 3 more shots at the SUV. Those last 3 shots, unanimously, attempted murder, guilty, 60 years right there under 1020 life.
CG Roberts says, Nick, the wife is in a different place. Every witness but her one also lines up. If he's reaching over her to get old man, she was in front of him. Oh, the wife is in a different different place every witness. Yeah, I mean Chad's wife.
Yeah.
Yeah, I'm not actually sure if she was on when they're sitting facing the screen. My initial impression was that she was on his right
That's my understanding.
because they turned around and then she would be holding him like this.
I'm surprised the
when
state
he's-
hasn't had more demonstrative aids. Don't you think it'd be good to say, okay, here's a picture, or here's a graph of the. If I was a prosecutor, I'd be putting up all the seats, and this witness was sitting right here.
Yeah. Yep.
Well, one of the problems is that when they get down to it, if they focus too much on what the wife was doing, they got this at trial. The ring was out, which means her hand was against his chest. That was the testimony.
Holding him back.
Like
basically.
this, like he was holding, like she's holding him back. And so, because let's face it, she probably was holding him back. Whether or not he was aggressively moving forward, she was probably holding him back, just being concerned about the rising tension over a stupid cell phone.
Right.
It's a very, very ridiculous situation going on there.
For the person in the comments, there's zero evidence that George Zimmerman was the initial physical aggressor in his confrontation with Trayvon Martin. Zero. None.
And when you say none, there was none raised at trial, and there's none that was excluded from trial. It was only a media narrative
Right.
about the initial aggressor. That
It was
has
just-
never.
that's- Yeah, it's just a racially driven, because the one that everybody agreed on was that the cop that shot the guy, the black guy that was running off, and he shot him from behind in South Carolina. I don't know if you remember that. He eventually got convicted of murder. That did not divide people. Everybody agreed on that case. So that didn't become the big media case. That was right in the same time. And so, the media doesn't care about that because it doesn't divide people. They only care about the cases that divide people.
I think
Just like here, we're covering this case.
I think that cop in South Carolina ended up taking a plea, but it was a big plea. It was 20 years.
20 years, I think. Yeah, I'd plea on that. That was a ridiculous shooting, and he planted the gun. I mean, everybody that looked at that said that was a terrible incident.
But people still say hands up, don't shoot in regards to Mike Brown. And when one thing that was a great exercise for me was reading the grand jury transcripts. Of every single witness who had told the media or said something about hands up, don't shoot. When they got in front of that grand jury and were put under oath, not a single person, not one person said that he had his hands up at any point. And they all said either they didn't see him, or when they saw him, his hands were down. And,
so here's an interesting backstory to that. The prosecutor in that case did something with the grand jury that he was not obliged to do, and that was he gave them all the evidence. The evidence suggestive of guilt of the cop and the evidence that was exculpatory. And the grand jury looked at that totality of evidence and returned a no true bill, refused to indict the police officer. That prosecutor had been the prosecutor in that jurisdiction for something like 50 years. He'd been there forever. The next election, a George Soros funded opponent beat him out, took that seat, and now that jurisdiction has hey, it's not a crime to shoplift anymore. Prosecutor in charge of that jurisdiction. So that prosecutor did the right thing and had the right legal outcome, and he lost his career over it.
And that was the Minneapolis area, right?
No, that was
St. Louis.
Ferguson.
Yeah.
Yeah.
Was it Missouri?
Yeah.
St. Louis.
Yep.
Jason.
By the way, that sends a message to all the other prosecutors, right? If this is a politically energized case, not only do you have to do the right thing, you have to bend over backwards to satisfy the political activists, or they will arrange to destroy your career.
Yeah, this destruction of people is, I don't know. I mean, there's no, like, I think you were saying it earlier about, there's no constituency for criminals.
I'll be right back.
Right? Nobody says, oh, who's going to stand up? But who's standing up for individual rights and individual freedom? You don't hear that.
I think there is a constituency for criminals, because a lot of people perceive criminals as itself being a racist term, meaning people are being unjustly put in prison, are being unjustly racially labeled criminals. And people should not be put in prison for doing whatever, a drug offense or whatever the offense might be. People should not be held without bail. People should be, and a lot of people, their belief is well-intentioned. They just don't think through the consequences that are naturally going to follow. And so, in effect, the criminals have become a constituency. Their loved ones, their parents, their children.
But there's so much racial division that's injected into everything, and it clouds people's judgment.
Right.
And it's not, and that's not individual freedom. That's a Marxist division machine.
Yes,
that is rewarded and empowers people. And the problem is that we're defending people on an individual basis. I have so many cases. I don't even look at the racial makeup of who I'm arguing. I mean, it's the facts are there and the law is there. And that's what I argue. It's an individual client in an individual fact pattern. This injection, I guess I'll speak outside my box a little bit. I am on vacation. This is personal opinion, but I go to these conferences and they say you need to be bringing these motions about racial makeup and racial things, and I'm like, I would be doing a disservice to my client to bring up the stuff that they're telling me I should bring up, these group battles in an individual case. What flies is what are the facts, what is the law, and that's it. Group decision making, like, oh, well, you're guilty because you're white, or you're guilty because you're black, or that's delusional. I mean, what does that have to do with individual rights?
Ultimately, what matters is a political decision, right? And I certainly believe the core is individual liberty, just as you've described. But right now, the president of the United States is saying he's going to appoint a black woman to the Supreme Court. That's not an individual merit.
Terrible. No. And then the commentator, I think it's in Georgetown, Shapiro, comments about, I don't think that's such a good thing because there's a friend of mine who's Asian or something, and they're the most qualified person, and she's being excluded. And then that person gets run out of academia. I mean, like I write all these articles, and
by the way,
like,
Biden announcing that intent is purely political, because he could do it and just not say he's doing it and nobody would know. He wants people to know he's doing it for racial reasons.
Yeah, it's so divisive, and that's a poison in our society. And I really do think it's a racial Marxism that I don't know how it's a poison in the Western culture. It's in every country, and it's really been used to great effect to divide people. And you never know what you're dealing with juries, because I mean, how many of the people on your jury are playing these games?
Oh, we see it all the time. We see jurors going through voir dire, and that one is lying their ass off to get on the jury. They are like super impartial and super biased. It's ridiculous. And as soon as they get on the jury, it's going to be the other way.
Yeah. And in an ideal world, Joe Biden's announcement of choosing a race and gender-based candidate rather than the best candidate would be a 14th Amendment violation. But
wasn't there was when Amy Coney Barrett was up for the Supreme Court, they were making religious tests, like, are you a fundamentalist Catholic? Do you believe, right? Do you follow the Pope, right? And they were basically putting a religious test in their votes.
Yeah.
And that's it's basically become so politicized. But the court has become politicized, and that's what we're seeing is the effect. I mean, the institutions have been corrupted, and I think the conservatives, who are generally the defenders of institutions, are seeing the corruption, and a healthy left should be the critical check on corruption of systems, right? That is their place within the society, is to have a left that is critical of corruption within institutions. But when you have an unhealthy left, they're basically out of control and destroying institutions. The conservatives, how do I defend the institutions that have been corrupted? It's a real problem with the country. I'm getting a little broader than maybe our coverage of this trial, but it's a problem throughout the society.
Doesn't bother me, especially because you're right.
In more ways than one.
Jason Semedru, welcome home. Jason Semedru says this prosecutor looks like Italian Fredo, if you will. Otto Rommel says you would agree that Andrew's book, Law of Self-Defense, is amazing, correct? Steve H says, are the Phoenix Wright games any good? Also, Steve, are you a gamer?
Me? Well, I'll tell you, here's the gamer. He's going to walk behind me. Go ahead, walk behind me. Wait, there he goes. Gamer
Wow.
number one. Just we're working here.
Yeah, don't worry. Shh.
For
I
certain
use-
values of work.
The problem is I'm a little bit obsessive in my personality. So I know that I used to game, like Civilization. I like big grand strategy games like Civilization and things like that. But the problem is I get so obsessive on them that I played this game called World of Warcraft. You ever played that dumb game?
No, I played EverQuest, which was, like right before it.
Oh, it was well, I got so good at it. I was like the top mage on my server. I was like number one. And then they upgraded it, and it was like all my characters that I'd spent all this time on building up all of a sudden became all useless and outdated. And I was facing the prospect of another 2 months of work to get up to the level I was at. And I was like, forget it. So I quit it all cold turkey. So I don't even have games on my computer, but I love them. But that's the problem. I love them, and it's a waste of time.
Yeah, you got work to do. Also, the Phoenix Wright games are garbage and terrible. I hate them. I hope they die. I hate all visual novels. I think all of them should burn in the fires of hell. Paul Forster says, have you heard of prosecutor Deborah Davis from Michigan? She has a YouTube channel. Would be cool if you invite her to be on as a guest sometime. I had never heard of her. No, I'm surprised an agent of the state would have a YouTube channel. That's kind of risky for them to do. So this might be more risky for her to come on this show.
She might have to listen to my jokes.
Yeah,
like,
that's
hi.
right. Just because we're on here with you, Andrew, doesn't mean we're agreeing. We're just laughing.
I'll have a banner across my image, jokes property solely of attorney Andrew Branca. Do not reflect the opinions of the
other
title law.
Right, yeah.
Can I license the jokes, please? I'll pay for them. Barron's guy says, unbreaded, back to Viva. See you when he's arrested. Yeah. Viva's been covering the Ottawa stuff. I think he had 24,000 watching his live coverage up there, which is awesome. Jackson Kai says, my biggest issue, if I was on the jury, is we know he reached over the seat since he had the defendant's popcorn. So witnesses that say he didn't seem coached. I mean, that is a problem because like all of them are like, oh, he wasn't leaning over the seat or reaching over the seat. It's like, oh no, he's standing perfectly upright, but his arms must be 7 feet long to reach and grab the popcorn. And I think that's kind of where the defense was going with the, you didn't measure the distance between these two seats. You didn't do that.
We might see that with defense witnesses, don't you think?
Right.
Yeah.
Yeah. I think so.
And the defense will play that same video and highlight what they see as that initial arm reach, right? The initial blow to the head that precedes the popcorn. But this guy would have had enormous arms. I mean, he's 6'4". His reach would have been like 40 inches or something ridiculous.
I'm 6'2". I got pretty long arms. I don't know.
Those rows are not that far apart.
Yeah. So, but he's also standing up. So the idea that he was able to reach, grab this guy's popcorn, which is going to be a couple feet away from his shoulder still, or more than a couple feet away from his shoulder. If we're talking 6'4", reaching down into someone's lap who's in the row behind him, he has to lean over the seats. It's physically impossible for him to stand up. I would wager. I mean, maybe they'll, and the defense, if they have any semblance of sense, which they seem to, they're going to have a rough measurement of how long that would have to be.
Yeah, I think you're going to see that the defense is terribly prepared. So, I mean, well prepared, excellent preparation. So I'm sure they've gone out to that theater, measured stuff out, taken pictures. So I'd expect, did they say they were going to have a cop testifying for them in the defense?
Yeah,
the guy a bunch of experts coming.
Okay,
well,
that's going to be fun.
One of the cops testifying, he's the guy who was supposed to get who ended up getting the footage off of the hard drives.
Oh, right.
That's the guy.
That happens more than you know. Like, we have some great defense attorneys in our team, and some of our trial attorneys are unbelievable, and they find stuff. I don't even know how they do it. How they find stuff, like, because they start with a police report, because the public defender 101 is you take the police report and you say, okay, we got this witness, and this evidence, right? That's what I got to work with. But public defender 105 is that they say, wait a second, I'm going to, start with that, but then I'm going to find all sorts of other witnesses and other evidence. What evidence is there? And that's the advanced level attorneys that you see. So these guys are doing that. So I'm expecting to see that with their experts.
Zombie Shoot says Rittenhouse lawyer style. Turn off the cell phone or I'll open havoc on your ass. Catherine Ruck says, put your money where your mouth is. Money equals speech. Patty Girl says, oh, hey, who's this guy?
Hello.
Hey,
How you doing, man?
It's good to see everyone. How's everyone doing?
awesome.
We're great.
Hello, Steve.
Hello.
Yeah,
Good
Kurt
to meet you,
meets Steve.
Mr. Uncivil.
Hey, Nick, we're going to have to reschedule our dinner.
Why is that?
Were we going to have dinner?
You're talking to Kurt, not Nick.
Kurt, sorry. Sorry.
I'm like, well, it's a
Got
little
so many people
forward,
here
but
now.
oh my.
I got to reschedule my trip down to Texas.
Okay, fair enough.
We got snow coming in when I was going to leave, and motorcycles and snow don't mix very well. So
Okay, no problem.
Yeah. So Steve, this is Kurt. Kurt, this is Steve. Steve's a public defender down in Florida.
Sweet.
Also, a bit of an academic who does a lot of writing on SSRN. So if you want to read some law review
Ooh.
articles,
No, I know he's serious.
they're in the his
Glutton for
link to it.
punishment.
The links are in the description. Links are in the description. So if you wanna-
I can't be. I'm too lazy for that, so I just make YouTube videos instead. It's like an SSRN, except not in every way.
This is so much more fun. Let me tell
Yeah.
you.
Let me write a
It's like-
35-page paper on the 18th Amendment implications of marijuana prohibition.
Yeah. See that?
And
That is
yeah, it's
tasty.
like maybe I won't do that. That's because that sounds boring.
Patty Girl says, I'm new to this channel. You guys are great. Love the coverage. Keep up the good work. Hey, thank you. Welcome. Josh Vermillion says, screw all these sandwich ideas. The way to go is 1/4 inch of peanut butter, all the grape jelly clumps, and a layer of regular salted Lay's potato chips. Okay. Nikki Giannopoulos, thank you. Joseph DeMartino says, the prosecutors weren't older and more experienced when this trial started. That's true. Fiery Red Podcast says, depending on Kim Potter's sentencing tomorrow, how much am I freely allowed to criticize the judge publicly? Obviously, no threats or things like that. You are able to criticize the judge as much as you want, outside of any sort of threat or harassment. You cannot, you shouldn't be reaching into the judge's life to criticize her, but she's a public official. You get to say that she's as smart or as dumb as you think she is.
do it from outside the courtroom.
Yeah.
Yeah. Don't be in her house or in her wheelhouse or in her job. Because if you're in her court, she can hold you in contempt. But everywhere else, you can do as much as you want. G says, Nick just accepted my first big girl real world job yesterday. Can I get an infamous toast if it's too early for you there? Any words of wisdom? Too early. Yeah, we can do a toast. Let's see. To G, I've got this Bushmills 21-year Irish whiskey that we're going to have a little bit of. G, you're accepting your first big girl real world job. You're stepping out into a different type of career, a different type of employment opportunity, and may the world of networking and corporate maneuvering, we'll call it, may that be beneficial and fruitful for you. I hope you find lots of success, meet great people, learn new things, and advance ever forward in your endeavors. Cheers.
Cheers.
Nikki Giannopoulos says, Reeves lawyers represented me in a 3-year mandatory minimum case. They wanted me to open plea because of my clean record. I got 3 years in and 5 years probation. I paid $20,000. So not,
well, it's hard. It's hard to judge cases. I mean, it's individual results. You don't know what the facts are,
Right.
So,
right.
It's easy to criticize, but it's hard to, well, like nobody, being a public defender, nobody ever appreciates what you do, because if you get a not guilty, they say, well, what took you so long? I've been doing this all the time. What have you been doing? Of course I'm not guilty.
Yeah.
So it's pretty hard to win as an attorney.
Yeah. Sorry that was your experience. That sucks. I for one am opposed to mandatory minimums in general. I think they're terrible, but that's me. Bill Anderson says, is Steve actually actor John Billingsley? Well, Steve, are you?
No.
Okay, thank you. Now that we've
Who
got
is
that on the
that?
record.
John, I'm going to look him up. I'm going to Google that now.
Yeah, John Billingsley. Bogey 34 says, any difference you'd make arguing to a jury of 6 versus 12? I don't think so.
Well, 12, that's with a death case, you've got 12. And when
Right.
you have only on a capital case will you get 12 jurors. And
In Florida.
In Florida.
In Florida.
Yeah.
And in those cases, well, are you familiar with the Colorado method of jury selection?
I'm not.
No, well, there's actually a method that was perfected in the Aurora shootings where the state kept objecting to defense questionings of jurors, right? And so a bunch of lawyers out in Colorado got together and said, okay, we're sick of these prosecutors objecting to everything we ask at jury selection. We're going to come up with a system and a technique for selecting jurors that is by the book and correct and effective. And it was and if you remember, the Aurora shooter got life, which was if anybody wants to see a great closing argument by a defense attorney, watch that defense attorney closing argument in that case. She's amazing. The whole case was directed at getting a life sentence because that's a victory for a defense attorney in a death case is a life sentence.
Yeah.
And anyway, that system is now kind of colloquially called the Colorado method. And what it requires is a system of questions that you asked one by one, and then you have a second chair who categorizes the answers based on the way that the answers are given to categorize them on a schema of 1 through 7. The object is to get jurors that are in the middle or at least a little pro defense. So I don't know what's first that question again. Oh, the 12 jurors. So anyway, there's a system. It's really the right way. It shouldn't be called the Colorado. It should be called the proper method of jury selection. But anyway, that just kind of hit my mind when you said 12 jurors, because doing death stuff is a whole different world.
Yeah, in Minnesota, you basically get a jury of 12 for any felony case. And 6.
Well, I would imagine you'd want more. More is better because you got more chances at getting a holdout.
Yeah,
if I can get 50, give me 50.
Right, they'll never agree.
But the question though is there any different arguments you'd make on a jury of 6 versus a jury of 12? I don't think so. You're really always arguing to a jury of 1. I mean, that's the goal. You hope all 12 of those ones agree, but you're arguing to a jury of 1. Your job is to convince one person. Now,
Steve, to your knowledge, does any state other than Florida use 6-person juries for felony cases?
I don't know. I'm just licensed in Florida, so I don't.
Yeah, because when someone mentioned to me, I thought it was the most batshit crazy thing I ever heard of in my life.
Really? Which jurisdiction are you practicing?
I'm licensed in Virginia and I live in Texas.
I went to school in Virginia.
Okay.
Washington and Lee.
Yeah.
Generals.
Yeah.
Big powerhouse in the Division 3.
I've heard of 6 persons for misdemeanors, but never for felony cases. That was like, okay, that's a different thing.
No, we get 6 persons on everything.
Yeah, that's all right. That's strange to my mind, at least. But I guess you guys are comfortable with it in Florida, so you do you.
It's not my call. I with Andrew. He says, "I'll take a 50-person jury."
Yeah,
that's a good idea.
Could you imagine how long voir dire would take? So we're gonna panel 50 of these assholes. Strap in.
That would be a good exchange. And no, you get 50, but no voir dire. Just the first 50 to come in.
You know, it's not the worst idea I've ever heard in my life, to be honest.
It's actually not that bad. Yeah, on a big enough jury, but you could do that 1 versus 100 method, right? You got 100 people come in and sit down. It's like, this is a whole jury pool. We're gonna get this thing done in 20 minutes.
I actually like that. How about no cause, no preemptories? We're just saying the first 12 that sit down, and if you can't get a conviction, then it sucks to be you. How about that? That's a representative sample.
What is it? I think it's a Bill Buckley quote about, I'd rather be ruled by the first 100 people in the phone book. And when I was prosecuting, I prosecuted for 6 years. That was the philosophy of my supervisor. And that's kind of what I took, which was just take the first people. You're the prosecutor, you're the state. You don't have much of it. If there's somebody that's obviously not going to be fair, but otherwise just take them. We want the trial. Let's go. As a defense attorney, we have a much different voir dire is a lot more important. I think jury selection, you can win or lose a case on jury selection.
Absolutely.
Again, that's one of
For
my
sure.
one of my major weaknesses, I can say, as a trial attorney, and I always like getting a second chair on that. But it is a very, very important part of the process, because just like you said, this case, we were talking about it, this case is going to rise or fall on what the baggage the jurors bring in. As you can see from the poll of your commenters or your commenters on this site, they're divided. So they're really coming at it with their own perspectives and judging the case by their own perspectives. So that's why jury selection is critical.
And judging the case on things other than the law and the evidence, like who would bring a gun to a movie theater? That's crazy.
Right.
That's not a relevant issue in this trial.
Stephen Cooper says Steve Gosney is now one of the best attorneys on YouTube.
Oh, there you go.
Make
That's got a
Orwell
promotion.
Make Orwell fiction again, says Branca likes his Seals and Croft. Andrew Clark says peanut butter and jelly Eggo waffle sandwiches. That sounds good, actually. Legitimately delicious. JDig 1982, thank you for the donation. Dwayne Beeler says, Andrew, did your wife go to the concert with a Tinder date?
No.
Kurt, we found out that Andrew's wife went to the Tool concert alone.
Okay.
For whatever, I don't know what that means, but it sounds like we're poking out a soft spot.
It means I'm not listening to Tool for 4 hours. That's what it means.
It means Andrew's an old curmudgeon. Turn off that noise. It's music. Shut up.
It's terrible. It's so terrible. It is noise.
Nick Naylor says the Bam Margera lawsuit might be worth covering. Maybe. I don't know anything about it. Ed and Steph says, can we sue Law and Crime to improve the stream? No, nothing they do could improve their stream. Crusader Saracen says, when is that Denver attorney coming back on? Who's a Denver attorney? I don't remember a Denver attorney specifically.
I mean, I think they were meant me, except I'm not.
You were on the whole time.
I'm 20 minutes out of Denver, but I was here.
No,
are you north or south of Denver?
South, between
Crusader,
Denver and Colorado Springs.
Crusader, I don't think you're talking about Andrew. Who are you talking about? Crime Talk with Scott Reach. That guy, he's great. He's also really busy. I sent him an invite yesterday, but he was in court. G says, wife civil lawyer always whispering to her. Why? She probably has questions. Also, maybe he's just whispering sweet nothings. Wolfgang Deo says, I love going into Cambodian live streams to teach them about freedom, human rights, and revolting against tyranny. They really get into it too. Okay. Automata says, they all say flick, but what about my flicker? Tor Theo says, if I was a prosecutor, I'd get past the dark and loud and ask, could you see and hear? Yes, thank you. Everything else is subjective definitions.
Right.
Yeah, but the problem is they already answered.
Too. I mean, so you can see, I mean, clearly it's not pure blackness. You can always see something, right? You can always hear something.
Well, I think that, jurors don't like quibbling over semantics, which I think lawyers like to do and defense lawyers like to do, which is like, well, you said it was dark, but it was actually dim. I mean, that's the sort of thing that jurors are like, come on. But they get all focused. They think they've got a really good point. I remember I had a defense lawyer when I was prosecuting again, which is a long time ago, but we had a case. It was a guy. The question was whether there was blood in the yard, and the defense attorney had depoted and gotten the cop to say that there was blood in the yard, but it was actually kind of in the culvert area, but it was still grassy, right? Oh, and he just hammered. Oh, so you're admitting it. And the cop comes back, and on redirect, I just said, so is this the yard? Is this the yard? And the jury was just rolling their eyes. So, you got to be careful in those kind of fudge words, because the witness is going to come back and say, yeah, well, dark. I mean, it's not sunny. And then the juror's going to say, that's a stupid point. So don't make stupid points if you're a defense attorney.
How many cases as a prosecutor did you binger?
Did I what?
Did you binger?
Did that?
Did you railroad someone who's obviously not guilty because of selfish pride and ego?
Well, of course, none.
Deep Service says the mask is to hide pillow burns equals face down loving. Okay. Adam Pennington says he's the kind of guy that offers his girlfriend's boyfriend a glass of water after the boyfriend gets finished beating up her sugar walls. Oh my God.
But someone in the comments had said, "Oh, he's not gay, but his boyfriend is."
I am
So
not
wrong.
gay. I have relationships with women and sex with men.
I don't know what was up with the mask thing. That was stupid.
I think just because he was a nurse, I think that was the main thing. So maybe that's it. I don't know. They shouldn't allow anyone to testify with a
I
mask.
agree. Absolutely. 100%. I think because how is the jury supposed to assess this guy's credibility, but let's put a sheet of paper over his head. No, assess.
Yeah. For many of these trials, it was also, how is a lawyer supposed to know how all of this is affecting the jury?
Yep.
How do you know how they're responding to what's being said or what your arguments are?
Yeah, that was the Chandler Halderson trial. Every witness was offered the opportunity to wear a mask or not. And so that they would come up wearing a mask, and the judge is like, well, if you think you can safely testify without a mask, we ask you not to. And then everybody kept their masks on. Safely testify. You're 80 feet away from anybody with plexiglass everywhere. What are you inhaling?
Hey, there's a Washington and Lee grad in the chats. How about that? There's only a few of us. So we got to shout out when we are because we're so few.
And she's one of the first class of women. Very cool.
I know. Salute. I was class of 99. Hell. She's 89. She's 10 years behind me.
JP
Washington
says,
and Lee didn't let women in until 1989.
Hey, we're progressive.
1986.
Very progressive.
Wow. That's a little late in the day.
JP says he may be wearing the mask because his employer might be watching, and it could result in disciplinary action if he's not masked in public. It's a possibility.
It's Florida. Come on.
Cameron Nelson says, I'm getting liminal order vibes from this witness. Catherine H says, beta. Daniel Tarasevich says, peanut butter and honey. The one person who has a YouTube profile with no name said, I don't know how you did that. Says, are we sure that's not Gavin Newsom? We are not. Scarlet Hawk, thank you for the donation. If I missed that earlier. Automata says, you wouldn't know my girlfriend. She lives in Wisconsin. Her name is Claire. That wouldn't happen to be Thomas Claire, would it? What a twist. Not applicable says, girlfriend is a giant hand named Handy McDaniel. Avahine says, witness should eBay that ticket stub. Trashman says, the binder is the lead counsel's Book of Grudges, Volume 8. He will be using it later to bombard a mass of greenskins. Aiden Ramos says, didn't see your girlfriend in the video. Is her last name Cena? Not applicable says, defense being an angry grandpa here feels like. Yeah, he was kind of being angry. 200 Watt Studio. Defense attorney looks like the principal from Back to the Future. You're a slacker, McFly. Justin P. Hey, shout out to Steve. He's been a good guest on the show. Now we just need him to make irreverent jokes about the witnesses. Quantum Bits says, someone needs to give that prosecutor popcorn to throw at Curtis Reeves. Ben Samuel, you're technical experts and you experience dozens of details when you go into court. For us, it's just walk in here, go there, say stuff, and there's far less detail to link to existing memories. I actually disagree with that. I think it's a little more routine for lawyers, especially trial attorneys, to be in court hearings all the time and make them unremarkable. Whereas people who go into court to testify in a murder case are doing this, once in their entire lives. Unless you live in South Chicago, then you do it every week. But, so I
Can
thought,
I ask, what is it, being an outsider here and looking in, but is the peanut butter and jelly references, is that like the thing where the prosecutors say to have elements, you gotta,
no.
is that what that is? Or what is this?
I'm just an autist on sandwiches. Yeah. And so when anybody makes a sandwich that is not just made in the obvious correct way, it drives me nuts. And so I mentioned you put peanut butter on one side, jelly on the other, and put the sandwich together. And people are like, no, you put peanut butter down, then you spread the jelly on top of the peanut butter, and you take a naked piece of bread and put that on top of the slurry mush that you have, which is disgusting. I don't understand that.
You know about the peanut butter and jelly jury selection method?
No.
I don't know what it is. Maybe it's just Florida. Maybe Kurt can chime in on Virginia, but prosecutors love to say, well, in order to prove a case, it's like having a peanut butter and jelly sandwich, and you got to have the peanut butter and the bread and the jelly and the peanut butter. If you don't have the peanut butter, it's not a peanut butter and jelly sandwich. That's like standard trope. Actually, it's probably defense attorneys that do that kind of thing of it. But it's like every time I hear that, it's so overused that everybody rolls their eyes. It's kind of like when
Come up with something better.
Right, it's kind of like when the new attorney out of
Couldn't
law
you mix
school,
it up and like just throw in other food edibles? Why does it always have to be the same thing every time?
Yeah, make a sub. But people go and they say, I strenuously object. You when you're first out of law school and everybody rolls their eyes strenuously, right?
That's from A Few Good Men, right? I object. I strenuously object. Oh, okay. That's where it makes a difference.
Well, in that
All right.
case, I'm going to change my ruling.
No, just for me, like if you ever hear something about a sandwich, for me, it's literally about sandwiches. I'm still bitter over Subway getting rid of the U-cut. I'm still bitter over it.
Okay, then.
And everybody else should be too.
I'm now clued in.
You remember the U-cut, right?
I remember. Yeah, they V-cut. Yeah, but yeah.
Yeah, so you used to go to Subway and they would cut a wedge out of the top of the bread. And they would peel that off and then they lay everything in there nice like a boat. And then they'd slap that thing right on top. And all of your stuff was in every bite like it was supposed to be. Now they cut it on the side and then they stuff this thing like a bread taco. And then they squirt mayonnaise on the outside of it like an idiot. And then you're holding this thing. And if you take a bite of the sandwich, it launches out. Otherwise, you got to hold it straight up. I hate it. It's stupid. Go back to what you know, or just cut the bread all the way in half like a normal sandwich and lay everything down and then put the bread on top. God, I hate Subway.
Go to Publix. Do you have Publix subs? They're the best.
I live like 1,800 miles away from the closest Publix.
Wegmans, I think, can put a light to Publix. They do some really good shit. Yeah,
I don't even know what a Wegmans is.
Okay,
these things don't exist where I live.
Harris Teeter.
Have a Harris Teeter. I was going to Virginia guy. Harris Teeter.
Oh God, no, sorry. No, there's no good food in Minnesota. Danny Conley says, since they had self-defense hearing with these witnesses and they lost it, could all these witnesses have had their minds skewed that he's definitely guilty? So their memories are reflecting that. That's possible, I guess. I don't know if they do or not. You would never know.
I mean, they've had 8 years of propaganda, if nothing else. So,
yeah, that's the main thing that would be doing it. Self-propaganda and the media propaganda. Nadim Hasso says, thanks for streaming. So glad I found your channel. Thank you. Fat Panda Frank says, okay. Cameron Nelson, did state not prepare because one guy had gun, one guy had popcorn, thought open and shut, but now realizing they're leaving the door open?
Probably.
Yeah.
They were hoping it went away. Yeah, they were hoping it went away by the guy dying at 8 years.
Not applicable says he made defendant sound guilty. That's why. Also, can't buy him if he cooperates from the beginning with the plaque. Yes, that was still a mess. JDig 1982 says if B. Ivory Lamar was his lawyer, his defense would be, Your Honor, my client slipped on the butter from the popcorn. His gun just went off. Tor Theo says if Canabro can have a hot girlfriends, why not this guy? It's a good point. That's a good point. Sword and Scale. Nick, have you seen the lunatic that admitted to hacking Give Send Go? I have only heard about it. I haven't seen it yet, but yeah, that's crazy.
It's exactly what you'd think when you saw him. He looks exactly like you'd think. Put
him in prison. if you're admitting to hacking a company like that and disclosing a bunch of personal data, put them in prison. That's what you would normally do, right? But we normally would do that. That's got to be a cyber crime, I would think.
No, only if you're on the right.
John O'Mara says, memory gets worse as you age. At least I think it does. Well, does it or doesn't it? I don't know. I can't remember. Kenneth Slayer says, best PB&J is grilled PB&J. Phantom Hive says, the last witness heard whatever was thrown hit Reeves. Could he really hear popcorn or was it the phone? Yeah, they didn't really focus on that too much on Cross. I was kind of surprised that he did say, I heard something hit him. Tobas says, oh, Tobas, you're the guy who did the unbreaded remix, aren't you? Thank you for that, by the way. Your Honor, I'd like the court record to reflect that the unbreaded remix is now on Spotify. Link in the original video description. So yeah, you guys can go check that out. It's great. Leaf Me says, I have a question about hearsay. If you committed a crime, then got drunk and told someone and they reported you, would that be admissible or only used as a method of finding potential suspects? No, that's admissible as a party statement against interest. It's an exception to the hearsay rule.
Or non-hearsay if you're in the federal system.
Do you practice federally?
My primary field is patent law. So yes.
Okay, excellent.
Bear. Oh, hey.
It's a real lawyer. That's not a schlub sounded. That's somebody who really. Federal law is a whole different world. You got to be on your A game for that stuff.
Bear Business One says, when did James Carville get the red tie and start being a lawyer? Yeah, kind of looks like the lead counsel for the defense. Sword and Scale. A cell phone isn't a deadly weapon. Have you ever heard of a cell phone all called Twitters or cell phone app called Twitter, sir? Yeah, exactly. Tor Theo. Defense is full of BS. Can I shoot someone in public, claim I was threatened, then go, well, nobody didn't see me not get threatened. It's nonsense. The reality is, yes, you can actually do that. And as long as your defense is reasonable and they don't have any contravailing evidence, then yeah.
And ultimately, would you want to be put through what this guy's been put through? I mean, it's not like a snap decision. I'm just going to go out and shoot somebody and get away with it. I mean, the guy's his life has been in the balance for 8 years and been put through hell, I'm sure. Even if he wins, he loses. So, it's not like people are just saying, oh, well, the law is so ridiculous, so I can just go out and start blasting away. I mean, that's not really what's going on in the world. Like, I remember when they passed the standard, Andrew probably remembers this in Florida. Remember they were saying it's going to be the Wild West in Florida and people are going to start shooting each other?
Blood's going to run in the streets. People are going to shoot each other over shopping cart bumps. It's the same every time they liberalize a gun law or liberalize a self-defense law. And of course, it's all nonsense. And then for years later, after Stand Your Ground in Florida, the local news media would run all these stories about how homicides had increased in Florida. Which may be true, but there's homicides, and then there are homicides.
Murder,
right? There's murder
homicide,
and self-defense, and maybe a lot of those homicides were people who actually felt comfortable enough to defend themselves from a deadly force attack.
Aiken says, "Is the judge a diversity hire?" I have no idea. Sword and Scale says, Nick, why are TV courts so cool and old-timey looking and real courts are like a gas station bathroom where you could catch a new strain of cancer AIDS?
Sometimes they're
Perception
nice.
versus
The
reality.
Rittenhouse court was nice.
Yeah, except for that one section of the ceiling that hadn't been fixed yet or hadn't been updated. Normally, federal courts tend to be a lot nicer than state courts too.
Oh yeah.
I went to federal court once up in Jacksonville. And I walked in there and I'm like, what is this place? There's nobody around. There's nobody in there at all except a bunch of guards in the front. And you go through these palatial things, you in the courtroom and the judge, and there's nobody around. It's a huge courtroom. Unbelievable. But a lot of it has to do with tax dollars. If you have a poor county, which this is Pasco, right? Which is a poorer county. So they're not going to have extra money sitting around to build a new courthouse. So you're going to get an older courthouse generally.
Yeah, just ask Judge Borkowski how he felt about the resources of the courthouse. Like, this place sucks. The technology sucks. It sucks, I tell you.
Look,
that was
be very
Rittenhouse
discerning. That was Theodore Edgecombe.
Yeah.
Okay.
He's like, be very careful going to the cafeteria. I want everybody to actually make it back here after lunch. Be careful what you order.
Take your chances.
Disgusting.
You're willing to risk it.
That guy, I want to cover only cases in his court because he's just a riot. Jordan Wolf says he said at least 5. Thank you. Thank you for clarifying. Radioactive Llama Pajamas. Nick, does Steve's jelly have roots or is he unbreaded? Steve, do you put jelly on like when you make a peanut butter and jelly, you put the jelly on the bread, right?
Right.
Yeah, because the jelly has to get roots down into the porous bread.
Okay. Yeah. My technique, I never do a half a sandwich. Take one piece, put the peanut butter on one bread, jelly on the other, and go.
Perfect.
And then I cut it in half if I want, cut it in half so that it's easier to bite.
Yeah, if you're going to have half a sandwich, make it that way, cut it in half and throw half away.
I'll never throw it away. I eat the whole thing.
The way I do it, actually, this is degenerate and everybody hates it, but it's really delicious. It's peanut butter and then a third slice of bread in the middle that has butter on both sides. So it's peanut butter, 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 jelly.
Wow.
Oh, it's so
Peanut butter,
good.
butter, jelly.
Oh, it's so good. Ponton21 says, isn't this just a case of bully getting what he deserved? Seems to me those who think he is guilty are bullies hoping to protect their own illness. I don't know. I don't think that it's hard to say. Some people, I can do it this way. My buddy played soccer. I played soccer too, but he played at a higher level than I did, and he played for longer than I did. And he actually got a decent suspension. It was like 10 games or something, because he was confronted by a referee, made a bad call in his opinion, and he had a habit when he would get mad at someone, rather than hit them, he might like take their hat off, and he took a referee's hat off, right? Like he was intentionally not harming the referee, but he did an aggressive motion and he made contact with the referee. That's against the law in decent society. That probably would have been a battery outside of a sports field. And so while he had no intent of being a bully, he was reacting emotionally to something in a bad way. That could be what was happening with Chad here. He grabs the guy's popcorn. Maybe he hits him. Maybe he doesn't. I don't know. That's not the question for self-defense. But if we look at the situation objectively, it might be that the guy's just like, this guy's being such a tool, and he grabs the popcorn to teach him a lesson. And that's the wrong thing that gets him shot. Doesn't make him necessarily a bully, but he might have been a bully. Don't know.
Not relevant.
Yeah. His intent and state of mind isn't relevant. The only intent and state of mind that's relevant is Curtis Reeves, because it's self-defense. Was he reasonable in his action? And what were his intentions?
Or did he reasonably fear an imminent touching which would cause a great bodily harm, right? That would be the he was being attacked with a cell phone. Andrew brought up something too, which I don't know the answer to this, and it'll be one of those things you'd really have to research, but about the fact that Florida has a 65 or over statute. So if you batter somebody who's 65 or over, that is a felony. So, so the fact that he's simply battering him, that is a felony battery simply by the fact that the guy is 65. So
And I think that's an argument. I don't think it's a strong argument. I think technically the way the statute is worded, it conditions that. First of all, I think it's really a sentencing statute, but it conditions this elevation from a simple battery to a forcible felony. The first sentence in the paragraph in the statute is, if someone is charged with the battery, you have this effect. But of course, Chad Olson was not charged with the battery for the obvious reason that he was dead. So I would argue that although philosophically it would, you could try for that and say, well, he committed a simple battery on someone 71 years of age. Statutorily, that would qualify as a forcible felony. Therefore, this is a felony. But I think it's a stretch based on a technical reading of the statute.
Yeah, and importantly, that doesn't seem to be their main argument at all.
I mean, don't get me wrong. I would argue it, but that's the other side of the argument.
But you'd want to obviously I'm sure this defense team has researched that and said if that's a good argument or not. And it sounds to me like they went with the burden of proof issue.
Yeah, I mean, if they're arguing, they're trying to get robbery as the felony, right? For the taking of the popcorn.
Well, that's like my Chad. That's my Kyle Carruth and Chad Reed argument, right? Like technically, it's a burglary.
But if the state, but the thing is if the state was charging him for the thing, they would be damn well on board with the whole robbery thing. They'd charge if that guy was a convicted felon 10 times and he did that with the popcorn and they charged him with robbery, they'd be all out and said, "Oh, this is technically a robbery."
Yep.
So with the shoes on the other foot, they don't like it so much.
Yeah, no doubt.
Barco Verrer says, could you ask Jimmy James from New Radio who among Joe Rogan, Andy Dick, Phil Hartman, Dave Foley, and Mara Tierney was his favorite co-star? I think they're calling you Jimmy James from News Radio. Dr. Evil Barbecue says, big difference in this case is the defendant highly trained and experienced in policing and knows what to say and what the courts want to hear to back up his claim for self-defense. I think that this
Yeah,
was maybe a response to the question of what's the difference between him and Theodore Edgecombe. Well, there's also a serious difference in physical disparity between the parties. And one of the most important aspects of Theodore Edgecombe is the only person who testified that the attorney was advancing on Edgecombe was Edgecombe, whereas lots of people have testified that there's a motion towards Curtis Reeves.
But what I think he's saying though is that the defendant is using his experiences to say he's an educated witness, so to speak. So when he knows what to say to push the self-defense buttons, and whether he could be impeached for that by the state is an interesting question too.
Yeah, and it kind of an interesting problem with that whole thing though is that it means that you cannot if you're knowledgeable of the law, you can't claim the defenses that are available, and that it's a catch-22. So I actually don't like that argument. Oh,
sorry.
Is that okay?
I mean, do we want to discourage people from knowing where the legal boundaries are? Because that would be the effect.
Right. Yeah, it's a mess. Jenny Bate, thank you for the donation. We're almost done here, guys. Kevin Zulik says, I had a friend who saw the Mike Brown incident go down, and she said his hands weren't up and he was beating the F out of the cop. Maddie G is me. Thank you for the donation. John O'Mara says, does nurse not know he's not in the hospital? Mask? Not applicable. Both sides are unhealthy. Corruption equals people's job. Isaac Bowles says, will Mr. Gosney make regular appearances on here? Well, he'll be welcome whenever, but he's got a real people job with real people hours. And actually, I would say public defenders have real people plus more real people hours. So
yes, thank you very much, by the way, for letting me play in the playground of the real world or in the internet world and away from my regular drudge job.
Well, I will say,
brother, both. Yeah.
If you, I'll give you my number, and if you ever do have some time and you want to pop into a show, just let me know that you have some time, and we'll make it happen, man. I've loved having you on here. It's great.
Thank you.
2012 Jameson says Arms Girl could do it. She can reach across states. That's true. Mega Mobas says Deborah Davis is the prosecutor that was involved in the Judge Middleton debacle here in Michigan with that guy violating a PPO while on Zoom court. Oh, that was her. Yeah. Okay. Now I know who you're talking about. Sword and Scale. Serious tech question. What camera does Uncivil Law use, and how does he do the focus foreground, unfocused background?
The camera is a Sony Alpha 5100, and the way you get the background blurred is either through the focal length of the lens, or in my case, by reducing the aperture. So you change the depth of field.
What's the camera, Kurt?
It's a Sony Alpha 5100. It's a relatively old camera at this point, but it does very well.
That's like a real size camera, though, right?
Yeah, it's a real camera. It's got like a 20 megapixel lens.
Right.
Yeah.
There you go. I increased my bokeh effect. People complain when I do mine. They're like, "Oh yeah, Kurt's bokeh effect's great," and then I do mine. They're like, "This looks stupid, you idiot." I'm like, oh, God, rude. Torgo the White says, Kurt, have you been following the IP stuff over the rare breed forced reset trigger? Did they have a real case to sue other forced reset trigger manufacturers?
I haven't seen the IP case. I was watching the ATF stuff a little bit because it's very interesting. But on the IP stuff, it depends, of course, on the particular details. The problem, of course, from an intellectual property standpoint, is, to my mind, what they've produced is a useful article, which falls into my domain of patents, which means you can't sue unless you have a registration for a patent, which, to the best of my knowledge, they don't have for that particular device. So no, they can't sue would be the answer to my question, the answer to that question, unless I'm missing something.
So Rare Breed doesn't have a patent on the forced reset trigger?
We're talking about the one that was carved in like the with the lasers, or in the in the business card looking thing.
No. That was a different thing. That's the thing where you can make an automatic weapon, right?
Yeah.
This is different. Forced reset triggers. I think they're the ones, Andrew, if I'm correct me if I'm wrong, if you know, but I think they're the ones that fire on the pull and on the release.
I don't actually know.
You're
All
thinking
my guns have normal triggers on them.
Right. So
yeah, Kurt, you're talking about the auto sear.
Yeah. So I think the answer is the same either way, right? You're talking about some sort of functional article. So because you're talking about a trigger, some sort of mechanism, it's mechanical by its very nature. You're talking about a mechanism that does something. It's a useful article. So that's patent law. So you need to have a patent to be able to sue over that, or otherwise you can't prevent someone else from making the same useful article.
I mean, that's why
if
we
they
have a patent
then yes,
system.
they can sue. If they don't, then no, they can't.
Right.
I got it wrong. What I talked about was a binary trigger. The forced reset trigger, I guess it forces your finger forward while you're pulling back. So it's like a built-in bump stock is how it's described. So
okay, yeah, same answer.
But yeah, same answer.
Yeah, same answer. It's a functional, useful thing. So if you don't have a patent, you can't sue. If you do have a patent, you can sue. Great. End of analysis.
Spencer Walsh says, could a lawyer actually be picked for a juror? Just wondering. Yes,
Sure.
they can.
Yep. I've been called.
I've been called. I've wanted to get on a jury so bad. I can't see. I almost made it once, and then the prosecutor, I was like, I don't know anybody. And then the prosecutor's like, you remember when we went out to dinner? And I'm like, oh yeah.
Not really. It wasn't that memorable.
Yeah, I didn't. I can't remember anything. So
20. I don't remember any hand stuff, so no, I don't. 2012. Jameson says,
what is this balls, no balls thing again?
Do you want to enter
coming.
the territory? Do you want
coming.
the question?
You don't, man. I'm trying to keep you pure. You're so wonderful.
People love this peanut butter and jelly. There's a lot of lore here in this group. I tell you,
there is some lore.
Pooh Zerker says Mr. Gosney is awesome. Nick, please always leave a link open for Steve to join. Mr. Gosney, the balls or no balls question concerns animated fun times by a female with a member.
That's not a female then.
But it is in this.
It is also
in this universe.
Okay,
animated.
This is the.
So
Dungeons
the question
and
is,
Dragons
in the case of the female with said member, balls or no balls?
Well, that's a weird question.
Yes, it is. Welcome to the chat.
I'm a married guy, so what can I say? I've been married 22 years, and I don't have to ever confront that question in real life.
No, amazingly
Yet.
not. No.
2012 Jameson says, will you cover the Malik McDowell trial? Look it up. I'll have to look it up. Never heard of it. L. Jones says, I worked in ER and have daily multiple exposures to positive patients. I would not want to be exposed to me in a group without a mask. So there you go. That's defense of the mask nurse. Not applicable. Says he's a sandwich idiot. He thinks it matters. It does. Zaboomafu says, reminder that Nick doesn't rat the ends of sandwiches.
What's that?
What is ratting the ends of
That's a
sandwiches?
sandwich topic. This is something crazy.
200 Watt Studio says they should have played house music to make the not gay witness feel more comfortable. Hayden Ramos says Lincoln didn't put his phone away in the theater. Oh no. Karen took the kids, says PB&J. I prefer P and BJ. Am I right, guys? Kendall Seeger says pub subs are where it's at. Crispy chicken tender. Thanks again, Nick and Andrew, for the amazing content. Nice to see Kurt's face again. And welcome, Steve, fellow Central Floridian here.
Hey.
Sword and Scale says, please change the name of your stream to It's Peanut Butter Jelly Crime. It's cute and appeals to basic bitches. Bowtie Charlie says, with your crazy taste buds, time to try lutefisk. No, never. Here, we're going to cook this fish. How? Put it in poison? Well, we'll wash it off afterwards. It'll be fine. Bowtie Charlie. Oh, wait. No, Justin Wright says Minnesota has the Spam Museum. There you go. Corpus Delecti says peanut butter and syrup on French toast is glorious. As for sandwiches, far superior to Subway, Wawa, Sheetz, and Jimmy John's.
Yeah.
Yeah, I agree for the most part. I also like Good Sense is great. Quantum Bits, can they appeal the JOA while the trial is ongoing?
No.
No? Okay. Because they can appeal a lot of stuff while the trial's ongoing in Florida, but not that.
Yeah, not really once the trial's going. That's called an interlocutory appeal, which is but usually that's a very specific thing. For example, and I don't think it was done in this case, but if, for example, the stand your ground hearing was denied, which in this case it was, in order for that to be appealable after the trial, you have to do an interlocutory appeal after the denial of the stand your ground. So, for example, and I don't think there was in this case, right? fact, they should have done that to delay it another year.
I think didn't they appeal the denial, Andrew?
Well, it's complicated because they had the stand your ground hearing under the previous burden of proof, which was defense
Oh,
by
that's
a
right.
preponderance, and he was denied immunity on that burden, based on that burden. Then the legislature changed the burden, put it on the state to disprove self-defense by clear and convincing evidence, and they asked for a new self-defense immunity hearing under that new standard, and the trial judge denied them. And then they appealed that decision.
Yeah.
And they got denied again, which is why they're now back at trial.
Okay, which would be an appellate issue. In order to preserve that a denial of a stand your ground, for example, you'd have to do an interlocutory appeal. But generally, rulings like that are not appealed until after the trial, because a lot of that is practicality logic.
Yeah.
That if the guy gets a not guilty, then who cares?
I do know in the Zimmerman trial, they had a number of interlocutories to the appellate courts during the trial. I think they were mostly evidentiary issues. The judge was, to my eye, very biased against the defense in that trial.
Oh, I remember that. Yeah.
Virtually all of her rulings were in favor of the state. And every time the defense did an interlocutory, they were successful.
Well, and I'll tell you a secret, because that's in the Fifth, and that's my jurisdiction. You know, the Zimmerman case was in my jurisdiction. And the Fifth DCA, one of the articles on the SSRN webpage is actually on the success rate of people on appeal. And actually, it was an analysis of the Fifth DCA statistically. And when I ask people, I say, well, how many, what do you think your chances on appeal are? Because what we get as a trial division questions, we get, well, I'll just appeal this, right?
Yeah, right.
Yeah.
The chances on appeal for a criminal defendant in the Fifth DCA is at best 0.6%. That's six out of 1,000. And that does not mean that you're not guilty. That means you get some remedy. For example, you might have a remedy of a new trial, which would be a great remedy, or maybe something like you got a 20-year sentence and instead you get 15-year sentence. That does not mean there was, out of 1,700 cases in the year I analyzed, there was one case where a person went from guilty to not guilty. So the chances on appeal are ridiculously low. But if you ask a person on the street, they think it's like, oh, it's 30%.
Yeah,
Cases
I like
are
to
getting
tell
reversed
people
all the
that
time.
appeals are for losers.
Yes, that is absolutely true.
Now, Steve, this might be an opportunity for you to correct some knowledge for me. I was under the impression that the global number, or let's say the US number, was something around 2% or close to that. Do you happen to know if that's true or if I have some bad information?
I only looked, I'm very specific and practical.
Okay.
And it was, you can check out the research at the SSRN website, download
Yeah.
that paper, but it was actually focused on 1 year in the Fifth DCA, which is my jurisdiction, because it gets kind of, I'd say the hardest thing about my job is dealing with a court that doesn't listen to arguments that should be granted. We get PCA-itis. They affirm without opinion all the time.
Oh, yeah.
And it's cases.
Well, welcome to my world. Actually, I have that problem in patent law. The Court of Appeals for the Federal Circuit, which hears all patent cases, because it's a subject matter court. So unlike going to the regional circuits, like pretty much all of the normal federal cases,
right?
All my cases go to the Court of Appeals for the Federal Circuit, and they affirm without opinion all the time. It's becoming a thing.
Well,
don't they have the highest? Doesn't the patent court appeals court also have the highest overturn rate?
The Supreme Court has enjoyed whacking the Court of Appeals for the Federal Circuit around over the last couple of years. A little bit of background: they created in 1981, and for a good 20-25 years there, the Supreme Court never heard any cases. So the Court of Appeals for the Federal Circuit thought they were the Supreme Court, and over the last 5 to 10 years, the Supreme Court has enjoyed reminding them that no, enjoyed whacking them around. So that's been fun to watch.
That is fun. Well, the problem in the Fifth or in our Florida, I'd say, and I don't know how broadly this problem is that there's no real check on the power of the appellate courts. If they do a PCA, it's final. The only appeal I have from a Fifth DCA PCA is a direct appeal to the U.S. Supreme Court, which is such a long shot, it's might as well be not there. So really, there's no check on the power of the Fifth. So I assume that they just have a rubber stamp over there, and they rubber stamp everything, and that if I get any kind of reasonable opinion, I'm happy, because there's no reason for them to write on anything.
Why do you think that is? I suppose is the reasonable question. Like, why? I mean, why wouldn't they listen to a truly reasonable argument? You come with a reasonable argument. Why wouldn't they come with a reasoned opinion on their reasonable argument?
Unchecked power is basically it. They have there's no reason for them.
Or if I didn't have to write an
they're
opinion,
lazy.
I wouldn't either.
They're collectively just lazy and can't be bothered. I mean, that's always a possibility.
Well, and I will just say, and this is not based on statistics, but one of the reasons I brought this up is because you said the Zimmerman trial was reversed a bunch of times. I've noticed that when there's a media case, they seem to write a lot more.
Oh, I see. Yeah. Okay.
I imagine.
No, they don't have such petty concerns.
Maybe they're just auditioning
higher
for
courts.
the
What are you talking about?
for the secret court to review the FISA warrants, so they can be the FISA court where they don't have to write anything. It's great.
That's
just say
that's
yes,
the
yes, yes.
job. That is the job, man. Could you imagine being a FISA judge?
Yeah, just say yes, yes, yes all the time. It's great.
Well, you can go to Colorado and let's go fishing with Andrew and just have your secretary with a stamp and just stamp everything for you. You don't need to be there.
Okay, Andrew Clark says thoughts on Biscoff cookie butter. No idea what that is.
Oh yeah, Biscoff. Yeah, yeah.
Good stuff.
It's like peanut butter, but it's made of cookies.
Sounds delicious. Britt Cormeyer says
best fan-made commercial ever.
Okay. Britt Cormeyer says, with the price of popcorn in a movie theater, does this not rise to the definition of grand theft? Yes, it's a grand larceny. Dorothea says, with the price of cinema popcorn, it might be grand larceny. Okay, so both of them had the same joke at the same time. That's amazing. Kingslayer Damocles says, I think I heard something during the Reeves video about Reeves putting his arm out touching Olsen when he was leaning over. Might have misheard, but that would change things about first aggressor. I don't think that changes who the first aggressor was, because he was doing that in response to Olsen, who would have needed to be into his space for his arm to touch anyone. Remember, Reeves is sitting down, so his arm out is this far at most.
I don't believe Reeves touched Olsen at all. But tapping someone on the shoulder to make a comment is not a battery.
No.
Right.
No.
Actually,
that is not the thing that society's prepared to recognize. A deal.
Actually, I hate to bring this up to you. I've got another paper in the works. I've got it half written. I'm working on an issue on this, which in Florida, prosecutors love to talk about. I can just tap you on the side, just brush you, and that's a battery.
No.
Well, in Florida, there is case law to support that opinion.
Really?
Yes.
Florida's dumb.
It is dumb. It is dumb. And I'm trying to write this article and approach about how to object to that from a practical standpoint at jury selection, because the prosecutors love to say, you're going to obey the law and a slight touch. So I think there's the way well, this is complicated, but you're hitting one of my sweet spots, my erogenous zones.
Oh,
and
my
that is
goodness.
that, yes.
Chad is corrupting him quicker than I expected.
But I
He's
think
infected.
there's a limitation. I think there should be a limitation on reasonableness and totality of circumstances, that an unreasonable touching in the context of a totality of the circumstances is not criminalized. But in Florida, it's very broad for battery. Simple battery is defined extreme to the point that, yes, a simple objectionable touch is.
So every time a guy at a club just merely taps a girl on the shoulder, that's a battery. Batteries are being committed every single day, every single moment in Florida.
Yes, if she is unconsensual or non-consensual.
Well, how would you know in advance?
Yeah. Well, I always use the mosh pit example. When I'm in the mosh pit at the end,
that's kind of consensual.
Well, yeah, but when I'm pushing the guy out of the way to get to the front of the stage.
I mean, anybody who walks in and out of the aisle of a crowded movie theater is bumping up against people. That's not. Those aren't.
But prosecutors would never bring such a case like that, would they?
You just trust them.
How many cases like that have you brought, Steve? How much of a part of the problem of the system are you, Steve?
No.
How much blood do you have on your hands, Steve?
All of it.
No, I reject this.
Lieutenant Hughes
no
says,
longer a prosecutor anymore because you actually had ethics.
Yeah, actually, the answer to that question is yes. I was actually fired by the prosecutor.
You either die a hero or live long enough to see yourself made the villain.
Right, for not obeying certain things. So I'm actually a happy public defender.
There you go.
Lieutenant Hughes says, keep up the great work. Nose. Poozerker says, to Steve, one of us. Seriously, I think you've earned a welcome spot anytime from a single fan. Oh, no, definitely.
Thank you.
And then I think we have 3 more. 4 more. 2012 Jameson says Nick put vodka in his PB&J. Xenothium says, Mr. Branca, do you have a recommendation for a first-time gun for someone new to firearms?
Well, I don't know what you're interested in. If you mean for personal protection, knowing nothing else, it's pretty hard to go wrong with a Glock.
I'd recommend a revolver, because unless you're a regular shooter, people are not. You can sit that thing for 10 years. You pick it up, you pull the trigger, it's going to roll, it's going to fire. A semi-automatic, you have to practice with it. If you're going to practice with it, semi-auto is superior. But if you're not going to practice, a revolver is more reliable.
Plus, it doesn't eject your brass, so it makes it harder for you to be found.
Right.
You
You can
can
toss
mount
it.
They're really good at killing,
Remember to tape the grip.
cinematographers.
What?
You press your thumb against the back of the slide, fire a Glock. It won't eject the brass either. But don't give the slide a running start.
Oof. Skeleton says, Nick, does salad with dressing count as soup? Fluids, dressing plus solids leaves in a bowl. I don't know. I think of dressings more of a plasma than a fluid. Also, thoughts on Elvis's favorite sandwich: grilled peanut butter, banana, and bacon sandwich. I've had worse. It's not for me. It's not for me. I'm a simple man. Ash says, Nick, zinc has been known to help restore taste and smell after an illness. Give it a try. Love y'all. And Steve is awesome. P.S. I, too, have a big-ass nose. David E. says, binary trigger fires on both pull and release. Technically legal with current ATF rules. That is not legal advice. And I think there's... Sword and Scale says, speaking of Florida, would you cover the Marilyn Manson #MeToo rape trial if he ever gets charged? Oh, yeah. 100%. Avine says, when I was in jury selection in Houston, the judge emphasized that they could not tell us what beyond a reasonable doubt means.
No, a trial judge who attempts to define reasonable doubt beyond the boundaries of whatever the jury instructions are, that's a great way to get reversed.
Right.
Yep. And that's the the super chats, guys. So we can actually wrap up the show and be done. Is there anything anyone wants to say before we do that?
Yeah, I think everyone should get hard. lawselfdefense.com. Get the hardcover copy of the book. Everyone is autographed. I just autographed about 300 of them a couple days ago. They're heading out to the warehouse. So we'll have them in stock. You can get this best-selling book. Read the reviews at Amazon, but I recommend you order it from us at lawofselfdefense.com/gethard.
So that's why his forearm is swollen from the autographs. Mhm.
Hopefully.
Thanks for
Well,
the pity laugh.
I do have to keep them balanced, though, Nick. So.
Yeah, that's true. Ponton21 says, Nick, remember to check in on Joe today. He stayed up until 4 a.m. last night killing a bottle of scotch. Oh, God.
Wow.
I'll text him. Kurt, anything? What do you
At least we
working
know
on,
he
buddy?
wasn't driving.
No, I think today I'm going to post the story about Michael Avenatti, just covering the latest in his woes and troubles, his recent conviction in New York, a mistrial in one of his cases that's ongoing on top of his otherwise conviction, and yet more charges facing. So we'll talk a little bit about Michael Avenatti and his future today, I think, on the channel. That'll be fun.
Very cool. And Steve, like I said, you're welcome back anytime. I've got your SSRN link in the description of the video so people can check out some of your writings. And anything you want to say before we hang up?
No, thank you. It's been a fun, and I will do it again someday. I'll try to. We'll do something. It's just got to be. It's got to be scheduled in the right. This just came in the right moment, and Andrew invited me, so thank you very much. I really enjoyed it, and
sure, thanks.
We'll do it again.
Well, it's been a real pleasure, man. All right, guys. Thanks for hanging out with me today, and we'll be here tomorrow for the stunning weekly conclusion. And
hey, the defense presents its case starting tomorrow.
It should be exciting. All right, guys. Have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lost-plaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes madder, raging at idiots from Twitter and hills of Glenlivet. There's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lethbrook. The spirits blow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Blaming tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed